Hey guys, hope everybody is having a fantastic Monday. It's been about a month since over here on this channel we started looking at the Zachary Adams case, more broadly the Holly Bobo case, the entire investigation, not just as it pertained to Zachary Adams. And we are finally, through our pre-trial coverage deep dive, we are finally in 2017. So remember, trial started September 11th of 2017. We are going to be looking at, we might get through the rest of the pre-trial stuff this stream. This is going to be February 1st, 2017. They're going to hear a couple motions. So we're going to hear a motion to accuse the judge, and we're going to see if we can get another defense attorney, Luke Evans, added to the team. Remember, it's a death penalty case, so it's not just, hey, we want some backup for the sake of it. It's, we want some backup for this case because it's a serious case. So we'll get through those. There's some more media coverage as well. There's two things I want to cover first. First is just lighthearted. Wanted you guys to know that Max Shart is arguing for bond in front of McBurney today. So if you miss Max Shart, you want to go pay him a visit, here's a little clip.
All right. Anything else you want to tell me about his criminal history?
No, I believe that's it. And with that being his criminal history and it being from so long ago and his presumption of innocence and the facts that we know about this case, I do not believe that he is a significant risk to reoffend.
So there you go. If you guys are missing the YSL days, there's a little bit of Max Shart today. Also, shout out Judge McBurney's title is Judge McBurney Final Criminal Calendar of 2025 with 2 exclamation points. And then one other matter of housekeeping, if we call that last matter housekeeping. Trial and Error podcast on their website, innocentbrothers.com, has uploaded the trial transcripts. So great times. This morning, you guys know me by now, I immediately went to the jury charge conference where they debate the jury instructions that are going to go to the jury before they deliberate. There's plenty of other stuff I want to look at. They have the voir dire transcripts. I want to try to look through sidebars, namely for U.S. Marshal John Walker, but there were some other sidebar moments that I want to go back and line them up with what we were watching in court. I don't know when we're going to do this, but we're going to go through. I don't think I'm going to reread the testimony that we were able to watch, but anything that we weren't able to see behind closed doors, whenever we can get together for a live for that, keep tuned. Here's a little preview of that, you guys. Here's a little preview, some clips I threw over. So this is from the jury charge instruction conference. The court is speaking. I have no problem giving that. And then the other one, so this other issue, the next issue we're going to talk about, is a special request number 2 from the defense. I will give that with the exception that it will be read, a promise of leniency or other favorable agreement is a factor you may consider. So General Ragland, prosecutor for the state, says, Your Honor, the state would suggest that further on in the instruction about middle way, witnesses testifying against the defendant on behalf of the state of Tennessee have been granted or offered immunity from prosecution. The court says, rather than granted. General Ragland says, because Jason Autry does not have, Mr. Dinsmore, and this mix-up here is because there's been some grants of immunity here for Dinsmore. The court says, all right, and then Jennifer Nichols, the bad Jennifer, says, he didn't sign it, didn't have it. And then the court says, let's do offered/granted, okay? So this is constraining the language. So the defense must have had some type of request to make the jury instruction include an instruction on a promise of leniency or any other favorable agreement. But the court and the prosecution here are constraining it down to an offer, an actual offer of immunity, which is different than an offer of anything in general. An offer of immunity is very specific, and or it being granted, something being granted. So if you guys remember when we watched the 2017 trial and Jason Autry was on the stand, Jennifer Thompson tried to get him to discuss expectations. And Jason Autry's like, no, there's nothing. I don't have anything in place. I haven't signed anything. She couldn't properly impeach him while he was on the stand, couldn't properly cross-examine him, couldn't get to potential motive, credibility issues because of outstanding promises, hints, offers of leniency that were out there. And then on the back end of the trial here, when the jury's being instructed on these matters, they're not being told that those mentions of possible leniency can be considered. They're being told they can only consider actual offers of immunity, very specific, or offers that were granted, such as a plea deal that's finalized and finished. So, yeah, that one was interesting. Next one, I think Karen Reed community will love this one. So there's a whole bunch of no, I don't know, I don't understand what. And remember, Mr. Simmons is Jim Simmons on the defense side. Ms. Thompson says, that's a different issue though, about what I wanted versus what they were, the order. One of the things I wanted on the verdict form, because the jury instruction says they're supposed to, at each charge, they are to look at it and decide if the person is guilty or not guilty. If they decide the person is not guilty, they go to the next lower charge. The courts, this is Creed McGinley. That's charged in there. Ms. Thompson, so what I want on the verdict form is to reflect guilty, not guilty of each charge. The court, no. Ms. Thompson, and I think the court says, it lends itself to confusion. I'm comfortable with this jury. So judge loves this jury, doesn't think that they need an option to be able to disposition that they found someone not guilty on a charge before proceeding to the next one. I'm assuming it was just at this point in time, you either say guilty and check it off, or you do nothing and move on. So there's that. And then the last one here, this one is an oopsie for Jennifer Thompson. You guys remember the whole saga with her not being able to qualify U.S. Marshal John Walker? Well, here's a bit from the voir dire on that, and I can't wait to read that in full. You have Judge Creed McGinley saying, let me say this. Maybe we can cut to the chase. If the court had allowed him to testify, is that not the same information we're getting from Mr. Reeves at the present time? So we had Jonathan Reeves up there talking about the same data and analysis that Michael Frizzell had used, where you're getting locates sort of from the tower, but different than the 2G pings from the phone, which is the analysis that John Marshall Walker did. Totally different. It's going to overlap, sure, but it's a totally different degree of precision. The type of data and analysis, plus the testing, the methodology that U.S. Marshal John Walker was doing. So the judge here is asking, well, even if I reconsider the other reason I'm leaving him out, I'm not qualifying him because he's not a cell phone device expert. What about the cumulative nature? Wouldn't it be cumulative anyway? And Ms. Thompson just goes, it is similar information, yes, Your Honor. So she truly did not understand the difference and the significance and or how to argue this. So that's a little preview. It was DB that pointed out that the transcripts were available. So that's what we spent, I don't know, like the last 45 minutes diving into. And I can't wait to do a deeper dive there. So eventually you'll see it pop up one of these streams this week or next week before the hearing on the 29th. And without further ado, we are back in 2017. This is February 1st, 2017. It's going to be in 3 parts. So I guess it was an all-day hearing and they just uploaded it in 3 different blocks. So we'll see what we get, you guys. Hope everybody's doing well. Hit that like button and let me know if the volume's good. A lot of chatter. And if you missed our last stream, they're all in the playlist if you want to go back and catch up with anything. And that one was only we were only together for like an hour and a half because the Delphi appeal docs just dropped. So we all ran over to watch Happily Angry Lawyer break those down. This door, and it's like the court has learned to focus on this doorway. Watch everyone walk in. Last stream, we actually caught Judge Creed McGinley standing outside as the defendants were walked in and out. And he's standing there and he's got his robe open. And he's pointing at what appears to be the holster on his hip. So Jerry Gonzalez had talked about that during the post-conviction relief hearings, that it was almost like the judge was there to push some air of intimidation or threat. All right, we can speed this up. I don't know if they're just going to be doing this. All right, never mind. He's about to come out. And a quick pause. So Real Happy 33 is asking, does anyone know who may be called as witnesses for 1229, the post-conviction relief hearing? Now, they said they had 6 witnesses that they planned to call, and Dana had mentioned when we did the collab last week that they have a boat guy. So they have some guy that's no one's ever heard from before. They never reported anything previously. But apparently this boat guy is going to come out and say that he was out on his boat on April 13th of 2011 and heard a gunshot. Or maybe he's going to have to get up there and say he heard the boom, 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 boom. I don't know. But in any case, like, good luck with that, because even if you have somebody in this part of Tennessee after turkey hunting season has started saying they heard a gunshot one day, how do you reconcile the ATM information and the impossible route? You cannot get to this area in Parsons. So state seems to be trying. I don't know. We'll see how they do with that.
All rise!
Well, good morning.
County Circuit Court's now in session. Honorable Judge Creed McGinley presiding.
Did you hear it? Be seated, please. Let's get you at council table since you're going to be engaging in some oral argument. I think he needs to be present with his counsel. there might want to be some discussion as we go through the process. Told the clerk to announce that we might be a few moments late starting. As late as 9:30 this morning, there had been additional filings on behalf of both parties, and perhaps I need to go take a speed reading course so that I can move through it quicker, but in fairness to all parties, I wanted to give due consideration to the matters that have been filed in this case. The initial part of this hearing is reserved for one issue only, and that's the motion for the court's recusal, because the rules are quite clear that until that is resolved, I cannot have any further action in the case. So your argument will be confined to that, probably be a short recess, and then I will make ruling on that. In the event that I am not recused, I will then proceed, unless I stay myself, which is unlikely.
But I'm not giving
the
this
rule
one up.
provides that I can stay the case, or the Court of Criminal Appeals can stay. I think it's imperative to keep this case moving. So in the event that I am not recused, I don't intend to stay any action by this court. I'll go ahead and let you know that on the front end. I don't think that comes as a surprise to anyone. So I'll give you an opportunity to speak over here on the issues that are solely confined to the court's recusal. I will take a brief recess to try to gather my thoughts, and then I will make ruling in the open court with the findings of the court. Okay? Ready to proceed, Ms. Thompson?
Yes, sir.
And I'm going to also, I will apologize in advance. I've probably done it before in discussing matters with her. I've got two Jennifers, and sometimes I'm calling her Jennifer Nichols. I've probably called you Jennifer Thompson. I apologize. I clearly know the difference between the two actors, and it's just sometimes the wrong thing comes out of the mouth, okay? So, Ms. Thompson, the court will be pleased to hear you.
Yes, sir.
I've even drawn myself a chart. I write the name of grand jury for people so that people that I've known for 20 years, I won't suddenly forget their name. So I've got you charted, but I put you in the wrong seat, so I've got Eris. So hopefully that will prohibit misidentification. All right.
Yes, Your Honor.
Ms. Thompson, the court will be glad to hear you.
Well, I'd like to put some proof into the record, Your Honor, so that I could make proof in the record. I'd like to call Erin Honeycutt at this time.
Okay.
She was my assistant, just to put proof in the record as to what was the substance of the telephone conference that morning.
Okay. State have any objection?
No, Your Honor.
I'm going to let you put that proof in the record. In the future, any telephone conferences, she ought to be identified as being present, because I specifically identified who was present on that call and who was not. And maybe it's oversight, but there was nothing whatsoever that would identify her as being present, taking notes, transcribing, anything else. Okay?
Yes, sir.
Come around and be placed under oath where you see. I'll do it. I'll do it. Up here. Raise your right hand, please. Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God. All right, be seated.
Would you state your name for the record, please? And how is it that you're employed? Okay. And so on Tuesday, January 23rd, were you aware that there was a telephone conference set up between the parties in this case?
The date again, I know it's all through that.
24th,
24th.
January 24th.
Okay, which was a Tuesday.
And were you on that telephone call? How was it that you came to be on the call? And what was the purpose that you were on?
I'm going to boost this because the witness is very quiet. So just to warn anyone with their headphones turned up, we're getting a little louder.
On the call? Okay. And are you usually present on telephone calls?
Yes.
Okay. And did you in fact take notes on that day? And how is it that you took notes? What program did you use to take notes into?
We have an operating system that has a calendar, and you can just click on the date and time. And do that way.
Chat, the camera person's giving us a note. I've never seen this before. They have a note that says no mic on stand.
Let me say, acoustics are not very good. Mr. Walker just squeaked his chair. I'm not going to tell you not to squeak, but you need to speak up a little because acoustics are not good in this courtroom.
It's an operating system called PLEA.
Okay. And is that, what kind of system is that?
It calendars events, it holds all of your case matters, communications, calendar events, time notes.
Okay, so when you put these notes in, what kind of little section then did you put these into?
Just a description box at the bottom.
For the event?
For that event.
Can you explain what an event is?
The event is a marker on a calendar.
Okay. And I'd like to pass that to you. These are the...
They were attached to the plea.
Do you recognize what it is that I have passed to you?
I do.
And what is that?
These are my notes from the teleconference on January 24th.
Okay. And you took them while the conference was going on?
Yes.
Have you edited them since that time?
No.
Okay. And so, while you were on the telephone call, and you've taken notes, can you please, for the record, tell us what it is that you recorded there in your notes?
Do you want me to go through kind of the...
Yes.
Okay. So I connected in on the call, and Jennifer was Governor Jim Simmons, she's the Nichols, Eric Christensen, Steve Ragland, Paul Hagerman, and Judge McGinley were there, or came in on the call. There was a remark about Susan, and then it was quickly discovered, somebody said the name Mary Ann, and it was quickly discovered that it looked like two parties were on the same line, and so the other party hung up. And so then the judge stated that he had invited Susan Jones in on the call, but she had a death penalty case in East Tennessee. He then said that the reason for the call was that he had approved after a pretty, he's going to say about 20-30 minutes conference with Jennifer and Jim, a third attorney. Technically, it's not in compliance with the Supreme Court rules, but they had a good argument, and that was the Dillon Luke case. They suggested Luke come onto the case because it would take less time for him to get up to speed because of his involvement with Shayne Austin. And under the immunity agreement, it was in the process of being revoked at the time of Shayne Austin's death. But he did have two questions, and he'll give Jennifer and Jim a chance to make sure that he's right. One, do they understand that April 3rd is the trial date if there's no plea? And then two, what about the conflict of interest? He indicated, Luke assured them that there was no conflict of further communication, and further communicated that with the Board of Professional Responsibility, and it had been confirmed. He issued an order saying that Luke could defend Zach. It was up to the AOC to decide if it was in compliance for purposes of payment for indigent attorney fees. This is Tuesday. The judge was supposed to have a court procedure, but not now. He was doing carpus. As of Friday, the AOC had not approved it, told Debbie Tate, the director of AOC, was rejected. What was to occur was that the unit would be submitted to Bivens for members of the Supreme Court to decide if they go beyond 2 disqualified attorneys. As of Friday, it was not approved. Mr. Evans had submitted his bill. Judge McGinley approved it, but not paid. But it has not been paid because it's not yet been approved. And then he asked Jennifer and Jim, is that accurate to this point? Jennifer said yes, that she did not know about the not approved part. And then the judge said, as far as the background of what he did, is that accurate? Jim Simmons says correct. And the judge asked, did anybody have anything to add? Jennifer said, get the conflict of opinion from the board before submitting. Also, the client signed a waiver of any potential conflict. The judge said, I did not understand that. So then Jennifer said, Zach Adams signed a written waiver of potential conflict. So the judge said, fast forward, I got a call from Jennifer Nichols on Friday. She said she was worried about a conflict. I know they said the board says it's okay. She didn't raise. BPR might result in censure of some type of warning, but we're in a new dimension when we're dealing with the death penalty. I told her to discuss with Jennifer and Jim and see if there was a way to work around that. That was not able to be accomplished. Jennifer Nichols expressed she's concerned about the settlement negotiations with the appearance of conflict. Jennifer Nichols, is this accurate? Jennifer Nichols says, you are. I did speak with Jim Simmons and advised my concerns over the issue after I spoke with you on Friday. I spoke with Jim on Friday and Saturday. Jim Simmons said there was no resolution. We don't think there's a conflict. Zach Adams signed a waiver of conflict. He would be deprived of his right to have Mr. Evans represent him. The judge said, well, not deprived representation. Evans may be pro bono. Jennifer Nichols asked the judge, do you want the prosecution team to set out for your honor and defend what our concerns are? The judge then said, I think the appearance of conflict is so strong, it makes it apparent Evans is no longer going to be able to represent Zach. This might reflect poorly in the confidence of judicial procedure. I'm going to disqualify Evans at this time. Prosecution, Judge then said prosecution make the order in my findings in the appearance of poor confidence in judicial procedure. Then Jennifer said, Your Honor, we had this hearing, not on the record. I request to have it again on the record. The judge said we will have it on 3-1. They hope to wrap the case up by then. Jennifer said she don't want to file an appeal on this. This is an appealable issue. The judge said you can be ready for whatever on 3-1, maybe an interlocutory appeal, and I'll rule on it. My strongest suggestion, if no negotiated plea before then, be ready for trial on 4-3, April 3rd. And Mr. Evans is invited to attend. Jennifer Nichols then said on February 1st, put it all on the record. The judge said yes, and it still remains. If I were representing Zach Adams based on the movements and what the court has noticeably occurred, like I said 3 months ago, if I were defense, I'd be beating down the door at 101 Poplar to see if I can get something reached. Any way to resolve 2-1 it needs to be. And the call.
Wait, so she's reciting the judge speaking right now, right? And because this is a reference again that if I was representing Zach, I'd be running down to, he said Poplar, I think that's where the courthouse is, to see if something can be reached. And we heard him say at Jason Autry's plea hearing in 2020, oh, I would have been the first one running down there. Hold on. So this is before you have commentary, it seems like, from the judge before trial. She's attesting to it. She's sworn under oath on the stand. Maybe it was Jennifer Nichols. Let's run this back.
Invited to attend. Jennifer Nichols then said on February 1st, put it all on the record. The judge said yes, and it still remains.
The judge said.
I were representing Zach Adams based on.
It's the judge saying it. And he's going to be like, nope, I'm not disqualifying myself. That's crazy. Not that any of us are surprised, but you have somebody putting this on the record now, that the judge before trial, the judge has a presumption that this defendant, before the evidence has been presented, that this defendant, and this is a death penalty case, so of course the judge is going to be deciding something serious.
To attend. Jennifer Nichols then said on February 1st, put it all on the record, the judge said yes, it still remains. If I were representing Zach Adams, based on the blueprints and what the court has seen noticeably occurred, like I said 3 months ago, if I were
like I said 3 months ago,
popular, I'd see if I can.
So that means he's saying that he was saying this 3 months ago. It is February 1st. So that would be, I mean, depending on what someone means when they say 3 months ago, he could be meaning November-ish, December-ish, you know, that area of time where we have questions about properly accessing the discovery file. And somehow Jason Autry gets an accessible version. Ooh, and sidebar, Max got his client bond. Love to see it. And Grammy Clover just came over from watching that as well. So shout out to Max Shart. Love to see it. That was a great little moment to see Max Shart. Also want to give a big thank you here to Derek Croissant for the super sticker. Thanks so much. Yeah, woohoo, Max. Love to hear it. This is just... We have 2 mentions now on the record. Judge, and let me timestamp this so I can find this later. We're 31 minutes into this, so like around 29 minutes. Judge talking about how he would have Zach try to reach an agreement 3 months ago. Not good.
Something reached any way to resolve to line it needs to be, and the call ended at 10:15 a.m.
And do those notes reflect your recollection of what was said on the call?
Yeah.
And so that's all I have for her.
Ms. Honeycutt, you've been present on the teleconference between counsel, the judge, and the prosecution. Yes. You take notes of those as well. Yes. So I'm sure that you've heard for at least the last 2 years, the judge encouraged all parties to engage in productive settlement negotiations. Haven't you?
Yes.
You've heard him say that from the bench.
Yes.
Do you take notes during court? Yes. Okay. So then you probably actually heard him say that exact phrase.
What if Jennifer Nichols was like, can you define notes for me? What are notes? Like, where do we do that at? Miss, I don't take notes during proffer sessions. Booth, like, communicating with her telepathically over here, like, yeah, ask about those notes.
Before, either on the bench or on a telephone, where he encouraged people to come to Memphis, to my office, and engage in settlement negotiations.
No, I don't.
This is the only time that you wrote that down.
I think this is the only time I actually heard you say that.
And you would agree then that on this particular teleconference, the one on the 24th, you heard the judge take a roll call, didn't you?
I did.
Okay. And you heard me identify the 4 attorneys from Memphis, right?
Yeah.
You heard Ms. Thompson identify herself?
Yeah.
Mr. Evans identify himself?
Yeah.
Mr. Simmons identify himself?
Yes.
And you chose to remain quiet?
Usually,
I'm sorry, my question, you chose to
I was
remain quiet.
muted. I was muted.
So in answer to my question, you chose not to answer the judge's question about who was present on the teleconference.
Correct.
And have you also done that same process on every other teleconference that the judge has had with the defense counsel and with the state?
I'm usually physically in the same place with Jennifer and the calls on.
I'm sorry, but maybe my question is not clear.
Yeah, I'll never directly address the court, no.
So every single time that we've had one, you have remained quiet and not responded to his honest question.
This time, I don't remember a roll call for it. Yes, that's correct. I'll remain quiet.
If you don't remember a roll call, that's fine. So I'm going to ask you another way. Have you ever identified yourself as present on the teleconference between the judge and defense counsel?
Not that I remember.
1 moment, Your Honor.
Address something else. got my telephone information. You've got my office. You've got my cell phone. You've called on many occasions for scheduling purposes. No discussion of the case, just scheduling purposes. Is that what all of those conversations have been for? Is scheduling purposes? Has there been ever any ex parte communication concerning any of the factual matters concerning this case? All right. Anything else?
I do have a follow-up question. Besides yourself, were there other people from the defense team that were on the call that day that you're aware of?
Yes.
And who was that?
I know Amber Trees, an investigator, was on the call.
Okay. No further questions.
And for the record, I did say 101 Poplar, it's 201. But I remember I misidentified in that call. But I think the intent to urge settlement discussions is what the court was getting at, to encourage.
Yeah, so this is the judge, and I don't know if he's doing this on purpose or not. We heard him say he's trying really hard to get the Jennifer's names correctly and not say the wrong name when he's referring to the other person. And now it's like, I know the courthouse dates too, but he's confirming on the record what was being discussed in this call. He's giving the recitation of what happened on this call as given by Honeycutt, the witness on the stand, credibility. But like, yeah, I was talking about that. I had the address wrong though. So
Encourage settlement discussions.
So Nichols looks dumb
everyone in
doubting
Shelby
it.
County knows about 201 Poplar, and that's just was an easy way to make reference. But I did say 101. So, all right. Anything else with this witness?
No, no.
Step down.
Step down. Are you guys picking that up though? Like he was so intent on correcting the record on his mislabel of an address that even after Jennifer Nichols tried to counter this testimony about the credibility of this call and how she's not trustworthy because she shouldn't even have been in there and she didn't want to say she was on there, so we can't trust you. This guy just gets up there and says, well, yeah, I said that, but let me correct the address I had wrong. Oh, too bad, Jennifer. Not that it's going to do anything, but still. Just arguing sua sponte. At least he corrected the address. Gotta have something correct in this case. Gotta have something correct in this case. Lovely manners, lovely manners.
Your Honor, in this case, we are asking that the court recuse itself. This is a death penalty case which has a heightened standard of due process. The telephone call that the court, in the telephone conference which the court disqualified Mr. Evans, the court made several comments. One of the things that the court said was that it had spoken with Jennifer Nichols and that Jennifer Nichols had raised concerns about the conflict with Luke Evans. The fact that that is more than simply scheduling, Your Honor. She raised concerns that that Luke Evans had a conflict. She also mentioned the fact, she expressed that she was concerned about settlement negotiations and the appearance of a conflict. And Your Honor, those things that were discussed are more than simply scheduling issue. They are ex parte communications that the court had with the state. And that it's not allowed under the rules. And it would give, the court disqualified Mr. Evans based on the fact that it would erode the public's confidence in the judicial system. And because the court in this case had extrajudicial communication with the state when the defense was not present, then that in and of itself, Your Honor, would be a reason to disqualify the court. The second reason would be that the court said, based on the very statement, based on what I have been, based on new developments in the case, and what the court has been led to believe occurred, like I said 3 months ago, if I were the defense, I'd be beating down the door at 101 Poplar to see if I can get something reached to resolve the case. And Your Honor, based on that statement, that the fact that it's not simply encouraging the parties to negotiate in settlement discussions, it is specifically giving an opinion that if the court were the defense attorney, and it also says based on what the court has been led to believe. So therefore, the court has some
Ex parte
information.
communication.
Based on that information, if the court were a defense attorney in this case, the court would certainly think that it's appropriate and necessary for Mr. Adams to be working out a plea deal in this case. And that's clear to the public, and the standard in this case, the standard that the court uses, is not what does the court know or what the court believes, but when you're looking specifically at the standard regarding a court's recusal, then the standard is what would an ordinary person in the public believe after seeing that statement. And it's clear that an ordinary person in the public is going to believe if the judge has said, you better be beating on the door of the prosecutor's office, and it's clear that the court believes that it is necessary, prudent, and probably...
Stop you just a second. As an officer of the court, how many times have I told you that it was not too early for negotiations? I told every single attorney in this room, they were...
You said very early there would be deadlines and there would be a cutoff. That was one of the first hearings that we got to watch.
present. Every time we've been in court, to my knowledge, I have tried to encourage the parties to negotiate towards some type of reasonable settlement so that this case may be put to rest. Will you agree as an officer of the court that I have done that?
Certainly, yes. But when the court phrased it that way, it put a chill onto the defense team.
It's pressure, it's power.
It came across as though the court had made up its mind.
Yes.
The court thinks Mr. Adams is guilty. And the court thinks
over here.
he should be working out a plea deal. And the second issue that I did raise in the motion for recusal is that the court has continually brought up the fact that there's not going to be a continuance of the April. Nobody at this point had asked for a continuance. Recently, I think we filed a motion that was ruled on in November, but nobody had asked for a continuance, and that also comes across that the court has already decided that issue as to whether or not it would grant a continuance, and that there's not going to be any reason for an exception. And again, having prejudged an issue, Your Honor, and expressed an opinion on that issue, then I think that's a second reason that the court should recuse itself. So there's three reasons, and when you look at the law and what the law supports in a case like this, that because the court has had ex parte communication, and even though it may have been slight, it's still the state expressed their concern about the conflict of interest issue, and they did more than just simply say, we need a hearing. They said, we're concerned, and we are, as soon as they add an and we are especially concerned about trying to enter into plea negotiations. That gives their opinion. They have communicated something to the court besides simply saying that they want a date to hear something on the record, or they need a date for a hearing. And because of that, Your Honor, we say that under the law, and the law is clear, that under the law in this case, and there's a heightened due process responsibility when a person is facing the death penalty. And there's case law that says that too, that in a death penalty case, they have a heightened due process responsibility to have a court that is unbiased and that appears unbiased. And so based on those three reasons, Your Honor, we're asking that the court recuse itself.
Denied.
I'll be brief, Your Honor, to address
I'll be brief
Thompson's.
because you're not going to disqualify yourself. So, guys, the short of that is, issues independently, but then also combined. The court is having ex parte communications with the state. Then the court is making commentary, not just once, but at least twice, that he'd be banging down the door at the courthouse to find some type of agreement, to negotiate, to reach some type of settlement, based on what the court has learned. So somehow there's some information being ascertained through these ex parte communications where the judge has now prejudged the situation, viewing the defendant as being guilty, and now repeatedly putting pressure on the defendant to not take it to trial. And I think the court was, maybe he's not really recalling, but the court did encourage agreements, but he was forceful in those. This was all the way back in maybe the end of 2015, the hearing that I'm thinking of. I can't remember the exact timing, but he said something to the effect of, work it out because I put a deadline on that. So hurry up and go take these pleas. That's very different than, I'm always encouraging you guys to have talks, to talk between the parties. That's take it before it's gone. That's like fear of missing out. That's FOMO. That's pressure. And then add to all of this is that we've already seen the judge standing in the hallway with his robe open and his gun on his hip in his holster. And the court should not be putting pressure on somebody to plea. A kind of recent example that I think a lot of you in the chat, if you followed YSL, might be familiar with, are the Pee Wee Roscoe, when the Georgia Supreme Court overturned his conviction through his plea because the judge was saying things to the effect of, well, there's been a lot of trials where somebody charged with criminal street gang activity got very severe and strong sentences. And I'm just going to warn you, I'm not going to go easy on you. In other words, instead of taking it to trial, because I, the judge, am going to go hard on you, you should take the negotiated plea deal that the state is currently offering you. And so Pee Wee Roscoe agrees, he takes the plea, and then the Supreme Court overturns it because they determined that was pressure. That was undue influence from the judiciary on the defendant, on the accused, in violation of, a knowing and voluntary right to decide whether or not they want to take it to trial, and whether their agreement with the state was knowing and voluntary. So, and that wasn't death penalty. So, in different states, but you guys know. So, yeah. Oh, what a mess. And this is February. This is February. They haven't even found the rusty revolver yet.
Concerns. One, about any extrajudicial statements that were made.
Oh, she's whispering.
Your Honor, I've been on the case over 2 years.
Oh, I'm going to be so sad.
From the beginning, you not only encouraged us to call you, there was a scheduling issue.
Encouraged us to call you. Look at the difference in Brent's face now, Brent Booth.
You actually explained that you're out of your office quite frequently, being a circuit judge, and that everyone has your cell number. You gave it to us in chambers, all of the attorneys. When I realized that I needed a telecon or something perhaps set on this date, I did pick up the telephone. I called you. I asked if I could schedule a teleconference. And I don't know in what world Ms. Thompson practices in, but I've never set a hearing with the judge without telling him or her what the hearing was to be about. And I said, I have a concern about Mr. Evans' representation of Zach Adams. That's as far as it got. And you correctly...
Would you agree that the total time of that telephone conference was less than 5 minutes?
I disagree. I think it was less than 2 minutes.
Okay. And part of that was dead time because I told you I was in a restaurant.
Yes, you went out to the car.
And total sum and substance, less than 2 minutes.
Yes, sir. Not only have I never, ever discussed the substance of the case against Zach Adams with Your Honor, I've never made statements about the case against Dylan Adams, nor Jason Autry, to Your Honor. Ms. Thompson made statements that you must have some information about what other defendants would say or wouldn't say. I can't speak to that because I haven't, and no one on the prosecution team has had those discussions with you. There were no extrajudicial statements made by me to you. There was zero discussion about the substance of anything other than we had received a notice of appearance representation from Luke Evans. I contacted the defense, all of them, including Luke Evans, explained my concerns. We've attached the email string to a filing this morning between myself and the defense, Luke Evans' response, and then Paul Hagerman's response there too. When that didn't work out, I called for a teleconference, which is what Your Honor has instructed all counsel to do, and based on the statements you've made from the bench this morning, others have apparently taken advantage of that much more so than the state.
Do you guys think that she's being intentionally superfluous with her wording when she says extrajudicial instead of specifically ex parte? Because there can be issues with extrajudicial statements, but not all extrajudicial statements are problematic. But all ex parte communications, there's disclosure rules. You're supposed to at least put the other parties on notice. And typically the judge is supposed to kindly remind the party, like, hey, unless there's a heightened need, like maybe you're applying for some type of restraining order and don't want to put the other party on notice because you're worried that physical harm might meet the requesting party. That's a reasonable exception for an ex parte communication. Like, why are we just not saying ex parte communications? Because that's what it is. And if we acknowledge that they're ex parte, then we would also need to necessarily acknowledge that you were supposed to make certain disclosures. The other parties were supposed to be made aware, at least in due time, if there was a reason warranting a gap in disclosure. Yeah, I'm sitting here listening, like, is she gonna just keep saying extrajudicial, or, yeah, what does it matter? The length of the call, the amount of time it took you to say the inappropriate things you said is important. Who cares how long the meeting was? Yeah, I agree. Devious, I think, is a good word here too, Shay. She's being devious. And the whisper voice. So you mentioned the way she's looking at the judge, but also like this whisper voice that she puts on. Do I have this locked and loaded, ready to go? Where is my... There we go. My favorite picture of Jennifer Nichols. By the way, Trial and Error did a short. They uploaded a short. It's like a montage of Jennifer Nichols and Amy Wyrick. It's a good little flashy one. I like it. So check that out.
I needed to voice the very real concern that we had about a conflict. I won't get into that now because I know we're talking about recusal. I think the second issue that
Negotiations.
was negotiations. I've been on the case a little more than 2 years. From day one. Every single interaction I have had with you, with defense counsel present, with you on the bench, with you in chambers, or a teleconference, with every defense lawyer, you have made the same type of statement. And the interesting part, though she is choosing to gear it towards some predetermination of guilt on your part, frankly, I took it as an admonishment to the state that we must engage in settlement negotiations if that was possible, because you wanted to keep things moving. You have never aimed those comments at one party in particular. You advised all of us to talk. And in terms...
Well, there's a problem with that, because if she were to, in good faith, exercise in some type of settlement negotiation, full availability of disclosure, your discovery needs to be available to you. And I hope Jennifer Thompson gets a chance to rebut this a little bit. I don't know if she will, or she'll go into it more specifically, not if she'll have a chance to keep making her record. But before you enter a plea, The state's supposed to show you the evidence that they have that they could use against you if you take this to trial, that they could be showing to a jury and presenting to a jury, or a judge if it's a bench trial. But if your discovery folder has things that are inaccessible, and defense counsel is telling the state, hey, we can't access certain things, I would imagine that even if the state had said, hey, do you want to talk plea? I can imagine Jennifer Thompson saying, well, maybe, but I'd like to be able to access all of the material first, and I still can't get into this folder. And we have the acknowledgement on November 16th or 18th, like a couple months before this proceeding, where Joe Walker is told by Jennifer Nichols to release 2 discs of discovery to Jason Autry's attorney, Matt Scholl, with the reason being written in this letter authorizing the release by Jennifer Nichols. Other defense counsel have said they cannot access certain files. So I find it really hard to believe that the state made an authentic, a genuine attempt at any type of negotiations with Zachary Adams. That was never going to be the person they needed to rely on. They were ready to rely on Dylan Adams until they changed their mind and shifted their focus to Jason Autry. And again, this is taking place on February 1st of 2017. If I'm not mistaken, I'm pretty sure that ride where they take Jason Autry out of custody and they have him in the one vehicle Kathy Ferguson says she was following in a vehicle behind them, recreating the route of travel on the day of the abduction, happened like mid-February, maybe early March. So sometime right after this hearing, they lock in and solidify with their Jason Autry proffers. It's all really suspicious to me. I don't believe anything that comes out of her mouth. Or the judges. So,
Of coming to 201 Poplar, that's customary. We just all happen to be spread out. And that comment that was made about 201 Poplar, and frankly, it's been made more than once, I think means nothing other than get together and talk.
At one time, I think I said, it's not too early to negotiate. Did I not?
Those are your exact words, but I believe you said them more than once.
Okay.
And this, I think Ms. Thompson made reference to 3 months ago, you're saying something. Your Honor, this has been going on for over 2 years that I've been on the case. And I can't speak to what you said before that, but I know what has taken place since November, December of 2014. And I don't have anything further.
Her third issue, continuance. You want to address anything on that? The statement of the court to stand firm in a trial date.
Well, I'm sorry I didn't address it because I frankly thought that's what your job was. You set this trial date months and months and months ago. And you, just like you've always encouraged us to engage in discussion, if appropriate,
so funny.
you've also said we're going to trial. And we all have...
Do you recall these exact words? And unfortunately, I was pointing my finger when I said it, that the court will try someone on April 3rd. At that time, there was no election.
Oh, and I remember this. We watched this last week. On Friday, I think. He specifically said Jason Autry would go last. So he said he's going to try somebody on April 3rd. Then clarified that Jason Autry would be the last one tried. And to be fair, there was a manifest reason for that. Like, Jason Autry just had a change in attorneys. But I think the latent timeline of all of that was to make sure that they could extend Jason Autry's stay without having to offer him an official plea deal before trial that would be available to the defense to use, and make sure that Zach Adams was tried first. So, tangled web that they were weaving here. But he's just going to represent it as, oh, somebody was going to go to trial, not like there was any roadmap painted out that Jason Autry was going to go last.
Election, but I think those were my exact words, that the court fully intended to try someone on April 3rd.
You were so adamant about that the state felt that we needed to advise one of the defendants in particular and advised the court
Particular.
that defendant was not going to be the first one that we tried. And that left 2. We felt...
Counting it
I
all.
think I stated that in open court
you did.
because the attorneys,
were pointing at me.
Mr. Scholl and Mr. Parrish, came on board later than the other attorneys.
Mm-hmm.
And I think I
Perhaps by
said that
design.
that theirs would be not
in
before the
July.
second day.
Yeah. Right. Now, that was said from the bench, but it's also been said...
And remember, the judge was previously saying he didn't make a decision on trying the co-defendants together or not. It was something he floated very early on in one of the hearings. And then later on, the state makes a motion to sever the defendants' trials. That way they could be tried separately. But the judge was opining on that type of decision before that motion was filed by the state. It's almost as if now we're hearing about ex parte communications and comfortable chats, extrajudicial, whatever we want to call it. The state wanted to make up their mind on what order. And then they finally filed that motion to sever. And ever since then, it's been the perfect timeline to make sure Zach Adams would be first at bat. And maybe if we can pull off using Dylan Adams, we'll use him. But we have Jason Autry on the back burner. And this is the exact season they start locking in. Jason Autry's had his discovery folder. He's about to line up those details. And they're about to start doing the, hey, my client wants to talk. Let's go for a ride. This is crazy. And the way they're chatting about it as if it's just like nothing wrong with this is crazy.
On every telecon.
I want to
in
thumbs
chambers.
down this video,
Until
but it's not
today,
their
we have
fault.
all met as a group, every single court appearance that I've come in the last 2 years in chambers. And you've made the same statements.
Anything else?
We got her face.
Yes, Your Honor. Along with my motion, I filed 2 other items as attachments, exhibits. Exhibit A was the ethics inquiry email between Mr. Evans.
I've seen it. It's attached to your pleadings.
And I'd like to make that an exhibit to today's.
I don't know that we need an exhibit. It's part of the record because it's attached to your pleading.
Well, I'm thinking in terms of an appeal, Your Honor. I think in terms of the appeal, I'd like that and the waiver to be made exhibits to this hearing today.
It's already in the record. If there's an appeal, the pleadings will go up with the attachments.
That's true. In order to have separate exhibits, it would be duplicitous and more or less carrying the coals to Newcastle, wherever that expression started.
And the other thing that's happened is, Ms. Nichols has been basically testifying about things that occurred in the telephone call, but she's not done that formally. And she's been arguing facts that aren't in the record. And I would like to point that out, and I object to those coming in because they've not been made an official part of the record, and she has not testified to them.
She's an officer of the court, as are you. Okay?
Oh, boy.
All right. Short recess. I'll make findings on the motion to recuse.
Look at her.
All rise.
All right, let's watch the walkout. Maybe there's something interesting. This is crazy.
Court be in recess.
So McGinley and Booth are out already. Jennifer's head is blocking everything. Oh, I guess we're not walking him out in front of the judge this time. All right, so I think we have, is that Kathy Ferguson just with different hair, a different hair color? And then there's Joe Walker. walks back in this doorway entrance. Wait, does he come in from the side now? Or is that the other door? That might be the other door. I think they turned the camera. This little preview down here. Yeah, Ariane says that was a long and intense quarrel between Judge and Nichols over whose turn it was to kiss whose butt. Crazy.
Court back in session.
All right, yeah, so they turned the camera to the other door. They said of all the days, don't walk him past the judge with his gun on the day that they're asking to disqualify the judge for putting pressure on the defendant.
Sorry.
Right. Well, once the judge starts speaking, I'm going to turn the volume back up.
No, it's all right. We'll give it a few moments. Be seated, please. All right. I want to say first and foremost to put a case on someone else unless there is a true conflict, which there is not. The defendant, through counsel, Ms. Thompson, filed a motion pursuant to Rule 10B of the Tennessee Supreme Court 101 for the court to be recused in this case. And in her memorandum set forth grounds. I want to dispel some of those. First of all, I think it's very clear at this point that the telephonic conversation on that Friday prior to the conference call was of short duration with absolutely no discussion concerning the merits of this case.
Now it was a short discussion?
As I've done on other occasions, I encouraged counsel to see if they could work the matter out. Said if you can't, you call my office, we'll do a conference call. It was my intention that that would be done quickly because we've got a trial date approaching, and I wanted to resolve the issue as soon as possible. At this particular time, I'm not going to get into the disqualification of Mr. Evans. I will take that up in a few moments on the defendant's motion. But there was no ex parte conversation. That didn't occur. Any conversation was towards scheduling, which is expressly allowed under the Tennessee Supreme Court rules, judicial conduct.
Paul, BS on that one.
As far as the matter on negotiations, as has been pointed out from day one, I've negotiated the parties, or I've tried to encourage negotiation between the parties. That was confirmed by the attorneys that at one time I actually said it's not too early for the parties to start negotiations. I think any good trial judge is not being responsible if they don't ask the parties in good faith to negotiate. The system without negotiated plea agreements would absolutely break down. So that's part of the process. And yes, you're right, I have encouraged it.
Well,
I've encouraged it a multitude of times. I've attempted to encourage it firmly, but not coercively. I want to make another thing clear concerning me speaking of negotiations. I did get a call from one of the attorneys. They advised that they would not be needing a trial date. There were no discussions of the merits whatsoever. Is that correct, Mr. Scholl?
That was from me, Your Honor.
Yes.
I gave you 2 phone calls, one of
Oh, let's run that back. So this whole morning, because this is a continuation, we're still on February 1st. They just took a recess for him to decide how he was going to recite his ruling that he probably already predetermined. What? What? So in his back pocket, he already knows. Holy shit. He already knows that he's gotten a call from Matt Scholl, Jason Autry's attorney, that they don't think they're going to need a trial date. After all of that whispering from Jennifer Nichols, you said, Your Honor, somebody's going to go to trial on April 3rd. And we knew that Jason Autry would go last. But we knew someone was going to go to trial April 3rd. The court knew this whole time? Throw this entire hearing away. This is the most important piece of information for any of the arguments made earlier.
But not coercively. I want to make another thing clear concerning
Yeah, make it clear.
me speaking of negotiations. I did get a call from one of the attorneys. They advised that they would not be needing a trial date. There were no discussions of the merits whatsoever. Is that correct, Mr. Scholl?
that was from me, Your Honor.
Yes.
I gave you 2 phone calls, one of which was to ask about what the procedure would to a plea agreement in Your Honor's court for approval. And then I told you I would notify Your Honor if we had felt that we were not going to be a trial.
I have never discussed whatsoever your client's case, have I?
We have not, Judge. I also told you on my second phone call.
That I would not be needing, that you would not be needing a trial date.
Second phone call, I told Your Honor we would not be in trial.
So that was probably what triggered what I said, that given recent developments in the case, that I would further ask the parties to negotiate.
Judge, and I did that with the state's knowledge.
And then
Of course. Of course. Thank you for saying it out loud, Matt Scholl. So the people that are not in this chat, if they ever watch this later down the line, can understand that the reason we're screaming at the screen is reasonable. Thank you for putting it on the record that you called the judge with the state's knowledge to tell them sometime before February 1st that you would not be needing a trial date for your client. And not for nothing, when was that last hearing? Wasn't it January? Okay, so the hearing that we watched on Friday was January 15th, 2016. So, or no, that's November. I can't read anymore. Okay. All right, but that's giving us the time frame. And then trial date was set. What date was this one? I think this is just a recap of the November. Yep, so then we have a gap in time between this November hearing date and then all the way to February. I couldn't really find any historical footage of that gap in time. We just know that during that time, Jason Autry has his discovery folder. What is going on? What is going on? What is going on? This is gross. This is gross. Hey, Keith, let's get positive. Let's say good morning to Keith. Let's see how else this can go awry.
as I said, I don't see the negotiations that the court asked the parties to engage in negotiations as showing any bias whatsoever of the court, and I don't have any other attorneys in here in other cases, but I've got police agents that will tell you it's not unusual in this particular case, that it's frequently done, that I've asked the parties to engage in negotiations. It's no comment on the presumption of innocence that the defendant has. It's simply that the parties need to have some reasonable dialogue concerning their case.
So now I feel like, was it like divine intervention that the Trial and Error podcast uploaded the transcripts? DB says, hey, they uploaded the transcripts. And I go, this was one of the first parts I got to. We looked at it at the beginning of the stream, but think about this now. This is during the jury charge conference. They're debating jury instructions for this 2017 trial before the jury starts deliberating the fate of Zachary Adams. The court says, I have no problem giving that. And then the other one is special request number 2. I will give that with the exception that it will read a promise of leniency or other favorable agreement is a factor you may consider. So this defense wanted to include language in the instructions, allowing the jury to consider. And the judge is like, hey, I'll let them consider any offers that were granted, but I'm going to make an exception. I'm not going to grant this part of your motion to also include that the jury could consider promises of leniency or other favorable agreements. The state goes on to say, Your Honor, the state would suggest that further on the instruction about midway, witnesses testifying against the defendant on behalf of the state of Tennessee have been granted or offered immunity from prosecution. So again, we're keeping it to that narrow scope of things that are more explicitly delineated as an offer conferred, a benefit conferred. The court says rather than granted. Ragland says, well, because Jason Autry does not have. Well, Mr. Dinsmore, court, all right, let's. And then Jennifer Nichols says he didn't sign it. He didn't have it. So all along, this is putting it full circle. That they knew they were going to have some type of deal with Jason Autry. And it was promised on a handshake with Matt Scholl, a new attorney that came in that seems to have a good working relationship with the prosecution team. And they weren't going to finalize and formalize anything until after the completion of the trial proceedings for Zachary Adams. Because if the paper was signed, if the ink was dry on the paper, it's something that Jennifer Nichols could use as a document, as a record on cross-examination with Jason Autry. It's gross. And then you have dumb Jennifer Nichols pretending she doesn't know what the rules of professional conduct are during the post-conviction hearings. Whenever Doug Bates would ask her, well, you're familiar with this basic rule that you should know, right? And she's like, well, I don't have the book in front of me right now, Doug. Just playing dumb, playing ignorant when it benefits their side. This is crazy. And and Sheriff Chuck with the reminder that Jennifer Nichols is now a judge herself. I'm angry. I'm angry. Oh, let's go, chat.
And concerning the fact that the court has said that I don't intend to continue the case, I guess that should be modified somewhat to indicate that I don't intend to continue the case absent good cause shown. And for good cause shown, it might be the unavailability of a material witness, it might be sickness or something on behalf of an attorney, but what I've tried to encourage the parties to fully understand that I don't want to get to the trial date and then have someone say, Judge, we're not prepared to go forward. Because it's been over 2 years. I think I could ready myself to try the Nuremberg trials in 2 years. So that's what I meant. Good cause shown, the court might have to, but it's firmly my intention to go forward as scheduled. So your motion for recusal is hereby overruled by the court. You want to proceed on your second motion?
Yes.
All right. It's a motion to set aside order disqualifying Luke Evans as attorney of record for Zach Adams. And I want to make a preliminary statement concerning that at this time. I have never, to my knowledge, set eyes on Luke Evans. I'm assuming this might be him in the courtroom, but I don't know. And I think he will confirm that. I will say that anything that I know about Luke Evans' involvement in this case was gleaned from a public record. I was preparing to hear a motion for injunction to enforce an immunity agreement that was filed in the Chancery Court of Decatur County. Frequently, I interchanged with the Chancellor, and she was fairly new at the time, and I was prepared to hear it. And then the untimely death of Mr. Shayne Austin rendered the case moot. But is that not correct? We've never met, to my knowledge, have we?
That's correct, Your Honor. I think we had a teleconference in that case.
We did in that one? I didn't even remember that.
Yeah, we had with Scott Sutherland, with the Attorney General's office, myself, and yourself. It was a scheduling conference regarding setting a hearing out prior to Mr. Austin.
And then upon his demise, it was moot.
That's correct.
Okay, thank you. All right, proceed with your motion, please.
Yes, Your Honor. I would like to call Luke Evans to testify.
Okay, come around, sir. Won't you raise your right hand, please? Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Would you state your name for the record, please?
Luke A. Evans.
Okay, and how are you employed?
I'm an attorney.
Okay, and who do you practice with?
I'm a law partner at the law firm of Bullet Fly, Hornsby and Evans, in Murfreesboro, Tennessee.
Okay, and can you explain to the court how it is that you came to be involved in the representation of Zachary Adams?
Yes, I was contacted by you and asked if I would be both willing and able to engage on behalf of Mr. Adams. In response to that inquiry, my first statement was that I needed to check with the BPR because I had previously represented Shayne Austin.
Okay, and did you in fact check with the Board of Professional Responsibility?
I did. I contacted them immediately after speaking with you on November 23rd, 2016. I spoke with Stephen Christopher that afternoon in detail about the issues related to any potential conflict that might exist and ultimately might.
They use the acronym BPR, Board of Professional Responsibility, we've got a lot of people that are non-lawyers.
Sorry, Brian. So I called the Tennessee Board of Professional Responsibility and ran it by Mr. Christopher in detail.
Just what details did you tell him? I mean, what facts did you make clear to him when he made the decision that, or when he advised you that there would not be a conflict?
On that date, I alerted Mr. Christopher that I had previously represented Mr. Austin, who had not been indicted in the case, but was considered at the time a person of interest in the investigation. I let Mr. Christopher know that I had filed a civil suit and litigated the issue of enforcement of the immunity agreement in the Chancery Court of Gator County, and that there was a proffer attended where for those who don't know what a proffer is, where myself and Mr. Austin met with several agents from the TBI one evening and had a discussion with them, as well as I had some interactions with Ms. Beth Boswell, who was the attorney at the time handling the case. Assistant attorney. Yes, sir. Had some discussions with her in negotiating an immunity agreement. I then let Mr. Christopher know that after all that had transpired and we were litigating in Chancery Court, that Mr. Austin had unfortunately taken his own life and was now deceased, and that I had been contacted by the defense team for Zach Adams with an inquiry as to whether or not I could possibly be one of his attorneys.
And what did you advise the board as to Zach Adams and what your role would be and how his case related to Shayne Austin?
Well, what I advised the board and what I had been, information I had received from the defense team was that essentially there would be a consistent defense theory at play and trial.
And what does that mean, consistent defense theory?
Essentially, from what I understood from speaking with you initially, that your argument on behalf of Zach, and therefore Zach's argument, was that not only was he innocent of this, they were all innocent of this.
Okay.
Including Shayne Austin.
Okay. And so then, did you relate to them any additional information?
Not that I
Like
recall.
whether Zach had been charged?
Sustained.
Did you relate to them any information about the status
I think that was just a leading objection.
this case was in?
I did let him know it was a death penalty case that was currently pending with Zach Adams. I'll know who the other co-defendants were in the case, I believe, when I was discussing.
Okay. And then
Oh
based
my God,
on
they zoomed all the way in.
what did you do next?
Well, I received an informal opinion from the BPR, which was provided to the court. That day, I just received it verbally from Stephen Christopher, and the opinion was that there was no conflict of interest. My understanding of his opinion was that essentially Mr. Austin was.
Let me say the parties furnished, or they sent some emails, both sides discussion of this issue and the opinion, which were forwarded to me by the staff attorney. I don't actually get emails directly from any of you. They either come to Sherry or they come to Susan Jones. But I was made aware of the email correspondence. So I didn't engage in any ex parte. I viewed emails that had been exchanged between the parties.
Yes. And I'd like to pass up to you a paper. And do you recognize what that is?
I do. This was this is a copy of the email inquiry that I ended up asking Ms. Laura Chastain to send me when I contacted them on January 18th. But it was generated, my understanding, by Mr. Christopher on November 23rd in response to my call.
Okay, so will you tell me then what happened? He gave you an opinion.
Yes.
And after he gave you an opinion, what did you do next?
I immediately contacted you back and let you know that I was cleared from the board's perspective. There was no conflict of interest, no issue related to my being able to engage in the representation of Mr. Adams. And so from that.
So if that's hard to understand for anyone, he's talking about they inquired with the Board of Professional Responsibility, which, you know, they're the go-to if you have a concern, an ethical concern as an attorney. They're kind of like the top level who creates the rules and guidelines and who can help you get some advice. And he's saying, like, look, we made sure to contact them because I used to represent Shayne Austin. Shayne Austin at this point is deceased. Would there be a conflict here? And that board said no.
Perspective that I was
Said no conflict. It'd be fine.
able to proceed and also willing to proceed should the court see fit.
Now, do you understand that there's a difference between having represented someone in a criminal action versus having represented them in a civil action?
Yes, and that's one of the things that the Mr. Christopher made clear when I spoke with him was that essentially it would almost be.
I don't object to what Mr. Christopher may have said in the telephone call between this witness, and we weren't present for it.
He says here, sir, all right?
Right, but basically,
We've got the written email, which the court will consider, but what the prior conversation, he can say, which he already has. We've had it, I disclosed things, he said there was no conflict. We've already filed that.
okay. But what do you understand after doing research and looking at the information is the difference between having represented someone in a criminal matter versus a civil matter?
Well, essentially my understanding upon the review of the rules and what I considered before engaging in this case was, could I ever be in a position to take in representing Mr. Adams that would be materially adverse to Shayne Austin, my former client. Upon my review of the rules and under concurrent understanding of everything I've reviewed, the state is essentially in a spot where they cannot take any further adverse action against Shayne Austin in a criminal matter, because he is deceased, you can't, unfortunately, he's deceased, and you can't charge somebody who's deceased with a crime. So, my understanding of it from that perspective was that would be in play. There was no current concern about a conflict that's related to Mr. Austin. I also understood it based on the opinion that was rendered back tonight. Disclose any confidential information I gleaned through my representation for Shayne Austin. And based on everything I reviewed and understood, my current representation of Zach Adams would not require me to do that.
Okay. And was it your understanding, what if at some point the defense team decided to go with a different theory that perhaps implicated Shayne Austin? Would that have affected your ability to represent Zach Adams in this case?
I don't believe so, based on everything I've looked at again, because the test is not, the test is based upon review of the rule, whether or not it would adversely affect the form of client. And again, even if you, theoretically, even if Mr. Adams took that position, it still would not have been the rules of professional conduct because it would have an adverse effect on Mr. Austin.
Okay. And did you also talk with Zach Adams in this case?
I did, absolutely.
And did you discuss with him your representation and the fact you had represented Shayne Austin?
Absolutely, I discussed that with Mr. Adams, and I discussed that with you as well. And the sole purpose of that was almost, from my perspective, is a belts and suspenders type of ideal to ensure that there was a conflict waiver signed by Mr. Adams. I wanted to, on top of, even though I don't think it was required, based on my understanding of the rules of ethics, I wanted to make sure that I had it. I wanted to make sure that he understood it and that there was no issue with that. So yes, that discussion.
And what I have put before you, do you recognize that?
I do.
What is that?
That is the conflict waiver that you provided me that was signed by Mr. Adams.
Okay. I'd like to make those two things exhibits.
They're attached to your pleadings. That is exhibit B to your pleadings.
I guess my fear is, Your Honor, I'm aware of another case that went
It's okay. The feed is frozen, but the timer's still going. So
up on appeal, and the court said because it wasn't made an exhibit to the testimony, that something that's in the pleading doesn't meet the standard.
But that's in the pleadings up. We'll just send the pleadings up.
The pleadings will be sent.
I'm just trying to cover all the bases. Okay, so after you had received the opinion from the Board of Professional Responsibility, what did you do next?
Your opinion is exhibit A. It's attached, okay?
Yes, Your Honor.
After I received the opinion from the Board of Professional Responsibility and informed you of that fact, I waited to hear back because it was my understanding that you and Mr. Simmons were going to approach the court regarding the appointment in this case.
Okay. And at some point, then, when did you begin work on the case?
December 29th, if I recall correctly, approximately December 29th, December 30th.
And when did you file your notice of appearance in this matter?
I'd have to see the date on the notice of appearance, but I would say maybe January 7th rings a bell, but I couldn't be sure. Whatever date stamp filed on it, or whenever the email was sent.
Okay. And what happened after that?
Well, immediately I'm being notified by you, Mr. Simmons, that I've been appointed subject to AFC approval by the judge. I began working because I knew that there was a trial date looming in April. Sent the notice of appearance out. We attended a discovery conference with Mr. Christensen and Mr. Hagerman and several members of the TBI on the 11th and 12th of January. Worked through that. Sometime after that, I received a email from Ms. Nichols. Ms. Jennifer Nichols, saying that she had concern about potential conflict.
And when you received the email from her, what did you do next?
I responded to Ms. Nichols' email, probably within a few minutes or a few hours, something to that effect, but on the same day, let her know that I had taken steps to ensure that there was no conflict of interest, that there was no issue, and that my representation to Mr. Adams didn't in any way offend the rule of professional conduct.
Then, as far as you know, what happened next is regarding you representing Mr. Adams?
I believe I received another email from Ms. Nichols. At that point in time, it said that, again, I think she stressed her overall concern, saying that she believed there was a conflict, not her exact words. And at that point in time, I contacted the BPR again. I believe that was January 18th. I contacted the Board of Professional Responsibility. On that day, I spoke initially with Ms. Laura Chastain, who forwarded me the inquiry from December 3rd, and then spoke again with Mr. Stephen Christopher. During that conversation, I let Mr. Christopher know that the concerns that had been raised by the state, I think I even read in our conversation, emailed.
And I'm going to object.
Oh, it's what you did, right? You're talking.
He's also saying what the other party responded.
He can say what he did, but
Well, just tell us what you did.
I don't see that it's any good. We can't know what the response is.
What did you do?
I read the email that Ms. Nichols had sent me.
So you made her concerns known to the Board of Professional
I
Responsibility.
did.
What happened after that?
The email that was forwarded to me by the BPR showing that no conflict existed.
Okay. And what was your next interaction with the prosecutors in this case?
The next interaction I had is when we left this discovery conference, we had been discussing several issues of deficient discovery, or missing discovery, or that we couldn't put our hand in. At least discovered that the defense is not going to get made aware of in some cases, or been provided. A list was then done by your paralegal who was present in the meeting and sent to the state, and I was, again, concerned about the upcoming trial. They emailed out to Paul Hagerman to say two things. One was, hey, we just want to check status on the discovery. Where are we on that? The second part of it was to inquire about any proffer statements that they had received from Jason Locke.
I'm going to object at this point. I don't see we're getting off. The purpose of this hearing is whether or not there's a conflict.
Right.
And we are well beyond that. I sat silent for a minute to see where we're going, but I think any conversations that we now have crossed over.
Concerning discovery, anything else is irrelevant.
Well, but but I'm just trying to outline the facts as I have them in my motion as to what led up to us having the telephone conference and him being disqualified. So what I was wanting him to, get to is just what Paul Hagerman had said to him, and then what he did from there, how we came to have the telephone conference.
And Your Honor, the discovery issues has nothing to do with how we came to have the telephone conference. And actually, those emails are also attached to the state's filing this morning so that Your Honor would have benefit of those. But I still say it's hearsay and it's not relevant to whether.
I don't see relevance.
Okay, so then let's just go to the telephone conference. You were a party to the telephone conference?
I was.
And in that conference, was there any new issues raised or new facts raised in the conference that would justify you being conflicted out?
I'm going to object, Your Honor, since it's not his opinion about whether he's, the purpose of the phone call was to voice the opinion.
I didn't let either side argue anything that day. I said that upon further reflection, I reached a conclusion that he could no longer ethically be part of the representation. That just based upon facts that I knew essentially from his prior representation concerning the fact that for all intents and purposes, he was representing the fourth co-defendant.
Okay, so,
But I think both parties will agree, I didn't ask the state for anything further, nor you further.
yes, that's the point that I was trying to put in. And so then no further questions, Your Honor.
All right, cross-examination.
Oh, here we go.
I was trying to write down the items that you said that you provided to BPR on the call, and I wrote down, she advised them that you had previously represented Shayne Austin, correct? You said yes.
Yes.
That you had advised them that you had engaged in a proper and immunity discussions,
Yes.
and that would have been with both the assistant district attorney handling the case as well as special agents with Tennessee Bureau of Investigation. By that, I mean discussions with Beth Boswell, president of the actual proffer.
She was not present.
President of the actual proffer, a number of special agents.
Oh.
Correct?
Good. Yes.
Did you advise them that you had filed a chancery action?
Correct.
And that was upon Beth Boswell and McAdams' determination that your client at the time, Shayne Austin, had not been completely forthright and honest.
Can you repeat that? I'm sorry.
You filed a chancery action to enforce the immunity agreement when Hansel McAdams and Beth Boswell withdrew their offer of immunity.
Correct.
They withdrew that because in their estimation, as is evidenced by correspondence remit to you, that they did not believe that he was completely honest and upfront.
That's correct.
Okay. And you told the board that you had discussed this case with Beth Boswell.
That's correct.
And you told the board apparently that it was Beth Boswell's case.
That's correct.
You did not, however, that Ms. Thompson asked you, was there anything else? You told them anything else? You said no. So you didn't tell them that Shayne Austin said that Zach Adams told him that he, Zach Adams, killed Holly Bobo. That wasn't in the list of things, correct?
Back up again. You're going to have to repeat the question.
All right. I will back up. 2 questions. Ms. Thompson specifically asked you whether the list of items that I just read were the sum total of what you discussed, what you provided to BPR. You said it was.
I don't recall giving that answer as a conclusive answer.
Well, yes or no?
Get her.
You said yes, so you're saying now
Get her,
that's not
Evan.
conclusive?
I'm saying
This is the opposite of, like, now that Jennifer is at the lectern and is not on the witness stand like we saw her in the post-conviction proceedings, she was playing these word games from the witness stand at the post-conviction relief hearings. Now she's trying to make Luke Evans look sketchy by saying that because Jennifer asked, hey, if I list off like a list, I write a grocery list, 10 items, and I say, did you pick those 10 things up? And you say, yes. Then somehow that means I also didn't pick up anything outside of those 10 items. Because I said yes when someone asked me if I picked up those 10 items. Like, Jennifer Nichols is crazy.
Said Zach Adams told him that he, Zach Adams, killed Holly Bobo. That wasn't in the list of things, correct?
back up again. You're going to have to repeat the question.
All right. I will back up. 2 questions. Ms. Thompson specifically asked you whether the list of items that I just read were the sum total of what you discussed, what you provided to BPR. You said it was.
I don't recall giving that answer as a conclusive answer.
Well, yes or no, you said yes, so you're saying now that's not conclusive?
I'm saying that
Robert, I didn't ask that question. I didn't say, is that all you told them?
well, she did.
Is that all you told them?
No.
Okay,
So,
so,
yeah, I mean, it depends on which day. I talked with them in the original, that's the 23rd. Then I spoke with them again on January 8th. So there,
In any conversation with BPR, did you advise them that your client, Shayne Austin, told 3 special agents with the Tennessee Bureau of Investigation
Smile.
that Zach Adams killed Holly Bobo?
not those words, I think.
Okay, thank you. Did you tell? No, that's not.
He's allowed to explain. Answer yes or no, and then if you wish to make explanation.
What I told them was that during my representation of Shayne Austin, that he did in fact commit fraud, where he made statements that implicated Zach Adams. Absolutely.
Okay, well, that's what qualified immunity, that wasn't my question. So my question was, did you actually tell the Board of Professional Responsibility that your client, Shayne Austin, said Zach Adams killed Holly Bobo?
Look at Jennifer. Look at Thompson's face.
Said Zach Adams killed Holly Bobo.
I wouldn't have said that.
Okay.
I don't recall him saying that.
You wouldn't recall that?
I wouldn't. I said I would not have said that because I don't recall my client Shayne Austin saying that during the proffer round.
And you didn't, I assume, tell them that
We have no notes.
your client, Shayne Austin,
Yep.
told you that Zach Adams said he put her in the river next to a rock that had an orange T painted on it.
What?
I wouldn't have specifically said that, no. I didn't, and no.
Your Honor, I object.
Hold on, I have questions here. So they were trying to get Shayne Austin to proffer first. I'm assuming we have no notes from the state on this proffer session. We're getting what seems like testimonial arguments from Jennifer Nichols for the public here, as DB's pointing out. I think you're on the money. The attorney is like, I don't remember saying that to somebody because I don't remember my client saying that. And now Jennifer Nichols is giving us the detail that Shayne Austin, when he was trying to guess at a location where the body could be found, he's mentioning rocks at a river. Does that not make you wonder if they were feeding details to try to get Shayne Austin to guess close enough? Like, stop trying to make the river and the rocks happen. Chat.
Ms. Nichols is mischaracterizing what was said in the proffer.
I'm sorry.
Shayne Austin did not say.
She's allowed to ask the questions if you want to.
But not testify.
She's
Re-examine.
mischaracterizing what was said in the proffer for the court. That's not what was said
Oh,
in the
this
proffer.
judge. Look at Booth.
Go ahead.
Your Honor, I'm reading from a report, and it's spoken to the agents, and it's spoken.
So you have this memorialized in a report? You don't take notes during proffers when it's something you would need to turn over to the defense team. But you have a report saying that a defense counsel told you that their client said that Zach Adams killed Holly Bobo. And that Shayne Austin also relayed the information about a rock with an orange T on it and a river. So this we get in notes, where there's no longer the original source individual alive to say otherwise. Where is the report for the PCR? Yeah, a report now. Oh my gosh, where is Doug Bates when you need him?
Ms. Boswell, I assure Your Honor, now, as in every other time I've appeared before you, I don't misrepresent what I believe to be the truth based on the evidence in front of me.
All right.
This is important, and I want to know what the board had in front of them when they issued or confirmed the defenses were similar. Because it seems highly unlikely that Mr. Evans may actually advise him of
He
this.
didn't say similar, he said consistent.
Consistent.
All right.
So that's no, you said you didn't tell him that.
Not those exact words, because.
Okay, any other motion?
Your Honor, if I may have the opportunity to complete my answer.
Go ahead.
I wouldn't have told them specifics number one, because I didn't have the benefit of that report or the specific recollection that you're able to recall reading a report that I didn't have the benefit of when I called the
So if you didn't have the benefit of the report, you have the benefit, you are the person who, in the course of this proffer, assisted the special agents in getting a handwritten note from Shayne Austin that implicated Zach Adams.
Handwritten note.
Surely you have recollection of that.
I do.
And did you list for the board the 5 statements that Shayne Austin wrote on his handwritten note?
No, because I didn't have it before me, but if you would have emailed it to me, I would have been glad to discuss it with the board at any given moment.
And you'd agree with Mr. Evans?
So there's supposedly this handwritten note. That they don't provide to the counsel for the person who supposedly wrote the note? Why wouldn't they provide that to him?
I would have been glad to discuss it with the board at any given moment.
And you'd agree with Mr. Evans that the state would have no way of knowing that you were trying to have yourself put on this case?
No, I mean, when you emailed me on the 18th or the 16th, if there's anything you wanted me to let them know, I would have been glad to do that.
So Shayne Austin told you that Zach said, I will make you disappear like I did that girl. That's what he wrote, right? In your presence.
You can tell me.
That's what he wrote in your presence during the course of the proffer.
Can I take a look at that?
No. I mean, I'll pass up in a minute. I want to see what you remember.
I don't know.
Okay. Do you recall that he said that he wrote, I had her chained up in the back and called Shayne to, please excuse me, Your Honor, fuck her. Remember that one?
Use your whisper voice.
When I recall,
Wait a second. Please, I don't want any disturbance out there.
no, I don't recall that being said.
Do you recall Shayne Austin writing in your presence and you providing it to TBI? You have to gut them so they won't float.
What I recall in that interaction now.
And I'm going to ask you to answer yes or no and then explain
No,
as
I
the
don't recall
judge.
that specifically, because, no.
Is this all just meant to line up? Was it Misty Tubbs? Maybe was it Jamie Darnell? Who are the two at Dottie's bar that are supposed to also have heard these things when Zach was drinking? Is this just like Shayne reciting something when he had an immunity deal on the table in front of him and he's writing these things out, reciting them? And it's supposed to look like, oh my gosh, here's first person knowledge of Zachary Adams saying these things out loud. It's coming from his friend Shayne. But those details are things that we've heard from other places already. So this seems like the same type of inserting, sprinkling in little details from other witnesses. That way they can triangulate and self-corroborate themselves.
But that's not what I said.
Do you recall Shayne Austin writing in his own handwriting that Zach said, I put her by the teeth in the river. They'll never find her there.
I do recall that, yes, ma'am.
Do you recall Shayne saying, Zach said, no body, no crime?
I do recall that.
So those items, the ones that you recall today and the ones that you don't, were
Yeah, each one of those things are things that we heard somewhere else before.
not provided to the BPR when you spoke to them, correct?
Not specifically in those words. What was provided to the BPR was me running through factual scenarios like, if my former client absolutely said that the current client had admitted to doing it in certain times, in certain places, would that in any way affect my ability to engage in representation of the current client if my former client was now deceased? I think that pretty well covers all those statements, but it would have to be an accurate reading of those statements too.
And you would agree that the email that you received from BPR says the caller confirmed. You're the caller, right?
Yes, ma'am.
So Luke Evans confirmed for the Board of Professional Responsibility that the legal and factual positions of the former client and prospective client with regard to the criminal allegations are consistent.
Correct.
So despite the fact that you were present for this proffer,
DB, I think you're really on to something. This is to tell Austin, who's watching this on the news from his cell, what to say. And we know he was speaking with his wife, Lisa Autry. But remember, Katie Spirko and Miss Janet Demeanor is going to be watching the Katie Spirko Jason Autry interview where Jason Autry recants. Katie goes, "Where did you get the idea to gut her?" And is this what Spirko is getting to?
and despite the fact that you were present when your client at that
All
time
over topics.
wrote those 5 things about the person you now want to represent, you confirmed for BPR that that was consistent?
Absolutely. Their positions, from what I've been informed from the defense team, are absolutely consistent.
And you were present here at the teleconference, of course, when the judge disqualified you from continuing to represent Zach Adams, correct?
Yes.
We heard him make statements, of course, about the appearance of impropriety or conflict of interest with respect to the public and the public's, in the family, and the public's confidence in the judicial system.
Yes.
Okay. And would it surprise you to know that this family and these friends of Holly Bobo would have a significant problem with you representing Shayne Austin and then now representing Zach Adams? Would that surprise you? Because that's the public.
Well, it wouldn't surprise me. I can't begin to imagine what those ladies and gentlemen have to go with. That wouldn't surprise me. But that's not the legal standard. Appearance of impropriety is not the legal standard.
And I appreciate you trying to educate us, but that wasn't my question.
Okay, well,
Oh,
You understand my question?
I answered it. Do you need me to explain?
No?
Okay.
You answered affirmatively. Would you agree with me, or you wouldn't be surprised?
But I said, I can't imagine. I can't begin to imagine that.
Have you ever had death penalties? Ever tried one? One. Sorry, what'd you say? Have you ever
I
tried
haven't
one?
said anything yet. I previously handled a death penalty case that.
I'm sorry, that wasn't my question. Have you ever tried a death penalty case?
No, ma'am.
Despite never having tried a death penalty case, you're aware of the scrutiny placed on those cases in the event of conviction down the road. Correct?
Sure.
You've read about that, I assume. Since you haven't tried one.
And I've tried multiple homicides, and I'm aware of the heightened standard, and I've handled other death penalty cases.
But haven't tried one.
Luckily, they took death off the table for them to trial, so.
You saw this waiver
I did.
and Ms. Thompson attached to our pleading. You recognize that as being her handwriting.
I did.
And you read it.
I have.
And it's your position, you're going to sit here under oath as an attorney and tell the court that you should stay on this case despite the fact that you guys got the defendant, Zachary Adams, to sign a waiver saying that there might be conflicts in the future. We don't know about them yet, but that's okay.
I don't understand your question.
Look, you told us that in part, you based the fact that you didn't think there was a conflict on the waiver and on the BPR opinion. Is that a yes?
Yeah.
And so this waiver says, there may also be actual conflicts at some point in the future. I have discussed this matter with Jennifer Thompson and am willing to waive any conflicts.
Okay.
So in other words, what's his educational background? Zach Adams.
I don't know about that.
Right. And that might be an important thing to know when you obtain this kind of a waiver from somebody, right?
Well, I didn't obtain the waivers.
Now, I'm just asking because you said you handle so many cases.
Sure.
And so if a person doesn't understand what they are being asked to sign and what they are waiving away, that would be a concern, wouldn't it?
If that, no, absolutely. If it was in fact the case that the person didn't understand, sure. That would be a concern.
How many capital post-convictions have you had?
One.
Do you understand that this waiver, Mr. Adams agreeing that he's waiving things in the future that he doesn't even know about, would not stand over the course of time when looked at in the post-conviction arena, separate and apart from your BPR clearance to proceed? This is a different issue.
Are you giving me a legal opinion or are you asking me a question?
That's the question.
You're going to have to restate it. I didn't ever hear a question.
Do you understand, given your vast experience, that this kind of waiver would not stand the time when it's looked at later on that he's convicted?
I don't understand that. Because I don't know that you can understand that either. Because we're not the courts and we're not in the future.
So you don't want to answer that question?
No, ma'am.
What another judge?
Oh my God, this squeak.
I need to ask you, I've left some documents back there. Is that proffer that you've been referring to, I either need that in exhibit or I need it attached to pleadings?
I'll get you a clean copy of this.
Okay.
It's attached to a pleading. I have something circled on mine. I'm going to get a clean copy for you. And you should have it, but I wouldn't want you to have to sift through the hard drive because it's IR.
Oh,
Let's just...
how considerate. Jennifer Nichols says you should have it. The copy I have on me today, I have a circle on it, so I can't give you this one. But you should have it. But I wouldn't want you to have to sift through the hard drive to find it. How considerate, Jennifer Nichols. You've gone out of your way to make sure Jason Autry could get things. You're going to make sure Judge Creed McGinley can get things. Those are your two important people, your two VIPs to make sure they can access important information.
File it as an exhibit.
Okay.
One.
Phone number, Joe. One that what the question? In the board opinion that you shared with us.
What did he say? They only attached the response?
Attachment to her response. That you shared with us. It actually says that that opinion is not binding on any court, correct?
Absolutely.
Or anyone else, for that matter.
That's correct.
It doesn't afford you protection.
No, it does not.
Your Honor, I've got the hour, but I just want to get a clean copy that's not circled. But I'll go ahead and file it, maybe I'll substitute it. We show the defense counsel's got a couple things circled.
I think we got a clear copy. We found it.
And it has an attachment.
Right here, hand that to her. Maybe that's,
That's the attachment to the proffer.
okay.
The actual proffer that Ms. Thompson was indicating.
Well, the attachment was what you were reading from.
Actually, I was reading from both, Your Honor.
All right,
Let me pass forward.
I've got it. Let's,
I don't think that's what she has. That's not what.
No, sir. That immunity agreement we discussed, but I'm passing forward.
I'm also thinking about how Jennifer Nichols was like losing her mind when Doug Bates was reciting something verbatim from any type of record or exhibit.
That's what I was reading from the part.
Yep.
it's got some markings. It makes no difference to the court.
What? Oh my God, in any other issue, like if the prosecution didn't want to turn over their copy, they would say something like, hey, this has our notes. This is our work product. This goes to like, you know, what we're thinking when we're going through certain pieces of evidence, certain records. And now the court's just taking versions with work product on them.
The handwritten.
And this is all after the first argument from this morning being you had these ex parte communications with the state and you came across certain knowledge that had you prejudging this defendant as guilty. So we cannot try to minimize the significance of any notes or any indication coming from one party and just one party only.
Was attached to the to this. All right. Then that'll be Exhibit 1.
Nothing for the purpose.
Yes, I'd like to see Exhibit 1 if I could, please.
Yeah.
Now, would you agree with me that saying somebody killed Holly Bobo and saying somebody said they killed Holly Bobo are two different things?
They are.
Okay.
Your Honor, I'm going to object to relevance to whether.
No, let her go. Let her go.
What is this guy like losing it over here? And I think he's losing it at Jennifer Thompson. I think that's unfair, but that's a serious question. There is a major difference between Shayne saying something to the effect of, I know Zach killed Holly Bobo, and then being able to explain how he knows that, and just saying, well, Zach said something to the effect of, I'll put you next to her. Yeah, is let her go a legal ruling? Oh my gosh.
And so when Shayne Austin went in to give his
Shout out to
proffer,
Sheriff Chuck for the 5 gifted. Thank you,
he
Sheriff Chuck.
specifically told the TBI that he never believed that Zach Adams had actually done those things.
If I recall.
He was telling the TBI what he had heard Zach Adams say before.
Yes, that's correct.
And the statement, you know, if you look at this IR report, the statement that he made about having Holly chained up, Shayne Austin said that Zach Adams said that in a bar. Isn't that right? And Double D's or Johnny's?
I'd have to look at the report and see what it says.
I'll just pass it to you and refresh your memory.
That's correct. That's
I just want to refresh your memory on the whole thing, and then I can ask you more questions about it.
Your Honor, can we have a sidebar conference, please? Judge.
Yes.
Would you like to hear?
let's go back there. I'll have the court report join us.
All rise. Court will be recessed.
All right, so next we have the part 3 on this one. What a stressful hearing. Holy moly.
In this matter.
Yes.
Run this back. All right, so part 3. They're coming back into court. Also, double shout out again to Sheriff Chuck now that I'm not playing anything. Thank you for the gifts. Thank you. He says, we need help in here. I'm pretending that it's blood pressure medication that you're dropping to the chat here, because what a day. So we've got everybody walking back in here. Camera person is going bananas today.
All rise.
All right, be seated. Mr. Evans, let me say that you cannot testify to anything that would be considered client privilege, client attorney privilege.
Absolutely.
You understand that?
I do.
Okay.
And I want to say for the record that at no time during my examination have I testified to anything.
Sometimes the way the questions are couched might raise concerns, okay? So listen very carefully, because you can't disclose communications between you and Mr. Austin.
Absolutely.
Okay.
And would.
Now, the state had asked you about a quote that Shayne Austin presented in the proffer session. And it was the one where Shayne said that Zach claimed to have Holly Bobo chained up out back and called Shayne to fuck her. Isn't it true that that statement was made by Zach Adams in a bar to unknown people?
Your Honor, I'm going to object to hearsay, speculation. He can't know when it was made.
No.
I mean, if his client made certain representations about when it was
That
made.
would violate privilege.
I'm sorry. Isn't it accurate that that's something that Shayne Austin said in the proffer? That he heard Zach Adams say in a bar to unknown people, he had Holly chained up at back and called Shayne to fuck her.
According to what's said in the proffer in the IR, that's what's written there.
And according to the IR, when Shayne said that no body, no crime,
Muted. I was gonna say I gotta pull one from Potentially Criminal here and draw some laser eyes from Brent Booth to Jennifer Thompson. Oh, that was all. That was all, chat.
at that time, that was not something that Shayne Austin took seriously. And that's what he communicated in the proffer to the agents, isn't it?
I'd have to look back at I'd have to look back and see what the IR says. Again, those statements weren't made to me, they were made to agents with the TBI.
It's in the last paragraph. On the first page.
What I've got is Agent Russ Winkler's IR here that says, according to Shayne Austin, the topic of Holly Bobo came up here. Zach Adams answered twice. In regards to disposing of bodies, say you have to get them so that they won't play. Shayne Austin says that he also heard Zach Adams say, no body, no crime in connection with the Holly Bobo investigation. Zach Adams says things like this to a lot of different people. It should have heard the same comments from Mr. Adams or from Zach Adams. That's what Mr. Winkler did.
Okay. And then towards the end of the IR, doesn't it also note that Shayne Austin said he never believed that Zach Adams had actually killed Holly Bobo?
Oh!
Agent Winkler notes on the second page, according to Shayne Austin, he should have told this information earlier, but he was a little apprehensive. He grew up with Zach and went to the same church with him. He just never believed that Zach was saying, what Zach was saying about killing Holly Bobo, about killing Holly was true. That's according to Agent Winkler.
Okay. And so the items that were written on the piece of paper and provided to the TBI, these are items that Shayne Austin told the TBI he had heard Zach say. Is that correct? I mean, according to the report, these are things that he wrote down that he had heard Zach say.
He remembers it or doesn't remember it?
Do you have a question?
Yes, Your Honor. And in fact, Shayne Austin, during the proffer session, told the TBI that he had been with Zach Adams on the morning that Holly had disappeared. Isn't that accurate?
I'll have to look at the
So this is just me reading the body language of Luke Evans here, but the way he's looking at this report now that he has it in front of him, it seems like this is the first time he's seeing a lot of these things, which to me would indicate that Shayne Austin himself never said these things to, at least in the presence of Luke Evans, which I think is suspicious. And K-Riggs, important context here that I should have said out loud. The state gave Shayne full immunity. They wanted Shayne to say, all right, tell us everything. Tell us where we can find Holly's remains so her family can get closure. And then when he did not point them to where to go actually find Holly's remains, probably because he couldn't, because he didn't actually know, they rescinded that immunity deal.
That's according to Agent Winkler's notes, or his report. That's what was said.
And also he told the agent that he had gone into Parsons with Zach Adams and Dylan Adams to purchase Xanax bars during the proffer.
Again, according to Agent Winkler's notes, that's what was said.
Parsons.
And Austin denied that he had, in the proffer, that he had ever
She wants to
did Shayne Austin disclose in the proffer that he had ever disposed of any evidence on behalf of Zach Adams?
Again, according to Agent Winkler's report, it says Shayne Austin said that he did not help dispose of Holly Bobo's body. That he has not ever gotten rid of any evidence, and that he has never been asked to do either.
Okay. And did Shayne Austin, during the proffer, tell or deny to the TBI that Shayne had anything to do with Holly's disappearance?
I'm sorry, I didn't understand the question.
During the proffer, did Shayne Austin deny that he had anything to do with Holly's disappearance?
Again, and referring to the report, Agent Winkler's report, Agent Winkler's report set the notes in as saying that he did not help dispose of Holly Bobo's body, and that he has not ever gotten rid of any evidence, and he has never been asked to do.
And does it mention that he denied having any personal knowledge of what happened to Holly Bobo?
Yeah, Agent Winkler's notes on the first page, Shayne Austin said that relevant to Holly Bobo investigation, he does not have any direct knowledge of anything to do with her disappearance or death. He claimed that everything he knows is based on what Zach Adams told him.
There's no further questions.
Mr. Evans, on March 8, 2014, 2 days after the proffer, you emailed Beth Roswell and said it is the position of my client that he was truthful, candid, forthcoming, and cooperative with the government in this matter. Correct?
Yes, that's what the email says, that's what I said.
And the matter that you're referring to is the information you gave in the proffer. Correct?
I was noting my client's position regarding the information in the proffer.
So that's yes.
I'm not sure if it's a yes, I'm not sure if the question is. I'm not.
You said in this matter, that your client was truthful in this matter. You're referring to the proffer, correct?
I didn't say my client was truthful. I said it's my client's position.
I'm talking about in this matter.
Yes,
You're
that would be the
referring to
proffer.
the proffer. It's not a difficult question, Mr. Evans. You're a smart man. You're referring to the proffer, were you not?
Yes.
There you go. not that part. In addition to the information given in the proffer, you are referring to 1 through 5 handwritten notes by Shayne Austin, weren't you?
I was referring to exactly what it says, ma'am.
Right. And in fact, you thought your client was so truthful, forthcoming, cooperative, that's what you said, that you filed a civil court action to enforce the immunity agreement for Shayne Austin, right?
Ma'am, I was an attorney.
I'm sorry, it's a real easy question. Yes, you filed a civil action, or no, I didn't file a civil action.
I did file a civil action. My thoughts regarding anything related to my client are privileged.
You filed a civil action, maybe privileged, but you put in here that it's your position, your client's position, that he was truthful, right?
Yes, I
And
was.
if you wouldn't have filed a civil action with no legal basis, in your opinion, would you? Because that would be unethical.
No, I would never file anything that was not based in fact.
And so because you filed a civil action confirming, affirming Shayne's veracity, that means you believed him with respect to Zach Adams and what he heard Zach Adams say. Because to do otherwise would have been you filing a civil action with no legal basis.
I can't answer that question.
Done.
Yes, Your Honor.
Step in. Next witness.
Didn't have a basis, Your Honor.
Okay. You want to be heard?
Yes, Your Honor.
I'm assuming the state does not wish to call witnesses.
We do not.
All right.
And so I'd like to see exhibit, was it 1, again, the proffer, it might be a prototype. So, Your Honor, the state's trying to make a point in this case that because Shayne Austin came in, did a proffer, and said those things, that then that makes Shayne Austin's position inconsistent with the trial theory in this case. And the state is clearly misrepresenting what happened at the proffer. What happened at the proffer was that Shayne Austin went in and said, I heard Zach Adams say these things. He put it on a piece of paper. I heard Zach Adams say these things. He wrote these things on the paper. At no time did Shayne Austin go into the proffer session and say, I know that Zach Adams killed Holly Bobo, or that anything of that nature. What he said is, look, I have no personal knowledge. I've heard Zach say these things. And, Your Honor, that is not going to be inconsistent with a defense in this matter. In this matter, it's not inconsistent to say that Zach Adams may have had and said some crazy things. What the state is wanting everybody to overlook is the fact that Shayne Austin was with Zach Adams that morning. That Shayne Austin did not believe that Zach was telling the truth. That Zach Adams had said those things to multiple people, Your Honor. And that does not make a conflict in this matter. First of all, and I will just point to the law. You know, the state cites no law in this case saying that Mr. Evans cannot represent Zach Adams in this case. But in this case, and the law on attorney conflicts has changed in 2011. The whole law on professional conduct was wiped out, and there's no longer canons. Now it's the rules of professional conduct that are in play, and there's no longer an appearance of impropriety. That was removed completely. It's a true conflict in the case, and In this case, there's two types of conflict, and this is under the rules of professional conduct. There is either an actual conflict between two clients, two present clients. You can't represent one side and the other side in a divorce. You can't represent both parties in a divorce. And that's never going to happen. There's never going to be that kind of conflict between Zach Adams and Shayne Austin, because Shayne Austin is deceased and he can never be charged with a crime. The second type of conflict in this case or in the statute, in the rules, is that there is a conflict, you're representing a current client, and because of a representation of a former client, somebody you've represented in the past, because of something you know about that former client, it's going to restrict you on what you can do for the current client. And that is not an issue here either, because there's no tool in the attorney tool belt that Mr. Evans has that he cannot use for Zach Adams, because the harm in this case, because it was a criminal case in this matter, the harm in this case would be that Shayne Austin would be charged with a crime, convicted of a crime, and that is never going to happen. So in this case, if it would be possible, and there would still be no conflict in this case, for for Luke Evans to represent Zach Adams and go in and completely blame the whole thing on Shayne Austin. He could go in there and said Shayne did it and come up with a complete story about what happened. That would still not be a conflict with the past client, because regardless of what they would ever say, and this is just hypothetical, it could never result in charges against Shayne Austin. And that's specifically what is in the law. I mean, that's what the law says. In addition, the theories are not inconsistent. The fact that Zach Adams may have said some crazy stuff in a bar does not make it more or less likely that Shayne Austin would be charged in this crime. And it is not an inconsistent theory with what the trial theory would be. And so because there is no actual conflict in this case, then the court could look as to whether there's a potential conflict. Well, there's no potential conflict that could possibly arise in this case either, because Shayne Austin can never potentially be charged with a crime in the future. It could not happen. And Luke Evans was representing him in a criminal matter. It's not like he was representing his estate or doing a will for him. He was representing him in a criminal interest. And that criminal interest has died when Shayne Austin passed away. Then the law is also clear that the court used the wrong standard when determining whether or not to remove Luke Evans, because the court used the standard that was the appearance of impropriety that would erode people's faith in the judicial system. Well, there are 4 other attorneys in this case that could have possible conflicts. One, Mr. Maddox, and this is in the discovery, came in and did a proffer session with another witness who came in and said things about Zach Adams and Jason Autry. And he did that in 2014. In May of 2014, he met with TBI agents in this case. TBI agents that are here did a proffer session, and they did a report on that. Paul Bruno, before engaging to represent Dylan Adams in this case, went to meet with Jason Autry in prison at Riverbend Prison at the request of Jason's mother to discuss possible representation. He met with him. He discussed things with him. But before he came on to represent Matt Maddox, he made sure that there was no conflict. They took appropriate action, discussed it with Jason Autry's attorneys. In this case, Jennifer Nichols was working for Matt Stowe.
I object, Your Honor. I never worked for Matt Scholl.
She was working on this case under the direction of Matt Stowe.
No, sir. Correct.
No.
She filed she was
Notice
on
of appearance
conference
pro
call.
tem.
Okay, well, she came in and was on conference calls and was working on this case while Matt Stowe was still the district attorney. Matt Stowe filed a notice that he had to get off the case because of a conflict.
And
Jennifer Nichols was allowed to stay on the case. Under the code, usually when one person in a firm has a conflict and a district attorney's office is...
Do you know why Matt Stowe got off the case?
He's cooking.
No.
It's essentially because he called the TBI a bunch of liars.
Oh,
Miss Nichols did not call them that.
Well, it
that
could be
doesn't
the
matter.
appearance of impropriety, Your Honor, because he had a conflict and he got off and she stayed on.
Actually, I didn't say that, Your Honor. I got off the case.
Well, she's back on.
I got off the case and was not reappointed until after Matt Stowe was taken off the case.
That's correct. And I did not discuss that with her, but I got a call from her district attorney that said she will no longer be involved in this case, period.
that, just because it wasn't from Jennifer Nichols. Look at her face. Look at her face. What the heck? Just because the call wasn't from Jennifer Nichols specifically doesn't mean, like, he's getting ahead of the accusation that he's speaking to one side ex parte. That would still be without the other party present. But he's just preemptively volunteering that detail. It's still the district attorney's office, though.
Once the conflict was resolved, I signed an order appointing her pro tem.
So she was working with Matt Stowe when
So he made that decision. He signed the order after only speaking with the state.
Matt had a conflict, and that conflict was not imputed to her to work on the case later, even though it might have been. I mean, oftentimes a conflict is imputed to another attorney. Beth Boswell worked for 2 different agencies. She was the district attorney, or assistant district attorney in this case, and was also part-time special assistant United States attorney in this case. And she had 2 different roles. I mean, she
Why
represented
don't we
2 separate-
confine this to Zach Adams and Luke Evans?
Okay. So, Your Honor,
That's the conflict we're here to discuss.
How can you discuss a conflict if you can't discuss the outside context? That is not a logical suggestion. What are we doing? Oh my god.
yes, there's no conflict between them. And to be more clear as to what the law says, there have been other cases in the past where they looked at conflicts, and the courts have held that a conflict that is remote, that is,
Whisper, whisper, whisper.
let me find the law here. There is a case called Burns. It's Burns v. State. And in that case, it was a death penalty case, and the post-conviction defender's office was appointed to represent Mr. Burns. At some point, the district attorney's office decided that they no longer wanted the post-conviction defender's office representing Mr. Burns. They filed a motion to have him recused, and the trial judge granted it, based on the fact that somebody in the post-conviction defender's office was a relative of the victim who had died in the case. And the Court of Criminal Appeals said, no, that was not enough of a reason, that there was not an actual conflict in that case. They evaluated that case based on the appearance of impropriety. And based on the appearance of impropriety, and then they went through other rationale as to what could be taken to assure that there wouldn't be a conflict, such as bringing the client into court, having the client say on the record that he waived the conflict, he understood it, and all of that could be done to ensure that the public would remain confident with the judicial system. But since the law was reworked, they've taken out that appearance of impropriety under the law. that now there's only a very, very narrow appearance of impropriety that is left in a comment number 9 to Rule 1.10 of the Rules of Professional Conduct. That cites a case that was the Tennessee Supreme Court in which an attorney was representing a couple in a boundary dispute. He left his firm and went to work for the firm that was representing the opposite side in the boundary dispute. The dispute was still going on. There were two current clients, and the Supreme Court found that the appearance of impropriety in that case was so strong, even if he promised not to tell any secrets, it still looked so bad that it eroded the public's faith in the system. But in that case, there were two current clients that were still in the same disputed matter with each other, and one of the clients had something to actually lose. I mean, one of the people was going to win at the expense of the other client. And there's a comment that still allows for an exception for appearance of impropriety if it's that narrow of a ruling. But in this case, Your Honor, the Board of Professional Responsibility found there is no conflict here. There's no actual conflict, and there cannot ever be.
What if they didn't have all the information?
Mr. Evans testified that he told them that he ran scenarios by, and one was, what if Mr. Adams actually came in and what if Shayne Austin had actually implicated Zach Adams in the case, had said he did it, which that's not what we have here. Shayne Austin said, I heard Zach say things, I never believed him, is what is in the record. And Mr. Austin ran a worse scenario than that by the Board of Professional Responsibility, and they said no conflict because Shayne Austin can never be charged with a crime. And so I argue, and the other problem with this is the state has not filed any motion in writing. There's no motion, there was no oral motion as to what their objections were. There was nothing in writing.
They filed a response.
Well, I know, but they didn't file a motion. And they filed, I thought the response was to the recusal.
No, the response, all of it was in the same document.
Well, it's a response to the recusal, not to the court, not.
No, they covered all of it.
Okay.
Oh my God.
So
I read it this morning.
Look right over. What? He darts right over, looks at the state's table right as he says that.
Not to the court, not.
No, they covered all of it.
Okay. So
I read it this morning.
in this matter, Your Honor, there's not a conflict. There can never be an actual conflict. There will never be a potential conflict. And so based on that, it was improper for the court to remove Mr. Evans. The court used the wrong standard to remove Mr. Evans, and therefore we ask that the court set aside that order and allow Mr. Evans back on the case.
Hear from the state. Just get that to her.
May I proceed?
You may.
Kind of start again and go backwards.
You can go any way you want to go.
I'm dumbfounded that Ms. Thompson would say there is not a conflict, there can never be a conflict, there under any stretch, because I'm looking at her handwritten waiver where she got Zach Adams to sign saying the exact opposite.
What? Just because someone signs a waiver saying I waive any conflict doesn't mean that they're arguing that there is in fact a conflict. Is this really the showboat performance we're about to get? Because I think that's what we're about to get. Let's run this back.
Kind of start again and go backwards.
You can go any way you want to go.
I'm dumbfounded that Ms. Thompson would say there is not a conflict, there can never be a conflict, there under any stretch, because I'm looking at her handwritten waiver where she got Zach Adams to sign saying the exact opposite. The exact opposite. So for her to stand before the court now and tell you that under no conceivable scenario could there ever be a conflict leads me to believe that they, the defense, really are trying to set up a situation where, in the event of a conviction, in the event that Zach Adams is sentenced to death, that they have a built-in successful post-conviction relief petition and or federal habeas. Because why else would you say that? Why else would you sit here in court and say that we have consistent defenses when they are so clearly...
Look at the bozos back here.
If you're not trying to set this court up.
This is crazy.
And as far as bringing Mr. Maddox into it, Mr. Maddox had a proffer with somebody that wasn't a suspect. And he threw his hand up and helped me out.
I'm not interested in
Maddox.
I'm not interested in you, whoever else she said had it. We're here, as I said earlier, concerning defendant Zach Adams and Luke Evans. Is there a conflict is what the subject is.
Trying to stay on course, Your Honor, it's clear that there is. They cannot know. They cannot know how this...
For this to be a good faith argument, it would have to be the case that there was never an opportunity to waive any conflict of interest. That's the premise that Jennifer Nichols is arguing off of here. But she's doing it in such a performative manner that it's just... The gallery on her side is probably like, wow, yeah, the defense attorneys are so disingenuous and they are misleading the court. Yeah, Jennifer Nichols.
Trial is going to play out. And there are so many scenarios where the exact things that they are saying do not present conflict, simply do. We have TBI agents who were witnesses to things said by Shayne. There have been statements made by Mr. Scholl on the record today about representations he was made to Your Honor about his client situation. Not going to get into.
He made them on the record, but he didn't technically get on the stand, and not for nothing, but that really doesn't help you or the court in either of your positions that you guys both followed the process and colored within the lines here. But anyway, look at Jennifer's face here. It's cut off, but she's like, are you serious right now?
Into that now. But there is a conflict. If Your Honor wants us to spell out in more detail the situation of other defendants, we will. It was my hope to avoid doing that at this point in time. But the representations made by Shayne Austin, the things he overheard, or things that Zach Adams told, regarding murder, rape, kidnapping of Holly Bobo. We have other proof confirming those statements. We absolutely put on the record what was said before, and that's what we're asking that Mr. Evans be, that you affirm the disqualification of Mr. Evans from this case and allow us to proceed with attorneys that don't have that conflict.
I would like to address the one issue about the waiver of conflict, Your Honor. If you do a waiver, then they say, and especially a waiver of something potential, you just say, there might be something in the future and I waive it. That certainly is not indicative at all that I was trying to be sneaky or tricky. A waiver just says whatever's there, I give it up. And as an officer of the court, I am absolutely not trying to do any kind of tricky things. I'm trying to take this man to a trial and do the very best job I can for him. And I believe that at this point, having a third attorney is absolutely essential. The state has 4. And Mr. Evans was an excellent choice because he knew facts about the case and he was ready to get to work on it.
Let me ask you something concerning ex parte motions under Rule 13.
She didn't bring that up, But we're just going back to ex parte. What are you worried about? I thought there was nothing wrong with your communications because it was just about scheduling. So why is this still on your mind?
Concerning ex parte motions under Rule 13. I have met with all attorneys in this case at various locations for ex parte motions concerning services. I've met with you or Mr. Simmons in 4 different counties and in the city of Nashville to accommodate. Do you recall a conversation where you mentioned to the court that you might ask for an additional attorney, essentially that the state had 4 and you felt like it?
That would be a scheduling issue.
You felt like that it merited?
Yes, sir.
You recall my response, if that's in violation of court rule, it can't be done, and you said I might want to build a record on that sometime.
Yes, Your Honor.
But yet you proceeded with an ex parte motion as opposed to a motion for extension of Rule 13 to add a 3rd attorney.
I guess all funding motions under Rule 13 are ex parte, as I understand them.
The appointment of attorney might not necessarily be.
Well, the funds to pay for an attorney.
So then have your court clerk say, hey, this isn't the way to file something like this. Or you respond to that motion and say, hey, in response to your ex parte inquiry about appointing an attorney, this doesn't really fall under the normal bounds of an ex parte communication. But yet you let that seemingly continue. You didn't address it. And now you're going to challenge it as a last-ditch effort to criticize Thompson, defense counsel, rather than address it and course correct while it was happening and not going through the proper channel.
Would be. If we're.
But the state had no opportunity to raise the conflict issue because of the way it was presented, correct?
That's correct, Your
All right.
Your Honor.
Take about a 5-minute recess and then we'll have a ruling.
All rise.
Like we have a hearing on it, though.
Let's get back our seats, please. All rise.
Mr. Simmons is front of us.
He's running back. I know that people run to the restroom. I didn't know they ran back. All right, be seated. Concerning the court's ruling, in retrospect, which they say hindsight is 20/20, the appointment of Mr. Evans should never have taken place in an ex parte motion. Those are for services and things like that to provide indigent defendant adequate representation.
So this
Such
is his
as,
way of
and I'm not
denying
referring
this.
to anything in this case, I'm just saying in general, mitigation specialist, investigators, there's any number of things. It should have occurred to me that I've never seen an attorney put on board through an ex parte motion. The first time I realized that that was the improper vehicle was when I got the telephone conversation of less than 2 minutes. She said, I have concerns, and it occurred to me at that time they had not been able to express concerns that the court might have been very interested in. That's why this should have been.
Did you ever have those concerns with the other ex parte communications? This is so weird to me. Because he did all of that work and heavy lifting earlier to say that doesn't matter if I had ex parte communications with the state. But now he's making this decision based on this issue that it's his fault for not addressing sooner by pointing out it was the improper vehicle with which to file a motion to appoint an attorney to the case, that it doesn't fall under whatever rule allows any funding request to go ex parte to the court. And now he's making his ruling based on the arguments that there is no conflict of interest with the appointment by saying there is a conflict of interest because this request was filed through the wrong channel. And I let it fly, even though I'm saying earlier that the court didn't make there was no issue with the court speaking with one party or another. Like,
taken up in open court where they argue that, yes, Rule 13 requires 2 death penalty certified attorneys and does not provide for a 3rd attorney. Mea culpa. I shouldn't have done it that way. But once I realized that what the conflict truly was in this case, I didn't let either side go into any discussion during that telephone conference. And the words that...
So they were all present? What? Hold on, did I hear that right?
That what the conflict truly was in this case, I didn't let either side go into any discussion during that telephone conference. And the words that I used were not appearance of impropriety by Miss Erin. By her notes that were read earlier, it was appearance of conflict. I am absolutely satisfied that there is a conflict in this case and that there is a distinct likelihood of additional conflicts developing throughout this case, and particularly in the sentencing phase, where the rules are different. There might be hearsay. I think Mr. Evans would be placed in an absolute conflict of interest, having received information from his now deceased client that might be in conflict with what Mr. Adams might or might not place evidence concerning. I honestly think that probably there's no one in this courtroom, with the possible exception of Ms. Thompson, that does not see the conflict in this case. It's overwhelming. If we were to use the medical scale of 1 to 10, where they ask you pain, I would say conflict is at 10 on this case. That's how strong it is, and that's how strong the court feels. It's not proper for Mr. Evans to serve on this particular case. The court confirms its earlier disqualification. I will prepare an order consistent with this. Also, I want to say that concerning the court's recusal,
We're back to that issue.
under 10B 2.04, the filing of a petition for recusal appeal does not automatically stay the trial court proceeding. However, either the trial court or the appellate court may grant a stay on motion of a party or on the court's own initiative pending the appellate court's determination of appeal. That stay is hereby on the court's own initiative, granted in this case concerning the recusal motion. All right, anything further?
Not from what I finished, Your Honor.
I'm sorry, I would like permission to appeal interlocutory appeal on disqualification, Mr.
Denied. You may seek an extraordinary appeal if the Court of Criminal Appeals wishes to grant it. I don't see this as an issue. Yes, sir.
Your Honor, there have been a number of Rule 17 subpoenas. I've asked if there's anyone here in response to a subpoena with records in the audience.
Amen to that. I don't know how many I've signed, okay? But I would say probably 25 at least. And once again, I've met, I can't think of his name, with your investigator a multitude of times. I've tried everything I can do to try to help the parties expedite this, including scheduling the ex parte motions, meeting your investigator for purposes of issuing subpoenas, the ones that can't be issued by the clerk.
Correct.
But what I'm saying is, I've tried to accommodate so that we can keep a reasonable time scale on this. And as one of the attorneys said at the outset, it might have been her, I gave everybody in this case my cell phone number and said, to avoid any problems whatsoever, scheduling or otherwise, you're free to call that number. Okay?
Yes, Your Honor, if there's anyone in the courtroom that is here in response to a subpoena.
Anybody here that's been served a subpoena to provide certain records?
I did, sir, and I gave it to your desk. There you go, guys.
Okay.
I think we got them all. Thank you.
All right.
And then, in response to that, Your Honor, the reciprocal discovery motion has been filed, and we've never gotten anything, so we sure would like to keep that as we move forward with Mr. Adams, Zach Adams in particular, since he's going to trial in 3 months.
Right. I don't want to do it right now. Keep your feet on fire. All right.
Did your Honor stay proceeding?
I did not stay.
Okay, I was trying
I
to...
said on the front end I would not stay it. You know, the reason that the trial court doesn't stay proceedings, any case that I have set, somebody can file a motion to recuse 30 days prior to trial, and if it is stayed, your trial date is busted. So I specifically am not staying anything in this case, okay? If I misspoke or misunderstood, I want the parties to understand that. All rise.
Run out of there.
Grab that. Need from the first motion and ruling, I need that transcribed where we can attach that to an order. Okay?
Your Honor, I believe there was another court date that was potentially set in this matter.
Right.
Is that still the case?
March 1.
Judge, may I ask if behalf of Mr. Autry that we do not participate in that report date? We are taking a different route. We are not set to trial in April, and we will have nothing to do with report to the court.
Be excused.
Thank you.
I've excused both defendants from being present today because we weren't taking anything up regarding them.
Can counsel for both defendants be excused?
If they wish to, yes.
Thank you, Judge.
And Dylan Adams here on March 1.
We'll have to let you know. We'll let you know more details.
Court's adjourned.
Everybody shuffling out. That was stressful. All right, so where we go from here, we will be back to press coverage, and it's going to be like 2 to 10 minute snippets all the way through until we'll get to some sentencing coverage. And I really want to get to the first bit of the post-conviction. Like, I really just want you to see the visual. I think it's really impactful. I think we can do that today. So we're going to keep going through this. But not without first thanking Sheriff Chuck for another 10 gifted. Holy moly, growing the gang. Shout out to Sheriff Chuck, as always, showing like a ton of support and turning everybody green. So much love here for Sheriff Chuck. Whew, that was a lot. I just think this whole proceeding was a lot. And so this would have been February 1st. Trial at that time was set for the beginning of April. I'd be sitting there if I was Zach, I'd be like, dang, I'm screwed. I'm innocent, but I'm screwed. Just crazy. So I'm going to hit the next button. This is going to be, we're going to go back to like the first and second deep dive we did on the media coverage. When we were jumping back and forth, I'm going to try to stop and pull up what date everything is published. And make sure I throw captions on every time we get to a new video. It could be jumpy with the volume, guys, so be forewarned that when it starts auto-playing the next video, it might be a little bit louder, but I'll try to keep us in a good range of volume. And then also, we had one issue where a hearing from like a year before was published late, and since this playlist is sorted by the date something was published to YouTube, we do need to be on the lookout that perhaps things could be uploaded on a certain date, but they happened weeks earlier. So I think those are all my disclaimers. We can hit the next button here, and we'll be getting into
Developments tonight in the Holly Bobo case.
April
6
5th.
years after the nursing
April 5th.
student's death, a trial finally appears to be a reality. Today, jury selection began in the high-profile murder case of Zach Adams. And News Channel 5's Chris Conti was in Hardin County.
Holly Bobo's kidnapping and murder have gained so much publicity nationwide that the judge decided the only way to ensure a fair trial would be to move it to here, to Savannah. But even though we've crossed county lines, finding potential jurors to serve on one of the state's highest profile murder trials is proving to be difficult. It is a quintessential southern town right down to the courthouse in the square. This is the place where the highest profile of cases will be tried. Wearing khakis and a button-down shirt, Zach Adams sat in the front of the courtroom. It was the first time in years that Adams appeared in public, not bound by shackles. Zach is accused of killing nursing student Holly Bobo in April of 2011. Judge Creed McGinley told prospective jurors that their honesty and candor were crucial in the voir dire process. You can't base a verdict on what you've seen, heard, or read, Judge McGinley told the courtroom.
But you prejudged.
200.
I think McGinley needs the same advice he's giving to potential jurors.
Verdict on what you've seen, heard, or read, Judge McGinley told the courtroom. 200 potential jurors were brought in today. Officials expect the process of narrowing down the jury pool to last the remainder of the week. Zach Adams' fate will be decided in a courtroom built at the turn of the century. Wood paneling and chandeliers symbolic of an era in the Tennessee judicial system no longer on display in larger cities like Nashville. Each juror was also asked if they could consider the death penalty as a possible punishment, the highest of profile cases in the smallest of southern towns. When all is said and done, 15 jurors will be seated here in July. 3 of them will be alternates, and this trial is expected to last 2 weeks. Zach Adams' trial gets underway on July the 10th. In Savannah, Tennessee tonight, Chris Conti, News Channel 5.
Thank you, Chris. The judge told prospective jurors today they're forbidden to research anything about the case. Once seated in July, all 15 jurors will be sequestered for the length of the trial.
All right, so this is now, if we go by the date, this was published, maybe same day, let's see. Yep, published same day as the hearing. So now this is June 6th, 2023. So we're jumping from April to this here. This is about 23 minutes that we've got.
Any other potential witness in this case, or any kind of incident reports or alleged gang affiliation could be relevant to any other witness in the case. The commissary trust account records, visitation records, including visits from law enforcement, or records regarding transportation away from the facility could possibly have any kind of relevance to any other issue or any other witness that potentially might provide testimony in this case. With regard to the phone conversations, without knowing who all may have been on the other side of a phone call in this case, I don't know if there's any other potential witnesses that are going to give testimony that are on the calls. But in particular, I wanted to address any particular calls that might have been made between Mr. Adams and his counsel. We don't believe that any kind of attorney-client privilege has been waived whenever there's a phone call between Mr. Adams and his counsel. I'm not certain as to when a phone call is made, if there's any type of disclaimer given at the beginning of the phone call. I know some jails give a disclaimer saying these calls are being recorded or things like that. But even if that were the case, even if that were the case, because an inmate has, either the choice of visiting in person with his counsel, or if he ever wants to talk on the phone, it's not like the inmate has a choice of phones to use or devices to use that would not be recorded. They're somewhat forced to use whatever's available to them in order to make contact with their counsel. And I don't think that that's any kind of a voluntary waiver of attorney-client privilege. So if the court were to rule that the phone calls can be subpoenaed and reviewed by the defense by the Zach Adams defense attorneys, I think the court should exclude any review of any phone call made between John Dylan Adams and his counsel, because I don't think there's been any kind of a voluntary knowing waiver of attorney-client privilege under any condition, and I think those should be redacted from any kind of disclosure. But kind of the bottom line to the whole motion is I don't see how these records become relevant in this particular case if Mr. John Dylan Adams is not going to give testimony in the case on behalf of either side.
So they know by June that they don't need Dylan's testimony. They're putting that on the record. So that was the state speaking first. Jim Simmons is going to respond for defense. And it seems like defense made a motion. Zachary Adams' counsel made a motion to obtain like jail call records. And they're saying even if you grant that in part, you should at least exclude anything, even though there's a warning that the calls are being recorded, you should exclude any attorney-client conversations. More importantly, even though I think that's a fair enough argument, I think what's important here to me is this timeline, because we are in June of 2017. June 12th. This is June 23rd, this hearing, but June 12th is when we have that investigative report generated in relation to the May 8th proffer session that Jennifer Nichols had with Jason Autry. So to me, by the time they're making this argument and us hearing that they don't plan to call Dylan Adams, I think that's because they've locked in. We've got Victor Dinsmore in line. He knows what he needs to say because he knows what Jason Autry is going to testify to. And we've solidified, we've locked into the record with that investigative report what Autry's proffer was. So this to me is more important for the timeline than the actual argument being made. But let's see what Jim Simmons says in response for the defense.
As you may recall...
Oh, was that Dylan? Okay, you're right. I think you might be right, K-Riggs. Maddox speaking, or Paul speaking for Dylan. So perhaps Dylan's counsel, not the state.
When this issue is a motion was first filed, we agreed not to review any of the records until it is ruled upon. The important part of this decision, I believe, is we do not know whether Dylan Adams is going to be a witness or not a witness. There's been suggested he would not be a witness, but that hasn't been confirmed, so he still may be a witness in this case. Broadly hinted. I don't think that's quite different from.
Okay, so that was Dylan's counsel.
But regarding the medical record, incident report, all of that could become very relevant, either if Mr. Dylan becomes a witness or in going through that as to the information that may lead to relevant evidence. It's not simply subpoenaing relevant evidence. It could be under discovery information that then would lead to relevant evidence. And as a practical matter, Your Honor, most of these documents we received from the state. That egg has already been out of the basket. We're talking about unscrambling the egg at this point because many of the documents were supplied through the state, which means they've already been provided through the discovery process.
And then weren't turned over.
As far as the telephone records, I think it's clear that if he makes a phone call and there's a disclaimer saying...
Is the judge stressed out? Look at him. Is the judge stressed out that there's no disputing that the state is already aware of something that was not turned over to one party through discovery? Watch the judge.
As far as the telephone records, I think it's clear that if he makes a phone call and there's a disclaimer saying this call is being recorded, it is subject to being reviewed, there is no attorney-client privilege. And the Eighth Circuit case of Hatcher is squarely on point, dealing with a co-defendant whose records were not provided upon request, and the Eighth Circuit found that was error. Now, in reversing it, the two things occurred. One was the court was very critical because in order to determine whether they're relevant, in fact, this court's got to review them. You can't say it's not relevant unless you look at the records. You can't say it's attorney-client unless you review the records. So I think on its surface, there's no privilege, and certainly the documents we have requested are either relevant or they could lead to relevant information, and the information has already been provided through the state. So, Your Honor, we'd ask that the motion be denied.
And
read the material previously today.
I did want to say one thing, just in full candor with the court. Okay. Well, I just wanted to disclose I had listened to some of the tapes before they filed stuff.
Motion to quash hereby overruled. I don't see the relevance of medical visits, instant reports, affiliation, and commissary and trust account, but the rest of those items could in fact be relevant. Would it be visitation record, transportation, away from the facility, and audio recording? And I'm constrained to admit that I started out thinking we had attorney-client privilege. After reading your Hatcher case, you convinced me otherwise.
Your Honor, I would like to, those documents that that we already have that have been produced, we'd like to file them under seal for the record.
Okay. All right, but you'll be given, in their motion to quash, you'll be given items 4, 5, and 6. Okay?
Thank you, Your Honor.
That takes care of John Dillon, everything.
All right, so quick summary there. The court, especially because he just heard the cite for that Jim Simmons gave, it seems like he was going to quash all of the requests, but he says he's only going to quash the medical and commissary records. And he might have said one more thing there, but he is going to allow Zachary Adams' counsel access to look at, the transportation records and those audio recordings. So that was really quiet. And I have the boost up. The court turned their volume down and we are all the way boosted. So.
Yes, Your Honor. Let's take about 5 minutes, and that way we can get him transported, and then I'll take up the rest of the back out.
I can turn my mic down if you guys think I should turn my mic down. I think they lowered the whole volume.
All right, other potential motions. The state has filed some notices, one under 609 for possible convictions of the defendant for purposes of impeachment. It would be premature at this time to rule upon that. I've looked at it, and in all candor, the majority of what they have filed, the court's not prone to be allowed in for purposes of impeachment. There are some felonies that are less than 10 years of age that in all likelihood the court would let in with appropriate instruction. State's got a 404B motion as well as 12D. And it would be premature at this time because I don't know what the proof will actually show. So I cannot weigh those matters and determine what might or might not be admissible in the trial of this cause. So that will be reserved to be ruled upon at trial. As soon as I can give you an inclination, I think it's fair to both sides to let them know kind of what I'm thinking and then be open to discussion on either side. The state supplemented their expert disclosure. I've read through that. There are 2 forensic anthropologists that they have given a full curriculum vitae on, and The court's looked at that, and I anticipate that they will be qualified and allowed to give expert testimony in this case based upon that.
Forensic anthropologist, June 23rd.
The state has filed certain motions in limine, and likewise, they are premature at this particular time, subject to them being made relevant at the trial of the cause concerning testimony of various people, and court will not be allowing opinion evidence from the people that they have listed on that. Opinions can only be expressed by experts, and there wasn't anything that indicated that they were being offered as expert witnesses, so we're still a little bit premature on that as well. State has also given notice of immunity agreements and listed the people that that they have made immunity agreements with. There's some 5 in number, but you folks have that.
Read it out
And I would
loud.
assume actually have copies of the agreements.
Read the names.
You don't know if they do?
If they don't have copies, we have copies.
Okay, that will be made available. It's
You don't
appropriate
know if they have
you'd be
copies?
able to consider that in the defense of your client. What else do we have today? Yes, she just reminded me this. This goes without saying. I've got professionals on board. Prior to seeking to introduce anything, 404-609, we'll have bench conferences. I've also discussed with the press, the press that will be pooling to the others, that bench conferences, no mic. During breaks, no mic. I told them I don't want it being broadcast on TV how bad my golf game is right now because we're on recess. So it will be dead mics during recesses, also dead mics during any bench conference. Bench conferences should be reserved only critical or necessary because it's very difficult to get up here, and I don't want to risk the jury overhearing something. It's not a long distance away, but at the same time, I don't like marching them in and out a multitude of times. So that should be reserved basically just critical situations. Is there anything else? And as I said, we're slightly over 2 weeks from trial.
Your Honor, at this point, I foresee us, or I guess at this time, I'd like to make an oral motion for a continuance. I recognize the court's been very clear that it intends to try this case when it's already been set, but there is a gun that the state has now, I guess, after 6 years, they've dug up a gun somewhere that it's my understanding they're going to say the gun is going to be.
And my
the
understanding
murder
is
weapon.
that as soon as they got that, you were forwarded this information.
Well, we were forwarded a picture of the gun and told what the caliber was. We don't have any reports on it. We haven't been able to inspect it. We are anticipating that we're going to want to try to get an expert after we get, if they're having the gun tested at a lab, we anticipate that we're going to want to try to get an expert. We've contacted, or we've gotten some names of some experts that we're planning to try to contact. But at this point, we don't have the gun and we haven't had an opportunity to inspect it. And so I think because that's going to be such an important factor now in this case, it's my understanding they've only had it since about Memorial Day. So, but all we've received are 3 pictures of the gun and an email telling us what the caliber is. We don't know what the serial number is or what the make and model of the gun is, and I think all that's going to be very important.
They'll furnish that information. You can move to exclude if you feel it's appropriate. Motion to continue is overruled.
And
Yes.
they also say that they're welcome to come and look at it anytime they allow. Nobody's made the request. The day we found the gun, the information was
I saw the picture. Somebody, I think she sent them to me, or you did, or someone.
I had actually notified the defense counsel before that.
Okay. So motion continues overruled. As I said, I want to be available essentially between now and trial to keep problems from arising. I will tell you, I can make the following dates available next week. Monday afternoon, probably 2 o'clock or after. I've got a jury trial in Benton on Tuesday, which I will continue in deference to this case if there's something that we need to, I want to avoid any disputes. So I'm saying I can take up discovery matters, whatever we need to do. Not available next Wednesday. I can be available next Thursday or Friday. The following week, I can be available July 3rd, and then after that, we're a little close to trial. Potentially, I could be available the 5th. That's the day before we finish our jury selection. I will let the press know there will be no cameras on the 6th. That's pursuant to the rule. We'll be totally involved in jury selection at that time, addressing the issues that have not already been addressed during the individual voir dire of these people. They'll be coming back in on the 6th. I anticipate that when we get the jury selected on that day, that I will excuse them with admonitions to, once again, not view or listen to any news reports or anything else. I will swear the officers that will be guarding the jury that day so that they can report to Pickwick Landing State Park Inn on Monday so that we can start the trial. They'll be sequestered from that point. We'll start the trial promptly at 9 o'clock a.m. on July 10th till its conclusion. I anticipate running from 9 o'clock in the morning, and I could start a lot earlier, but the jury's sequestered. It's impossible to get it much before that. Be running till probably 5 or 5:30 in the evening. Once again, I don't mind going later, and if there's something that we need to take up outside the presence of the jury, perhaps we can do it, but I don't want to mistreat the citizens that are sequestered. I anticipate running 5.5 days a week, Monday through Saturday around lunch. And then I think to push it beyond that, it's going to be grueling like it is, not only for us, but for the jurors. So they'll be given Saturday afternoon and Sunday. Sheriff will do what he can to make it as pleasant as it can be under unpleasant circumstances. So we'll look at that. I also will tell you, I'll take care of it, okay? Hey, I've got this, okay? Lost my train of thought, which becomes more frequent.
The sheriff has been reviewed.
Oh, yeah, thank you. Thank you, both sides. Curry favor with the court. They'll probably, might even get them to open the movie theater. We won't be showing my cousin Vinny to them or anything that's related to the courtroom. I don't know, that might be something good to show to them, but they will host them. Oh, I know what I was going to say. I got a call from one of our jurors who is pre-qualified that presents a reasonably good hardship reason. I'm not going to discuss the name here, but I will make the parties aware of that. As a matter of fact, the gentleman I thought would be an excellent juror, but his employment probably would suffer hardship. So I'll let the parties know further about that. Also, I did let the parties know we had one of our prospective jurors that moved out of the state. She has been released. I thought she would make an excellent juror, but she has moved to on the coast, maybe Florida.
Florida, I think. But I let the parties know before I released them. In other words, I'm not going to do anything at this point without full knowledge of the parties. All right. Anything further from the state?
Your Honor made reference to the motion to eliminate, even though you said that the 404B and the 609 you were going to wait until trial. I guess I would also ask that, and you admonish both sides not to bring up any of those items without discussing it. I'd ask that the same be with respect to the things listed in the motion to eliminate.
I think it's appropriate. There doesn't need to be any mention unless I determine that someone's going to give testimony or not give testimony. And there's some fairly, I think it was filed under seal because there's some fairly sensitive matters there. And I earlier have discussed that I don't want any disclosure of these sensitive matters without permission of the court.
Yes, sir.
All right, anything else from the state?
No, sir.
Anything
I
further?
had some questions about the arrangement of the courtroom. I don't know if the court wants us to take that up now or just in private.
Just general?
Well, one of it is, my team has a lot of laptops and computers. We might even be bringing a big computer. I would prefer, is there any way we could just tilt this at a right angle so people in the gallery cannot?
Let me do this. Let's recess. This isn't critical, so your client doesn't have to be here. Let's let the press get gone, and we'll have informal discussions. I want the sheriff to remain with me. He'll be here. You'll find that the sheriff, as well as the clerk's office, is very, very accommodating. So we'll do what we can to accommodate, okay? All right. Anything else?
No, Your Honor.
All right. Let's recess for 15 minutes, and then we'll address this informally.
All right, so they're just going to show the gallery clearing, but I think there's something critical being not stated, but something being indicated about this timeline again. I know I keep going back to this timeline, and it keeps getting longer. I can't zoom on this? Okay, well, I'm going to read it out. It's really tiny. I'll have to reformat this. Oh, can I do this? Usually I can scroll with my mouse, but I have to press a button for this. All right, so I'm going to hammer home the same thing. We learned today that in February, well, that was the first. I don't know why I put 2 here. I'll have to correct that. Matt Scholl, attorney for Jason Autry, acknowledges that he called the judge sometime before that hearing. So sometime prior to February 1st of 2017, Matt Scholl is telling the state, and he says this was with the state, telling the judge with the state's knowledge that they wouldn't need a trial date for Jason Autry. Around this time, I don't know how to pinpoint the date, but they're going to start doing these test drives with Jason Autry to recreate the routes. We have that May 8th, 2017 proffer session. Now, there's been a lot of conversation about this, and I either need to go back and listen to Doug Bates' questions on this proffer session and questions about the revolver. But look at what we're adding to the timeline now. May 29th is when the defense says they were notified about the gun being found. Which, in logical order, one might conclude they found the gun on Memorial Day. But what that doesn't explain is how between May 18th and May 19th, the 2 days that Brent Booth is talking to Dinsmore, and then he goes back on the second day to say, hey, just want to clarify I didn't put words in your mouth. He's really pushing on there needing to be a mention of a revolver, which would suggest to me that something that Nichols garnered during this proffer session and what Brent Booth obtained about a possible sale or trade of a gun that Shayne Austin might have been carrying on the 18th wasn't matching information that was garnered on the 8th. So on May 19th, it seems like Booth has to go back and correct the record on not just the truck parking issue, but also I really need you to say that it was this revolver. And then they disclosed to the state that there was something, they found a gun. The defense, they don't disclose that until May 29th. But I'm not buying the jump in time from the May 8th through the May 29th, because why else when we know there was a conversation between Jennifer Nichols and Brent Booth between these two meetings, even though Brent Booth is saying, nope, I didn't know anything about that proffer session. I have no information about what Jason Autry may have said during that proffer session. Did he go back and need to scrutinize and fine-tune and have Dinsmore hunker down on the firearms question? And then we get a report generated June 12th, right before this hearing, for that May 8th meeting. I don't know. My antenna is going off again. Let's get back over here. Every time I share that timeline, I don't know if it's something with the app. Let me unshare this. All right, that way we don't run into like a sound sharing issue when we get back. Let's see. We'll back out of this. And then the next video is just the news covering what happened at this hearing.
Final stage of
To any other.
Sorry, I did that weird jumping thing.
Final stage of jury selection gets started tomorrow for the Holly Bobo murder case. And those chosen appear headed for trial. As News Channel 5's Nick Beres tells us, defendant Zach Adams rejected plea offers. And
All right, so this is July 5th that this news story was published. So like 2 weeks after this other hearing, they're supposed to start jury selection. Plea deals are falling apart.
appear headed for trial. As News Channel 5's Nick Beres tells us, defendant Zach Adams rejected plea offers, and there are now questions about the quality of the evidence against him.
One of the big questions going into the trial is, what's the quality of the evidence here at the TBI? Is it mostly circumstantial, or is there some physical or DNA evidence?
I do not believe, from my understanding at this time, that there's any DNA evidence or any direct evidence.
If that indeed is the case, then News Channel 5 legal analyst Nick Leonardo says prosecutors will depend primarily on witness testimony to prove that Zach Adams kidnapped, raped, and murdered Holly Bobo. So far, 5 individuals have been granted immunity or plea deals to take the stand against Adams, but all will likely have their own credibility issues.
It's really going to come down to credibility and what the jury believed.
If convicted, Adams faces the death penalty, but questions about the quality of the evidence against him is likely one reason Adams has chosen not to accept a plea deal for life in prison. For the moment, he's set for trial. The issue now is selecting the jury in a very high-profile case.
This is a death penalty case, and so they have to get a death-qualified jury, which means that these jurors have to be willing to impose the death penalty. Not necessarily agree that that's going to be the outcome, but willing to have an open mind and entertain that as a possible punishment.
Leonardo believes a jury will be ready to go by the weekend, and despite rumors of settlement talks, the trial is expected to begin Monday. The bottom line at this point, just days before the trial is to begin, no indication that there will be any plea deal. Nick Beres, News Channel 5.
All right, Nick, thanks. And a reminder, we will provide gavel-to-gavel coverage of the entire trial. We will have reports tomorrow from Hardin County, and the two Nicks will begin our coverage beginning Monday morning on News Channel 5 Plus and streaming live on newschannel5.com. Disbelief and despair tonight in...
Oh yeah, let's check the date. I keep forgetting to check the date every time. All right, this is the next day, July 6th. This is what they're covering.
An unbelievable turn of events. The Holly Bobo murder trial has been delayed again. This comes on the same day that jurors had been brought in for jury selection. News Channel 5's Chris Conti has the new developments from Hardin County.
This was a complete shock to everyone involved here today, to Holly's parents, to jurors, to prosecutors, to defense attorneys, even the judge. No one wanted this case delayed once again, but there was no choice simply because of a gun that was recently found.
A disappointing day.
Time has never looked favorably upon what happened to Holly Bobo, so perhaps today should have come as no surprise to anyone involved. But inside the Hardin County Courthouse, you could hear an audible gasp as the judge told 70 potential jurors, Holly's family, and the man accused of killing her, Zach Adams, that the case would once again be delayed.
So it was something that we all feared could happen.
The trial was supposed to begin in just 3 days, but 2 months ago, investigators apparently found a gun along the side of the road.
2 months ago, and I know when you say things like that, it's a ballpark, but I would not, because Memorial Day was May 29th in 2017. This is published July 6th. I would not say 2 months ago to mean the end of May, at the very beginning of July. I have questions.
Underwater. That evidence is apparently crucial to the state's case against Zach Adams. Defense attorneys argued they needed time to analyze the gun. The judge had no choice but to delay the case to September.
Karen, you guys want to say anything?
For the first time in what seemed like years, Holly's mom sat in the courtroom and cried. Days away from potentially learning what happened to her daughter, time has once again robbed her of that chance.
It's been over 6 years, and every minute of it, every hour of it's been, painful. So to know there's 2 more months of it is hard, but it's necessary. And
so the wait will continue.
We'll be here in September, ready to try the case.
So what happens next here? The judge wants to keep the jury pool intact, so those 70 people will be recalled in the next 2 months. A new trial date has been set for September the 11th. But the way things have been going, it's anyone's guess as to whether or not it will actually start then. In Savannah this evening, Chris Conti, News Channel 5.
Chris, thank you. As for the gun found by investigators, it's still unclear how it is connected to Holly's death or where exactly it was found.
Dramatic new details unfolding in the Holly Bobo murder case.
We now know more about the gun investigators.
All right, this looks like it's probably around the same time, but let's see. July 10th, so this is a few days after the other video.
Think was used to kill the nursing student, and we know at least 2 of her family members will be called to testify.
News Channel 5's Chris Conti spent the day digging through the documents, and Chris, the potential jury could be in jeopardy here.
Well, Vicki, according to defense attorneys, 97% of potential jurors have heard of or discussed the Holly Bobo case. Zach Adams' attorneys so concerned they've asked for another change of venue. But the most stunning revelation today, the state believes they now have the weapon used to kill Holly Bobo.
97%.
Today, of all days, was supposed to be the day 15 jurors would file into the Hardin County Courthouse to hear the case of Zach Adams. Instead, though, we got a glimpse at what's to come. Court documents reveal that state prosecutors believe a recently discovered gun is the murder weapon used to kill Holly Bobo all those years ago, calling it a, quote, critical piece of evidence.
So right there, the document's referring to an Arminius model HW5 32 S&W long revolver with the serial number 2494755. So, and this is from the defense motion to exclude.
The gun is similar to this, an Arminius model 32 caliber Smith & Wesson long revolver. It's still unclear where the gun was found, but its cartridges have been tested for blood. As for that immunity agreement given to Jason Autry, who's also accused of killing Holly Bobo, we now know the state is considering reducing his charges in return for, quote, truthful testimony during Zach Adams' trial. Defense attorneys have also asked for all rape charges to be dropped because, quote, it is undisputed that no evidence regarding the alleged rape of Miss Bobo will be presented to the jury. And as for the jury, potential major flaws exist. Defense attorneys want another change of venue, saying many potential jurors in Hardin County sincerely believe Zach Adams is guilty. We know defense attorneys believe 61 of 70 potential jurors have potential conflicts or knowledge of the case. One person in the jury pool even had a Pray for Holly picture on her Facebook account. There was also this strange piece of evidence. Attorneys want to bar witnesses from referring to the discovery of Holly's remains as divine intervention. This trial of the decade may be delayed, but it is becoming clearer what we should expect. And tonight we know that Holly's mom and dad have been subpoenaed to testify, as well as Zach Adams' grandfather. Barring any major developments, this trial is now set to get underway on September 11th. Rory.
Chris.
Disheartening.
All right, so before we get into this, looks like community call-in. Just going to quickly pull up. So this is circled. This graphic is from the Trial and Error podcast. Again, following this firearm evolution, they've done a great job. Ignore what's circled here. Ignore what's circled here. What we're talking about now, what was just introduced, would be 0.312 inches if we consider after it's ejected from the casing, the diameter, right? So we're talking about this 32 S&W long revolver. And let me back up. No casing would be ejected because this would be a revolver. But this would be the diameter. 0.312. And with Holly Bobo's skull, the defect was, what, 0.35, 0.36, which would fit closer to something like what the defense is arguing is more likely. The 380 auto casing found next to Holly's skull, which, if you take away the casing, which a revolver could not eject, it would be more close fit to the 0.36-inch diameter wound in Holly's skull because it would measure 0.355 inches diameter. But this is what the state has at this point in time, and the defense hasn't been able to do any type of examination on this. And we heard Jerry Gonzalez say, look, that was a hot mess going into this trial. Not being able to properly examine, what was his name? It wasn't Ross, was it? Whatever, like the medical expert that was starting to opine on like the ballistics. Jerry Gonzalez tried to do some cross-examination, but it wasn't thorough, it wasn't fully fleshed out, and then they don't call an expert that's able to get into the stuff to confront the state on their claims. And then in closing, Jennifer Nichols leans into the fact that the 380 casing was excluded. Rossi. Okay. Thank you. Thank you. Oh, man. Let's get back over here. And again, that's in July that the defense is now able to file this motion to exclude. And they're getting it identified, you know, this make and model. But they still didn't have the serial number during the hearing that we watched at the end of June. So this will now be July 11th. And this is a different news station. So this now is over at Channel 3.
7 years feels even longer now for the family of Holly Bobo. First, the trial that was supposed to start this week was delayed. And now news of immunity for 4 people.
Family was not knowledgeable beforehand on who would receive the immunity. I can just only imagine the gut-wrenching, just slap in the face that has to feel.
We went to the Hardin County Courthouse today to examine these new documents. They show suspect Jason Autry is receiving federal immunity in exchange.
Saying Jason Autry, but this is saying Jason Kilzer. The state incorporates its notice filed on June 22nd. So this is a supplement. Notice of Jason Kilzer. Information regarding Mr. Kilzer was provided to the defense counsel several months ago. Well, that's interesting because in my timeline, where the Kilzers actually become relevant was January 2014. And Zach was already arrested and then indicted and arraigned by March of 2014. So why are they only disclosing information about Jason Kilzer on the eve of trial? It continues to say the state provided notice of a federal immunity agreement with Jason Wayne Autry. The state does not have an immunity agreement with Mr. Autry. So they're saying we don't have that agreement. That's why I keep harping on the jury instruction, the charge conference that we got to read the transcripts of this morning. They do not want this to have ink dried on paper by the time the trial starts. The state and counsel for Mr. Autry agreed to discuss reduced charges against Mr. Autry after the trial against defendant and Mr. Autry's truthful testimony period probably ends right there. And then it's signed by Jennifer Nichols.
For testifying. But the state has only promised to consider reducing his charges, which include murder. They also show the state has promised immunity to 3 men, Victor Dinsmore, Michael Alexander, and Jason Kilzer. Decatur County officials tell us all of these men have extensive criminal backgrounds. A friend of the family tells us there have always been rumors about how these men were involved.
So now that all this is coming out, it's kind of like, okay, we need to go back and re-look at things, re-evaluate stuff, and figure out what these guys' roles are.
And although the documents don't say how the men are involved, they do talk about.
I'm assuming Ricky Alexander, who's speaking, is not related to the Michael Alexander on the one of 4 of the immunity recipients. And it's also because Shayne Austin's still listed there. So Victor Dinsmore, Jason Wayne Autry, Michael Alexander, and then Shayne Austin. Didn't they say 5? Or maybe that means Dylan Adams and they didn't want to list it out on this supplement?
The reason the trial was delayed. A gun discovered in an undisclosed location in May. Documents show it's an S&W long revolver, and the defense believes the state will introduce it as the murder weapon.
The gun coming out, it kind of caught every single person off guard. We didn't have any idea this was coming out. Trying to get to the end of it.
Double talk and deception. Tonight, there's trouble for the key witness in the upcoming Holly Bobo murder trial.
Co-defendant Jason Autry cut a deal to testify against Zach Adams, but will anyone believe him? He may have tipped prosecutors to the location of an alleged murder weapon, but in this exclusive story, News Channel 5's Nick Beres tells us it won't be hard to prove Autry is a liar.
I spoke with Jason Autry from his jail cell there in Riverbend Maximum Security Prison 3 years ago. And I think it's safe to say what he told me then is very different from what he's told prosecutors.
No, sir. Right hand before God, and the Father, and the Son, and the Holy Ghost, I didn't bother that girl. No form, no fashion.
Do you know who did?
No, sir.
Jason Autry is one of 3 defendants charged with the kidnapping, rape, and murder of Holly Bobo. Then there's the Adams brothers, Zach and Dylan. If convicted, all 3 could face the death penalty. Zach will stand trial first in September. Autry cut a deal with prosecutors to testify against him.
His testimony is extremely important.
News Channel 5 legal analyst Nick Leonardo believes Autry is the one who only last month tipped prosecutors to the location of the alleged murder weapon.
Mr. Autry had to be the one to divulge to the Tennessee Bureau of Investigation the whereabouts of this firearm.
But is the weapon the real deal or simply a false distraction? It's hard to know what to believe with Autry. He told me he had nothing to do with Bobo's death.
Honestly, I don't want to speculate and make a rumor of what happened to the girl.
And at the time, Autry said he refused offers from the TBI during several visits at the prison to turn on his friend.
It was trying to be a forced move to get me to bear false witness against Zach Adams.
And it begs the question, are you simply doing this to get consideration for yourself?
You know, there is a death row here at Riverbend Maximum Security Prison, and some believe Autry will say anything to keep himself off it. In Nashville, Nick Beres, News Channel 5.
Thanks, Nick. The Holly Bobo murder trial is set to begin on September 11th. Meanwhile, Holly Bobo's cousin, Whitney Duncan, a Nashville singer-songwriter and former Survivor contestant, has released a new song in her memory. Duncan posted it on her band Post Monroe's Facebook page saying, quote, "I didn't get the chance to say goodbye to Holly or have a final conversation with her, so this song is my way of filling her in on everything since she's been gone." Take a listen.
All right, we're going to jump that. All right, next video takes us.
Bobo case today, we now know that prosecutors will argue the missing nursing student was shot after being abducted nearly 7 years ago. News Channel 5's Chris Conti in Hardin County tonight with what this means for the case.
It has always been the unanswerable question with this case. How did Holly die? And from prosecutors today, we started to get an indication that they believe she was shot. They said that an expert will likely testify a defect in Holly's skull is an indication that there was a bullet hole, although it's not clear if that's exactly the cause of death here.
And went for months with no response from Ms. Thompson or her team saying, "That's not true."
That intense moment came as the defense and prosecutors sparred over evidence that was found at Holly Bobo's home a few years ago. It has to do with a shoe print that the defense says they haven't been given that is in some of the evidence case here. Zach Adams was here for this entire thing today, sitting in the front of the courtroom with a black suit on. Holly's family, of course, as they have been, was sitting in the front row. There was also some questions about whether or not people should be allowed to sport those pink and green ribbons that have become so synonymous with this case. The judge here said that he simply wouldn't allow anyone to have Justice for Holly bumper stickers on their cars outside of the courthouse here. And he once again said that this trial will not be delayed.
You folks have been living with this case for 2 years plus, so you ought to be able to have your thoughts and your directions fairly concise so that we can stay on focus.
So, if everything goes according to plan, the potential jury pool will be brought in here on Saturday, September the 9th, the weekend after Labor Day. The jury will then be chosen over the course of that weekend, and this trial is set to get underway on Monday, September the 11th. In Hardin County tonight, Chris Conti, News Channel 5.
Chris, thank you. We still do not know if Zach Adams plans to take the stand in his own defense. His trial is expected to last at least 2 weeks.
All right, so calling a quick switcheroo now that we have mention of the boot print. So if you missed that, we saw like that little clip of bickering in court with Jennifer Thompson saying that's not true. And the discussion was relating to, they never turned over the picture of the boot print, the shoe print that was found in the court report that didn't belong to Clint Bobo. Defense didn't have access to that. If you missed it at this weekend or last week, I forget exactly when, Trial and Error podcast uploaded, it's Dana explaining the Terry Britt shenanigans. I don't even have a way to describe it. But there's a still from it with stuff that have not seen before. So we've seen this picture of Holly Bobo where she's circled, and, this was found in like the shed at the Britt's property. We also know there were burner phones, but we're seeing like this bag here. There's burner phones, more phones. We have hard drives just sitting loose in the house. We have search history, and can't zoom in on this, but it is the content, like the different types of grape pornography, browser history here. We have a JVC video camera bag, which might not be innocuous in and of itself. The computers, weird thing with toilet paper and nuts, and then boots circled here. So I'm very curious about this boot print that the defense was asking about in August. A month away from trial, a month and 2 days away from the trial start date, August 9th. Defense still doesn't have stuff turned over like the photo of a boot print from the carport that doesn't belong to a family member. And they can't analyze it. What if we wanted to compare it to what's sitting here circled, the boots? Anyway, it was a great breakdown by Dana. So if you guys haven't already checked it out, I highly recommend it. They also have a nice little funny montage of Amy Wyrick and Jennifer Nichols that I think you guys will just enjoy. But yeah. The next one, moving into the next video. Let's see.
There is nothing.
We've got September 4th, 2017.
To link the gun to the murder of Holly Bobo.
Oh.
That's just part of what we've learned about evidence in the high-profile murder case. Tonight, News Channel 5's Nick Beres also learned plea talks have stalled, and barring any new bizarre twists, the case will finally go to trial 1 week from today.
6+ years of evidence, interviews, paperwork, an entire room full of it here at the TBI headquarters from their investigation into the murder of Holly Bobo. By now, attorneys on both sides of this case have reviewed that material. The question is, will any of it convict Zach Adams?
The state has been very clear in discussions with me that there is no DNA that links Holly Bobo to Zachary Adams.
The TBI did recover Bobo's remains, but in February, Adams' attorney Jennifer Thompson said that forensic testing came up empty.
So there's no DNA that matches.
The state's told you that.
The state has told me that, and I feel comfortable that that's accurate.
But since then, prosecutors produced a gun, an Airmanus Model 32 caliber long revolver similar to this one. They also indicated there appears to be a bullet wound to Bobo's skull.
So is it the murder weapon? Did it belong to Adams? Sources tell News Channel 5 the gun was badly rusted. No DNA or fingerprints were recovered, and there's no way to do a ballistics test to link it to the bullet wound. So what will the prosecution have at trial?
At this point, it appears as though it may very well be a circumstantial case. There's no direct evidence linking Mr. Adams to the murder of Ms. Bobo.
But News Channel 5 legal analyst Nick Leonardo says that doesn't mean you can't get a conviction for first-degree murder.
The state is going to tout, yes, we don't have DNA, but we do have witnesses.
Prosecutors already granted co-defendant Jason Autry and 4 others limited immunity to testify against Adams. Will it be enough? Thompson says there is not the evidence to convict, and her client never considered a plea deal.
He's maintained his innocence, yes.
While the evidence to convict may be unclear, the defense is worried about the jury. In fact, they have asked for another change of venue, arguing that the jury pool in Hardin County has already decided that Zach Adams is guilty. We'll see. Nick Beres, News Channel 5.
There will be one final motions hearing this Friday. If there are no further delays, jury selection will begin Saturday with the trial to begin on Monday. And of course, we will provide gavel-to-gavel coverage live on News Channel 5 Plus and also streaming on newschannel5.com.
I'm not going to talk about.
All right, so this is now after sentencing. So trial happens, and we've watched this, but we'll speed it up because we've already watched it. But let's listen to this now that we've done a dive all the way back through the pretrial coverage and the timelines. Let's re-listen to Nichols, and Paul's going to speak a little bit after sentencing. Remember, they do address, yeah, he was facing the death penalty, but we came to an agreement before having the jury start that mini trial for the penalty phase. And also, Sheriff Chuck, W's in the chat for Sheriff Chuck. Thank you again. That is 1 million memberships by now. So thank you, Sheriff Chuck, the elf of the chat, growing the gang. Hoping more people come in here and pay attention to this case and the craziness that's going on. Thank you, thank you.
The plea negotiations and who started it. I think you heard Karen say on the stand that with reluctance she accepted this, and y'all can read between the lines on that. So it's probably the best way to do it.
What do you think was, I mean, you've obviously worried about any case, but I mean, was it the 10 different witnesses from the 10 different places? What did you think was kind of your star element for that jury that just pushed it over?
I mean, and the rest may disagree with me. I don't think it was any one witness. I mean, yes, the 10 that he made statements to, and the 2 or 3 that he had actually made broader confessions to, that you guys heard from, were important. The co-defendant was important. The corroboration of the co-defendant's statement was very important because they were small pieces. They were small pieces that, couldn't be dreamt up. I think this was truly a case where it took putting all of that together to get the, full picture. I don't know if y'all disagree. I think it was everything.
Well, you look emotional. I mean, can you explain?
Who couldn't be? 6 hard years for her and for Dana and the rest of the family. Her daughter, Holly, and we heard testimony. She was shown absolutely no grace by these defendants.
I think we need
They
to
had chance
look
and
at the
chance
transcript real quick.
to let her live. Absolutely no grace. But at the end of the 6 years, at the end of the Zach Adams story, Holly's family, Karen and Dana, they chose to end this thing with grace. And is emotional, is powerful. I think it's the best end to this terrible thing.
Nobody has ever seen this idea of, to see you with a hostile U.S. Marshal witness or a TBI agent. This is unprecedented. Even the judge had you had to deal with this misled investigation, and then you said that this second investigation is on the money. I mean, what was that like, having to kind of like disqualify and yet give credibility at the same time to the same agency?
Well, I came in 3 years ago. So when I came in, the stage was already set. And so it is certainly a very different than the norm, coming in after things have been in place and different agencies have done different things.
We got to hear that again. I don't know if I paid attention to that the first time we watched this.
And so it is certainly a very different than the norm, coming in after things have been in place and different agencies have done different things. And I don't think it was, you used the word discrediting an agency. I never felt like it was discrediting an agency, because the agency was working all along. I think that Mr. Hagerman started in an opening statement saying about missteps and mistakes, and then Special Agent Booth talked about missteps and misdirection. And then you heard from Jack Van Hooser, who came in with a fresh set of eyes and was able to put his finger on where the missteps were and where to go from there. No question, it was different, because that doesn't usually happen on cross-examination. But I think the jury understood what had happened, and it's pretty clear by their verdict, what they believed. And you saw that. Did you?
I think what got us through that, I mean, like you said, you saw us confront officer, marshal, whatever it is. I think what got us through that is our job in this case, from the second she got involved and from every second we spent on it, is just to do what is right. Just to do what is right. And if that means standing up or asking certain questions or whatever else it is, you just do what's right.
If it meant challenging those who normally might not be challenged, that was part of it in this case. And it meant, because of the 6.5 years, it meant taking an enormous amount of material, just an indescribable amount of material, and figuring out from that what we actually needed to make a case to present a case against Zachary Adams, because that was what our job was the last 2 weeks, was the Zachary Adams case.
Yeah, if you could just follow up on that discovery error, because there were 3 things you said, like in the jury room, that people's mouths dropped open. One was that alibis weren't checked, which, you could hear in the casket here. Shayne Austin was cleared because he didn't have a car, so of course he couldn't do it. And then the third thing, that there was a prevailing theory that it could only be one person.
Be one person, yes.
Astounding.
Right.
The public is just, what are we supposed to do? It's astounding.
It was. And in the end, as astounding as all of those things are, truth prevailed. And the jury, one after the other, resounding guilty on all counts, not a hesitation exhibited on any of their parts. So I say that to be, yes, it was pretty astonishing, but in the end, truth dominated all of that. And the Bobos were able to sit here.
Then why were you mentioning the pink panties 5 times throughout the trial when they had nothing to do with Holly?
Today and make the decision themselves for the first time in 6.5 years. From when Dana went to work that morning and from when Karen went to work that morning, yesterday is probably the first time they've been in control of their family's destiny, their family's desires and wishes, and what was going to be best for them going forward. And that's probably why she said she saw Dana Bobo smile for the first time. And I'll tell you, I'd never seen him smile. Not one time. I didn't know the man had dimples until yesterday. And I was like, Dana Bobo.
So quick interlude. We're going to read these trial transcripts one of these days. But I saw this part earlier because, sneaking around, jumping around the documents. And they're discussing this issue about the duty to preserve evidence. There's been no evidence that the state has failed to gather, preserve evidence. They're talking about jury instructions. The court, the only reason, and it's very collateral and peripheral, was, and then Miss Jones steps in and says, Dana. Judge says, Dana. I was trying to think of the daddy's name. Said he had put up the purple tape. General Nichols, that wasn't the preservation of evidence. People were already around. Yes, Jennifer Nichols, that's the problem. But Judge can't even remember, even though he's hanging out with the family in the gallery and knows Karen Bobo, can't remember Dana's name. The court says, take that out. Jennifer Nichols says, he simply, Judge McGinley says, y'all can argue the scene was contaminated. There's no evidence. And then General Nichols says, I think it was. Miss Thompson, what about the sock in Shayne Austin's trailer? General Nichols, what evidence is that other than he masturbated? Miss Thompson, well, you all raised that question, that it might have been something else. And then, so look at how even in these trial transcripts versus what we're seeing, talking about the truth in these press conference hearings, you have Jennifer Nichols out here arguing about jury instructions acknowledging that the sock was a big nothing burger, even though the state is the one that wanted to make an issue of it and think it was some damning evidence, because they're also going to talk about the pink panties found on the road in front of where Shayne Austin's trailer is. Like, so yeah, I can't wait to actually go in and read these, because it just seems ridiculous. Just ridiculous. And then look at this freeze frame on this face. Look at this freeze. Let's take a screenshot. Let's take a screenshot.
You know, the jury did that. I mean, this is an incredible county, and these people, I think, worked hard the whole time, just paying attention and working through this. Just kudos to them.
Follow up on Dennis's question. Do you feel like you lost a lot of physical evidence that could have been gathered had the TBI followed what they should have?
You know, I don't want to talk about, the evidence in particular, because we do have, we have 2 more defendants. And, those are different cases against, different individuals that we have to work through. I will say, generally speaking, common sense tells you that if you learn something 6.5 years after the fact, for instance, it's been out there about finding the gun, and I got to say, there were some people digging that you'd be surprised that knew how to hold a shovel.
So why is she volunteering? When people blather on and they start thinking about the things that are their top of mind, this question didn't involve specifics about finding the gun. Did they?
On Dennis's question, do you feel like you lost a lot of physical evidence that could have been gathered had the TBI followed what they should have?
I don't want to talk about, the evidence in particular, because we do have, we have 2 more defendants. And, those are different cases against, different individuals that we have to work through. I will say, generally speaking, common sense tells you that if you learn something 6.5 years after the fact, for instance, it's been out there about finding the gun, and I got to say, there were some people digging that you'd be surprised that knew how to hold a shovel. But the point is, like, you find it sometimes, and sometimes you don't. And so, say that with the general terms in terms of, what we might have lost or whatnot.
Can you talk about Jason Locke at all? I mean, he goes from being essentially your star witness, and now you have to turn around and prosecute him. He's got to be.
Yeah, I'm really not going to talk about those that are still pending.
Can you just talk about the process?
The process, yes, it's set in November for a status date, which gives us over a month to get with their attorneys and talk to their attorneys and figure out what the game plan is. A lot of that, of course, depends on them. So.
What worried you? What woke you up in the middle of the night about this case?
Well, what didn't?
You assume we went to sleep?
Yeah, I'm like, yeah. For me, and everybody may have a different opinion. For me, it was what I talked about earlier, just the sheer mountains of material, much of it not relevant, but still collected, much of it important, and trying to come up with the best way to present what happened to the jury. A lot of times that's not a problem. You think about it, most cases you guys cover, you got 10 or 15 witnesses, you got 5 witnesses, 6 witnesses, you put them on and you're done. And this was totally different. This was trying to figure out the different pieces and dealing with a lot of people that were locked up in different locations and finding them and following up with them. It was quite.
And making sure they knew in advance what would be testified to at trial by somebody else. Maybe. We're not going to say that part, though.
A task.
You met with the jurors.
Actually, very briefly, yes.
Talk about that.
I just took the Bobos up there to meet them and thanked them myself, and then left the room. So they.
Did you leave the Bobos with the jurors?
Can you discuss at all what aggregating factors you were prepared to argue in this case to seek the death penalty?
It's filed in the file. When we filed the death notice 2 years ago, it's in there. That's public record.
Any specific ones that you were going to stress more than others?
No, all 3 of them. I mean, there was 3 of them, and they're in the file.
When the jurors asked the second question about circumstantial, what was your feeling at that time?
I was fine with it. I really was.
It was a good sign to you?
We'd had another question before then that didn't worry us, and I think in light of the first question, I think we were. I thought their questions were smart questions and thoughtful questions.
What was the first question?
I don't think the judge released it, so you'll have to.
The defense said that they were worried about yesterday when we talked to them. They were worried they prepared back for a guilty plea. Were you guys worried that you would come back the other way?
Always concerned, but I think we all felt like that the witnesses who testified were credible, and most of what every single one of them said was backed up even by something else that was said. So I don't think any of us are ever like quite certain that how something's going to turn out, because that's a pretty bold and brassy place to put yourself in that we don't generally do. But
Never stop worrying.
yeah, I think we all felt like that the proof came in because of the sleepless nights that y'all were talking about, came in the way it needed to.
What happens with Mr. Autry now?
And his case is still pending, so we can't talk about it.
Do you think some of your colleagues, your district attorney colleagues around the state, opine that when the question came in about circumstantial, that juries sometimes are looking for permission to convict because they, even though they know circumstantial, they can rule it, they want to make sure and be told again, yes, exactly, you can use that to prosecute. Did you take it that way? Because other DAs clicked in and messaged people and said, oh, they're asking permission to convict here. Did you feel were you employed by that?
I wasn't worried about the question. I mean, again, I thought it was a smart question. There was certainly circumstantial proof in this case, and then we had direct evidence, in the form of eyewitnesses who heard and saw things that Zach Adams said and did. So I think from certain aspects, circumstantial evidence, played a part. So I don't know whether I started making that leap to, I don't know, I wasn't following what people were saying, but it didn't scare us. This was a good bunch.
Since there was an agreement made on the sentencing, does this mean that he cannot appeal the sentence?
No, it does not mean that. It does not mean that. He can appeal the sentence, but but there was an agreement as to what the sentence was.
Was there an effort to compel him to testify as part of the agreement, saying, we're not going to say the death penalty, but you go up there and confess and tell his family what he did, you scoundrel?
I can't say that there was an effort on the part of, yeah.
Because if there was an appeal, you could use all that, right? If you made a statement.
Anything that was said under oath would certainly be admissible in any appeal.
If the family didn't need to hear from him, they didn't need to hear from him. Karen needed to look at him, and she needed to say what she needed to say. She didn't need to hear from him.
And wasn't she graceful and articulate? And I think anybody watching her saw the teacher come out and look at me, look at me, and then can you scoot back so he can see me? I mean, she wasn't missing a beat. I honestly just think we're all so proud of them and the restraint that they've shown and the just good sense through the course of this trial. So it's good for her to get to do that.
What will you guys all do tonight?
Pack. I don't know. Pretty keyed up right now still.
We'll be sad to leave Savannah tomorrow.
We'll be back.
They've treated us great.
Oh my goodness, they really have. So anyway, anything else? All right, thank you guys.
And now we have
All right, before we do this video, I do want to take a quick hop over to what's going on in Georgia, in DeKalb County. So I think we've talked a lot about the pressure of jails, prisons, with Delphi, with this case, obviously with Fulton County cases. And we've talked a lot about how Georgia prisons just don't seem to have their act together. Well, apparently 3 inmates have escaped from DeKalb County Jail. They found out this morning. So Stevenson Charles, who was charged with murder, and 2 other inmates were discovered missing this morning. So 3 inmates have escaped from the DeKalb County Jail, including 1 charged with murder, and a manhunt is now underway to find them. The DeKalb County Sheriff's Office said in a release that inmates Stevenson Charles, 24, Yusuf Minor, 31, and Naod Yohannes, 25, were discovered missing during Monday morning's routine security check. Charles is in charge with murder and armed robbery. Minor is charged with 2 counts of armed robbery and other counts. Yohannes is charged with simple assault, arson, and other counts. The 3 men may be armed and dangerous, the sheriff's office said. And they're looking for help finding them. So, shout out to Georgia and their never-ending jail saga. It's always something. It's always something. This video here, back over to Holly Bobo. Let's see. I think this was uploaded late. Or what I mean by that is this is from the 2020 episode. And we're not going to play this, but 2020 was highlighting that law enforcement was suspicious of Clint Bobo. The entire 2020 episode is available on the 2020 website. We were able to watch it over in the Discord. Just want to recommend that and put that on the radar. I thought it was interesting ABC News published this after the sentencing, and we hear Jennifer Nichols and Hagerman talk about, oh, the truth, we got the right people. So, next we have, let's see.
Jason Autry is one of 3 men accused of kidnapping and murdering Holly Bobo. In fact, he was the state's...
This is November 14th now. So we heard Jennifer say that, hey, there's going to be a status check in November 2017. That's where we are with this.
Star witness against Zach Adams.
And now he could end up testifying against Zach's brother Dylan as well. So what will he get in return?
News Channel 5's Nick Beres has uncovered exclusive details about a potentially sweet plea deal.
This is different, a bit unusual. The Holly Bobo trial is over. Zach Adams is convicted. There will be an appeal. But now this, the former lead TBI agent on the Holly Bobo case, has filed this brief essentially challenging the truth of what Jason Autry told the jury. You remember Jason Autry.
What was your plan of disposing of Holly's body?
Mr. Gutter. Autry is a co-defendant along with Zach and Dylan Adams in the murder of Holly Bobo. But this past September, he turned to state's evidence to testify in the first trial against Zach Adams.
I do believe that Mr. Autry was the star witness for the prosecution.
I did not kidnap, I did not rape, and I did not kill Miss Bobo. And I did not. But I lied and said that I didn't have no details to it.
At trial, Autry admitted to trying to help Adams dispose of Bobo's body.
And I grabbed the upper torso of Miss Bobo. Zach come around, let the tailgate down. I brought the upper torso to the end of the tailgate.
The jury believed Autry and convicted Adams. So what does Autry get in return for his crucial testimony?
Someone made an allusion to the fact that he might be home in time for Christmas.
News Channel 5 legal analyst Nick Leonardo says such a sweet deal for Autry is possible, but unlikely. Autry's currently serving time on a federal gun charge. Those close to his case say they could flatten the sentence and he could be released inside 5 years.
Nothing would surprise me at this point.
Now, if there was a star witness for the defense, it was Terry Dykes, the former lead TBI agent on the Bobo case. He's never believed the Adams brothers and Autry were involved in the murder. And in a very unusual move, Dykes filed this brief with the court just last week, essentially calling Autry a liar.
The determination I made is that he could not have been involved in the kidnapping.
Dykes argues there are multiple easily proven inconsistencies in Autry's testimony, calling it factually and materially false. Much of that will likely be brought up at Adams' appeal, and it could lead to a new trial. The judge in the Bobo case will review Dykes' brief, but it's highly unlikely he'll take any action, likely leaving everything to the appellate court to decide. As for Jason Autry, well, we will likely find out tomorrow whether or not he'll walk out of jail in time for the holidays. Nick Beres, News Channel 5.
Both Jason Autry and Dylan Adams are scheduled to go before a judge in Hardin County tomorrow. Of course, we will be there and we will let you know what happens.
New tonight, a former insider is raising questions about the hiring practices in...
All right, so this one was a sidebar. This doesn't directly relate to the Holly Bobo case, but it was an issue, controversy going on involving TBI's hiring processes. So this was published on November 20th of 2017. So it's like a little bit of a side story.
Inside Tennessee's top law enforcement agency.
She says if you want to become a TBI special agent, one of the key questions may be, who's your daddy? News Channel 5's chief investigative reporter Phil Williams spent 3 months digging through TBI personnel files looking for evidence.
We're conducting search warrants. We're trying to glean information.
When it comes to the big cases like the abduction and murder of Holly Bobo,
One of the officers fired his weapon.
Or shootings involving local police.
Tell
the street where you get run over.
Or cases involving public corruption, responsibility often falls to special agents of the Tennessee Bureau of Investigation, agents for whom the badge is a badge of honor.
Nepotism is in the policy, and it's not allowed.
Melissa Smith worked in the TBI Human Resources Department for 2 years, where she says she watched the children of TBI bigwigs get hired as special agents over military veterans with far greater law enforcement experience. That despite a state law that says veterans will be given preference in hiring.
When we were trying to write the veterans letters to justify, why veterans weren't hired over everyone else that was hired, the word legacy came up.
Meaning?
That they're family members. It's part of their legacy to be a TBI agent.
Which sounds like a fancy word
for nepotism.
I'm absolutely looking for the best and right.
Last year, more than 1,000 people applied for just 14 TBI special agent jobs. One of the 14 lucky hires, Hunter Locke, did not even graduate until December from Cumberland University. His resume shows a degree in health and human performance with a minor in sports management. His primary work experience, he was a pizza delivery person. Still, a TBI interview panel voted to strongly recommend him to become a special agent.
There's a lot of competition out there, so you have to do things to set yourself apart.
Hunter's dad, it turns out, is TBI Deputy Director Jason Locke, the number 2 man at the Bureau. Here, speaking to a group at Boise State, Locke had some advice on how other young men might fulfill their dreams of becoming TBI agents.
We always encourage people, especially if they're right out of college, maybe to try to get out and get some experience at a local law enforcement arena, at a local police department or sheriff's department.
But when it came to Locke's own son,
he wasn't a criminal justice major.
Nope.
He had never worked in law enforcement a day in his life.
Mm-mm.
If this had been any other young man straight out of college,
He wouldn't even made it through.
notes from the TBI interviewers reflect his limited law enforcement experience. But then there's that word, legacy. We showed the notes to Melissa Smith.
what jumps out at you there?
The fact that they actually wrote the word legacy.
What does that tell you?
It's nepotism.
Mark Gwynn is the director of the TBI.
Are there situations where you might reject someone who's more qualified to give the job to someone's son or daughter?
What you may think is qualified may be totally different than what I think is qualified.
Experience.
What you may think is experience may be totally different than what I feel experience.
Why'd he just run back his first
Gwynn
answer?
says he got his first police job because the police chief knew his dad, who was a reserve officer. And he says he hired his deputy director's son because he knows the values the young man learned inside their home.
He watched his father go out and work cases. He understood what the values at TBI were and what that badge meant, that TBI badge meant.
If he had not been the deputy director's son, would he have been hired?
I can't answer that.
And legacy could be one of many criteria in the selection process. So
Lou Ryder is a law enforcement consultant who retired as a deputy chief of the Los Angeles Police Department. He says it's good to have people who understand the values of an organization, but it shouldn't be the only factor.
if they're selected over more qualified persons, then you'd have to say, well, the legacy has more weight than it probably should be.
In fact, a year earlier, Luke Webb, the stepson of TBI Assistant Director T.J. Jordan, beat out more than 1,100 other applicants to become a special agent, even though the interview notes show he failed to get a strongly recommend from interviewers.
There aren't many in the interview process that get a recommend that make it through to the second round, because there are so many applicants and there are so few spots.
The number one rule at the TBI is don't do anything to embarrass the TBI.
And what about the state's nepotism law? It says no state employees.
Excuse me?
Because there are so many applicants and there are so few spots.
The number one rule at the TBI is don't do anything to embarrass the TBI.
And what about the state's nepotism law? It says no state employees who are related shall be placed within the same direct line of supervision. In the case of Hunter Locke, he reports to a special agent in charge who reports to an assistant director who reports to Jason Locke. And Hunter's dad has the authority to act as the TBI's top dog when the director is away.
How does that not create a potential conflict of interest?
Because you've got to know TBI.
Gwen says TBI attorneys tell him that because Jason Locke does not directly supervise his son, it's not illegal. Still, Ryder says there's a potential conflict of interest.
Now, if Daddy, being top dog in the organization, then protects him and gives him favoritism on assignments and circumvents the normal processes, yeah, then that would be a potential liability.
If someone calls you tomorrow and says Hunter Locke or anyone else is getting preferential treatment, I'm willing to do something about that. But to turn my back on that young man that wants to live that dream of following in his father's footsteps, or anyone else out here that wants to follow in their parents' footsteps, I'm not going to do that.
Still, it turns out the TBI made some pretty questionable claims when it was required to produce these letters explaining why it did not hire veterans who had served their country. More on that when my investigation continues.
Thanks, Phil. And you can go right now to newschannel5.com to see extended interviews with everyone featured in tonight's story. Then be sure to watch tomorrow night at 6 when Phil reveals how the TBI justified the decision not to hire veterans.
Her killer is convicted. So what happens now to Holly Bobo's remains? Her skull with a bullet wound was a key piece of evidence. But will those remains finally be laid to rest? Surprisingly, News Channel 5's Nick Beres learned it may be quite some time before the skull and the bone fragments are returned to the family.
The Holly Bobo trial ended nearly 2 months ago with the conviction of Zach Adams, but Bobo's remains are still with the TBI, and that figures not to change anytime soon. Investigators did not find Holly Bobo's entire skeleton, but they
All right, so this is November 27th of 2017.
did have her skull and other bone fragments. That key physical evidence at trial was proof positive Bobo was dead, and the jury decided Zach Adams killed her. There are 2 others charged. So now, what happens to those remains?
Typically, anything that's used as an exhibit in trial is saved throughout the appellate process.
That's right, not returned to the family, at least not yet. It's true prosecutor.
Yeah, so they only found a few partial ribs. They had the skull. Some of the teeth were knocked out. And then I think scapula. And to be honest, I have no idea what this would be. We don't have any, like, fingers, like tarsa, even though we found a promise ring at the scene of the remains. But yeah.
Only introduced photos of the bones, not the bones themselves, but News Channel 5 legal analyst Nick Leonardo says new questions could come up, especially regarding the actual skull.
Given the fact that there is a bullet wound on the skull, I do think that that could be an integral part of any appeal that would ensue.
Zach Adams' appeal could take years. You'll recall Karen Bobo, Holly's mother, agreed to a life sentence instead of seeking the death penalty for Adams, something that Adams' attorney appreciated at the time.
I said, I just want you to know that what you've done today is an incredible gift that you've given my client.
It is possible Adams could return a favor. He could waive the use of the actual bones for his appeals. Doing so would allow the Bobo family to finally give Holly's remains a proper burial. Whatever happens, we know that Bobo's remains will remain in TBI custody until at least next May. That's when Zach Adams' brother Dylan goes on trial for the kidnapping, rape, and murder of Holly Bobo. Nick Beres, News Channel 5.
Nick, thank you. Zach Adams' attorney has not commented on whether they will need the remains for her client's appeal. The final decision on the release of all evidence, that will be made by the prosecutor's office.
And next video is going to be about top prosecutor appointed judge.
6:45 and a good morning to you. Exclusive details now regarding the Holly Bobo murder
January
case.
11th,
the top prosecutor is no longer involved. She is off the case. News Channel 5's Nick Beres has been following this story since the beginning. He joins us now with these exclusive details. Nick?
Yeah, good morning to you, Dan. You know, this is a very significant development. So many people have followed this case. We did it gavel to gavel, and it's really far from closed, the Bobo case. One trial done, but one, maybe two more to go, and now the top prosecutor is gone. Here's what we know this morning and what it means to this case. This morning we know that lead prosecutor Jennifer Nichols is off the case. Why? Governor Haslam late yesterday appointed her as a criminal court judge in West Tennessee. Congratulations to her. I assume that's something she wanted, but what this means is that takes effect immediately and means Nichols, as of now, is no longer on the Bobo case. Now,
So she was appointed then, but she's up for re-election. And like her Facebook, she's like campaigning for the next election cycle so she can continue to be a judge. So next round, she'll have to be voted to stay as the incumbent.
of course, led the successful prosecution of Zach Adams for Bobo's murder last year. Next up is Zach's brother, Dylan, who is set for trial in May. And then don't forget, there's another defendant, Jason Autry. He too could potentially go to trial. It's not clear right now who will replace Nichols. It could be one of the prosecution's legal team. There were others involved. But this further complicates the long-running Bobo case. There's a January 22nd deadline to reach a plea deal with Dylan Adams. With Nichols gone, you have to wonder, do all negotiations start over? What happens with Jason Autry? And the big question many people will be asking, thinking about the Bobo family, does this mean more delays in the case? Great question. We'll learn more about that later this month. We'll send it back to you in the studio.
Developing news now. We will learn later this morning if there will be another trial in the Holly Bobo murder case.
January
Channel 5's Nick Beres is in the 5 Alert Center with exclusive details this morning on what we might expect. Nick.
Now, certainly a story we've been following for some time. And the big question this morning, Amy, is whether or not there will be a plea deal for Dylan Adams. The judge set a deadline for a deal today. What will happen? All right, prosecutors, of course, last year convicted Dylan's brother, Zach, of kidnapping, raping, and murdering Holly Bobo. Now it is Dylan Adams' turn, and after him will come a third suspect, possibly even Jason Autry. Now, sources tell me prosecutors have offered Dylan a plea deal in the 40-year range, and that if that's the case, Dylan, will likely just go ahead and take his chances at trial. Many experts think the case against Dylan is nowhere near as strong as the one that convicted his brother. Also, this time something to consider, jurors will come from Chattanooga, and it's a safe bet they're going to know a lot less about this case than the jury from Hardin County did in Zach's trial. And one other big development that just happened over the last month, the lead prosecutor in this case, Jennifer Nichols, she's gone. She's no longer on the case. She was recently appointed to be a judge, so she can no longer prosecute. That's an awful lot to cover. Now, I can tell you this. A lot of people have followed this. We will be covering the hearing live. It begins at 11 o'clock, both on News Channel 5 Plus and streaming live on newschannel5.com. Keep in mind, if there is no plea deal announced today, this case will go to trial in May. We'll send it back to you in the studio.
3 decades behind bars, that's where Dylan Adams will be following a plea deal in the Holly Bobo murder case.
The nursing student was kidnapped and killed more than 6 years ago, and Holly's family was instrumental in reaching today's plea bargain.
News Channel 5's Chris Conti was with them today.
For Holly's mother, father, and brother, this was all about avoiding another grueling trial, and today's plea bargain with Dylan Adams ensures that. And now this family's interminable quest for justice appears to be entering its final chapter.
This family's been through hell for 7 years.
Day after day, year after year, they've waited. Waited for Holly to come home, then waited for justice.
Trying very desperately to reach a resolution.
Inside the Hardin County Courthouse today, the wait for justice came to an end.
Are you entering this plea of guilty freely and voluntarily?
After a month of negotiations, Dylan Adams pled guilty to facilitating the murder of and carrying out the kidnapping of Holly Bobo in 2011.
Are you in fact pleading guilty?
The 30-year-old's plea bargain, though, did not require him to admit guilt. He will, though, have to spend 35 years in jail. Far less time than his brother Zach, who is behind bars for life for his role in Holly's death.
But this started 7 years ago. They've been waiting for 7 years for justice. They got some with Zach's trial and Zach's verdict. Now they get a little more with John Dylan Adams.
More than anything, this deal prevents the Bobo family from experiencing another weeks-long, grueling trial.
We came prepared for a trial, but for the sake of our family and just letting one more chapter be behind us, we decided we would go with this.
For Holly's mother, Karen, there is no such thing as closure. There never will be.
Honestly, there's really no such thing as closure when something like this happens. Justice, some justice, and but no, there's no closure, and she's still the last thing on my mind when I go to bed every night and the first thing when I wake up every morning.
Before the court today, Dylan also made a statement letting the public know that Holly's brother Clint had nothing to do with her disappearance.
We've had a lot of support.
So this was a condition for this plea that Dylan had to let the court know that Clint Bobo, exonerate Clint Bobo.
Very thankful for that.
Day after day, year after year, they've waited for Holly to come home, but now the wait for justice is at an end.
There are, of course, two sides to this plea deal. While Holly's family has some semblance of justice, Dylan Adams' family is now dealing with a new level of heartbreak, as both of Cindy Adams' sons are now behind bars for their role in Holly Bobo's murder. As attorney Warwick Robinson once said, there are no winners in a case like this, only losers and survivors. In Hardin County this evening, Chris Conti, News Channel 5.
Thanks, Chris. And you can watch all of what Karen Bobo had to say today by going to our Facebook page or by visiting newschannel5.com.
All right, so this is, and when we got to this, I want to link you guys over to Burton Staggs' channel. That way, if you guys want to pause this and slow this down, Burton Staggs did some, and I think maybe it was DB, maybe it was K Riggs, but I think someone said that he might have been on the witness list, even if he's not one of the 5 or 6 people that the state plans to call at these final post-conviction hearing sessions. But he's been quiet on this case during this post-conviction petition phase. And I think someone had said that it's because he was added to the witness list. So I've been waiting till we got to something from his channel, and I'm curious to see if he's going to publish anything else. So again, this is Burton Staggs if you're on Replay Crew, and I just dropped the link in the chat for this video. But this is going to give us a bit of the lay of the land. Maybe I can make the quality a little, force it. No, but we'll see. A lay of the land. Normal speed.
It's 7 years to the day that Holly Bobo disappeared, and now we know was subsequently murdered just a couple hours later. This is the spot or the road that Zach Adams reportedly took Holly's body down and hid the body. It wasn't found for several years until ginseng hunter Larry Stone found it. And I'm going to walk you guys down to where her remains were found. It's several feet or yards into the woods, but this is pretty much what the terrain looks like.
Oh, that was a joke.
I would estimate they brought Holly's body about 400 meters into the woods. Of course, you're following logging roads.
So you can see that there's like a utility pole here. I think maybe that's a tall tree, because it does kind of look like the same color. Well, let's keep playing, because I'm not sure exactly what because it looks like he might have turned the camera around when it jumped.
Or yards into the woods.
Right, watch this.
But this is pretty much what the terrain looks like. I would estimate they brought Holly's body about 400 meters into the woods. Of course, you're following logging roads at a point, and I've always noticed that there's buttercups. At this point, the logging road turns to the left, and we'll continue down that trail. We've come about 400 meters into the woods. As you walk down this path,
all right, there you go.
You come to the spot where Larry Stone originally found the remains. And today, 7 years ago, Holly Bobo was placed in this shallow grave. There are now markers here to memorialize where she was found. People have asked a lot of questions through the years about where she was found, and now that we're past most of the trial, I feel comfortable talking about what I know about the case. Larry Stone came down this hill looking for ginseng, and then he made a horrific discovery.
And I can hear the water in the background trickling. Just for anyone that might not be able to hear it, I don't know how much louder like my headphones might come through for the way everyone else might listen, but I hear water trickling, water running.
The skull of Holly Bobo was located where that vase of flowers is, between those trees. The TBI dug many places here to find other remains.
Good evening, everyone. Jason.
So there you go. And again, what I heard was that he was on the witness list. So I would be curious, go follow his channel, see if when he's not under sequestration, if he'll have new content come out. So, and then this one here, this might have been a side story. Okay, this was like a side story about TBI drama, but we're going to watch it anyway. So this is June 19th of 2018 now.
Jason Locke began the day serving amid scandal as the acting director of the Tennessee Bureau of Investigation.
But then, after a wave of calls for him to step aside, the TBI announced this afternoon that he'll be placed on administrative leave. Lieutenant Randy McNally, who's friends with Locke, had told News Channel 5 Investigates, "If I were advising him, I would counsel him to resign for the good of his family and the Bureau." House Speaker Beth Harwell was even more direct. She said Locke needs now to step down. Our chief investigative reporter Phil Williams first broke all of the latest developments. Phil.
Well, Becky, the new TBI director, David Roush, does not take office until next Monday. Jason Locke appeared to be hanging on to the job of acting director. That is, until prominent lawmakers began questioning what damage might be done to the TBI.
Yeah, we dodged a bullet. I wouldn't want a man like this heading the TBI if these allegations are true.
Senate Chairman Mike Bell says all indications were that acting TBI Director Jason Locke might have been Governor Bill Haslam's first choice to be the next director of the TBI.
I've devoted my career to this agency because I love what it stands for.
In applying for the job, Locke bolstered his longstanding image that even his own wife has characterized as a Dudley Do-Right. But in email sent Friday to the governor, Kim Locke accused the TBI veteran of having an affair with another high-ranking state official at taxpayer expense. Confronted with those allegations, Kim Locke claimed her husband picked up a gun and held it in his hands the whole time we talked. She told the governor, "I'm very afraid that I'm in danger."
His silence is deafening.
The East Tennessee Republican was among the first to call for Locke to let someone else run the Bureau until incoming Director David Roush takes office next week.
Even though I think he's only in office for another 4 or 5 days, I believe he should step aside immediately unless he's going to address these allegations. And
Democrat Mike Stewart agreed.
When you have charges like this leveled at somebody of this seriousness, they have to step aside and turn over their operational duties to their deputy so that the public understands that until this investigation is complete, someone else is going to be running the show.
You can't falter. You can't make ethical mistakes.
Our News Channel 5
Channel 5, with the way they cut in these old clips, it's great. They do great work with their edits.
Until this investigation is complete, someone else is going to be running the show.
You can't falter. You can't make ethical mistakes.
Our News Channel 5 investigation had previously raised questions about the hiring of Locke's son Hunter as a TBI special agent. The Bureau passed over veterans with more experience for the job.
what bothered me there was that the TBI and Mr. Locke here ignored what I think was the spirit of the law that the legislature passed, wanting to give veterans preference.
There's a phrase in law enforcement.
After Locke became acting director with authority to hire and fire, he could never explain how that did not violate Tennessee's law against nepotism. And the panel that chose the final nominees to be TBI director never asked about that or any other part of the TBI culture.
I think it is a concern, and I hope with the new director coming in, he will hear that that's a concern and make changes from the top down.
Ironically, if Jason Locke had been appointed as the TBI director and then this had come up, it would have been a much more serious dilemma. Removing him might have required the legislature to come into special session for impeachment proceedings. Bell says he expects that next year lawmakers will take a hard look at how to make the TBI more accountable. Of course, we'll be watching.
I'm not sure.
What's next for the state's star?
All right, let's get a date now that we're back to Holly Bobo's Zach Adams and co. case. So July 9th, 2018, the fate of the final defendant.
Our witness in the Holly Bobo murder case. Jason Autry is charged, but he's helped to send the two other defendants, brothers Zach and Dylan Adams, to prison.
Now, some believe Autry, who is still jailed awaiting trial, will get a sweetheart deal. In this exclusive report, News Channel 5's Nick Beres learned that may happen.
It's been 10 months now since a jury convicted Zach Adams of kidnapping, raping, and murdering Holly Bobo. He's now serving life in prison, and there's no debate. Jason Autry put him there. You remember Autry.
What was your plan of disposing of Holly's body?
Mr. Gutter.
Autry is a co-defendant. He was charged along with Zach and his brother Dylan Adams in the Bobo case, but last September, Autry turned state's evidence to testify against Zach Adams.
That's the way the game is played. You have a case that's circumstantial with some physical evidence, but you need someone to tell the story. And so he was important. He had to tell the story. And so that's why he was valuable. How valuable he was, we'll find out when they cut his plea deal.
I did not kidnap, I did not rape, and I did not kill Miss Bobo. And I did not. But I lied and said that I didn't have no details to it.
At trial, Autry admitted to trying to help Adams dispose of Bobo's body.
I grabbed the upper torso of Miss Bobo. Zach come around, let the tailgate down. I brought the upper torso to the end of the tailgate.
It was chilling testimony that sealed Adams' conviction and a life sentence. A few months later, his brother Dylan pleaded guilty to facilitation. That's 35 years. Autry's been jailed now for more than 5 years, awaiting a trial that likely won't happen. What's in store for him?
Well, obviously a sweetheart deal would be probation.
Counting time served. It could happen, but legal expert Jim Todd says prosecutors are in no hurry to resolve the case against their ace witness, and here's why.
The state is concerned that if the case is reversed, and in my opinion there's a strong likelihood of that they'll need him again.
Zach Adams' attorney Jennifer Thompson has filed a notice of appeal, and she plans to cite several issues, alleged mistakes, arguing for a new trial. So Autry could remain locked up until the appeals court ruled, at least a couple more years. We'll see. Nick Beres, News Channel 5.
We will indeed. For now, Jason Autry remains incarcerated without bond in the Riverbend Maximum Security Prison.
Refused to let two Tennessee Bureau of Investigation agents search their house.
All right, so this is something we'll hear more about. You guys mentioned it in the chat, and I went back and added some of this stuff to the playlist. So this is going to be a bit of a TBI side story, although it does kind of remind me of the guy who said he was like a tactical search and rescue guy, who said Brett Booth and another guy came and tore up his house without a search warrant. And then the TBI was like, that's false because we don't have a Brett Booth. There's a second couple, and they end up winning a lawsuit. This saga starts in 2018. This couple's going to come out. This news story, this video we're going to watch is November 5th, 2018. They're going to accuse TBI of an illegal search. So parallel issue.
Without a warrant. And they say what the agents did next was a crime.
For the last year, News Channel 5 Investigates has been asking who investigates the investigators. But the TBI tells our chief investigative reporter Phil Williams that what you're about to see is exactly what agents are trained to do.
We planned for this house for years, and this home was a part of us and our heart.
The U.S. Constitution says people have a right to feel secure in their homes. It's a right that Marilyn Wortman had always taken for granted until one afternoon 3 years ago.
It was utter terror. I didn't know whether we were going to be killed, arrested. I could not believe that someone was breaking into our home.
It was a nightmare.
Fred Wortman says it began when two TBI agents, Mark Reynolds and Jeff Jackson, came to their Lake County home.
Now, if you guys don't remember Jeff Jackson, that's the same guy who was interrogating, leading, contaminating the memory and testimony and statements of Dylan Adams. So that video where Dylan Adams is being interrogated and questions are shouting details at Dylan, that's Jeff Jackson in that video.
Looking for evidence
With Brent Booth sitting next to him during the time of that interview.
for a case involving an adult son who did not even live with them.
Opened the door and I said, can I help you? And he said, can we come in and sit down and talk to you? And I said, no, you can't come into my house, but I'll step outside the door and talk to you.
Outside, the two agents asked Wortman if they could search his house. Their son, who was already in jail for attempting to have his wife killed, had told another inmate that there were some valuables inside his parents' house that he might be able to get to pay someone to carry out the plot. The two agents wanted to seize those valuables, even though they knew the parents were not involved.
And
What? So, a murder for hire plot. Somebody's promising payment of jewels. If TBI has reason to believe the jewels are still in parents' property, then those jewels were never obtained to use as payment. So, how does this give them the search warrant right to these jewels that belong to the parents that somebody else sure might have been making some alleged offer about? What are we doing? How does this compute to us getting here to search the parents' home? Oh, chat.
I said, do you have a search warrant? And he said, no, we don't have a search warrant. And I said, well, in that case, I'm going to ask you to get off my porch and get out off of my property until you go and get a search warrant.
You thought it was your constitutional right to say no to a search.
No, I knew it was my constitutional right. So I opened the door, went back in the house. I shut it just like this.
Suddenly, Wortman says he heard the sound of someone attempting to crash through the door.
So, I mean, hitting it. And so I pushed up against the door, started screaming, get off my property.
What were they trying to do?
They was trying to force their way into the house.
Fred was screaming numerous times, get out of our house. Marilyn called 911.
I was able to withstand their beating the door for about three pushes, and then they knocked me back like this and came in.
In their own investigation.
So this is all a demonstration of how Judge Creed McGinley wishes any of the co-defendants ran down to Poplar, what is it, Poplar, 201 Poplar, and said, I want a deal, I want to settle this case, I want to negotiate. That's the type of banging on the door that Judge Creed McGinley wished he saw earlier from the co-defendants in the Holly Bobo case. So we've got a report here. Good old IR. This is what they look like. You can see approved by Kathy Lynn Ferguson. So here we go. Well, if they don't read it, we'll pause it and we can read it if you want.
Investigative report, the agency.
All right, so they're not going to read it. Let's
me back like this and came in.
In their own investigative report.
All right, so we've got approved by Kathy Lynn Ferguson, prepared by Mark Lane Reynolds. So the special agent in charge was Kathy Lynn Ferguson. This is the process we heard Terry Dykes talking about. Like, hey, I turned over this report, but it was never put in. I don't know why. Well, what's the process? Well, we turn it over to the special agent in charge, who at the time Terry Dykes would have been referencing would have been Jack Van Hoosier. So that's the process. Reynolds is giving this to Kathy. Kathy's approving it, putting it in. And we've got, I guess, suspect here is Fred Austin Wortman III. That's the son that's in custody accused of the murder for hire, I'm assuming. And then Stacy Jones, the victim, who I'm assuming is the spouse of Fred. So on July 29th, 2015 at approximately 4:30 p.m., Special Agent Mark Reynolds and Special Agent Jeff Jackson went to the residence of Fred Wortman Jr. and Marilyn Wortman to conduct an interview and ask for consent to search for items of evidence. The interview and collection of evidence was per the direction of ADA Mark Davidson and General Mike Donovan. Discussion was made by Agent Reynolds with the ADA and district attorney about consent versus, and they maybe spelled it wrong, a search warrant. Due to the complexity of the search warrant, criminal informant warrant, is a CI thing here? ADA and DA advised to attempt a consent search first, and if denied, to secure the residence and obtain a search warrant. Upon initial contact with Fred Wortman Jr. at his residence of 146 Arga Road, sorry, let me move my microphone because it's blocking. In Ridgely, Tennessee, introductions were made and the purpose for being at the residence was explained. This agent asked if we could go inside and talk with Mr. Wortman. He stated that we could stand on his porch and talk with him. All right, so we're like, that seems accurate at this point. There were several pieces of furniture on the porch. Let's play and pause real quick to see if we can diagonal it up more. Okay. All right, so let's see. There's furniture on his porch, and this agent asked if we could sit down and have a discussion. Why can't we just say this agent? Why aren't we just naming them? Mr. Wortman stated again that we could stand on his porch and talk. Mr. Wortman was asked if he would provide agents with an interview. Agents were told that he would give an interview, but not without the presence of his attorney. Agents responded with that was fair enough and asked if he would like to contact his attorney, and Mr. Wortman responded no. This agent then inquired if Mr. Wortman would consent to a search of his property for items of evidence in this case. Mr. Wortman asked what the items of evidence we were seeking were. It was explained that Mr. Wortman, or explained to Mr. Wortman, that the items were a Utah flag, Utah Vols flag with player signature, a UT Vols print with player signatures, athletic college championship rings, and a diamond engagement ring with a gold band. At that point, Mr. Wortman became extremely agitated and began telling agents to get the hell off of his property and stated that we were not getting a fucking thing from his property. Tell him! Mr. Wortman then began to enter his residence, yelling for us to leave his property, and again, reiterate that we would never get an effing, he spells it out, thing we were looking for from his house. As Mr. Wortman entered his residence at a quick pace, this agent was... Okay. I'm scared if I play it, it's going to move too fast for us to see anything. But quickly, before we try to read more, I see something, the safety of Agent Jackson, due to Wortman's something state, agitated state, and verbal remarks, agents follow Mr. Wortman into the residence. So, uh-oh.
Agents admitted.
Okay, that went a little too fast. Let's see if we go back a little bit. A little bit. Why is it jumping so much like that?
The agent.
Yeah, this is tough to read. I don't think I'm gonna discern much from this. Yeah, so his body language and verbal comments, agents followed him into his residence. Mr. Wortman, something on Agent Jackson, pushed the door. I'm not going to be able to read this accurately, but I do see a mention of a weapon. It looks like something, a weapon. And then Mr. Wortman, Agent Jackson. Yeah, so honestly, I don't feel like I can read. I don't know if I can turn this quality up, but I don't want to take guesses any further because my guesses will drastically change the meaning. But yeah, interesting stuff there. So let's see what they tell us in the rest of this video.
It's admitted that due to the complexity of the search warrant, they did not even try to get one. That Fred Wortman was telling agents to get the hell off his property and that he entered his own residence and tried to shut the door. But instead of leaving, they claimed they pushed the door open out of fear that he might produce a weapon from inside the home.
Keyword being from inside the home. Which would mean, how would you remove yourself from the threatening situation if that's really what you feared? Maybe you don't push inside the door.
First words out of his mouth, I could have shot you. I thought you was going for a gun.
You were not going for a gun?
No, I wasn't going for the gun. Hadn't even thought about going for a gun.
The agents also claimed that they needed to secure potential evidence in the residence that Mr. Wortman was now aware of.
That's your
But
fault.
I can tell you from my review of the case that the agents did exactly what they were trained to do.
TBI Director David Rouse says that Reynolds and Jackson went to the house fully expecting that the Wortmans would willingly give up the property they were wanting to seize. When Fred refused, Rouse says that's when they needed to take steps to make sure the evidence wasn't destroyed.
And then at that point, they did what the law allows, and that is to hold the scene until a search warrant can be obtained.
So you're okay with TBI agents going to a house and asking for consent to search? And if the homeowner says no, you're okay with them bursting into the house?
No, sir. That's not what I said.
That's what happened in this case.
Well, now so again, we're getting into specifics that I can't argue.
Okay with them bursting into the house?
No, sir. That's not what I said.
That's what happened in this case.
Well, now so again, we're getting into specifics that I can't argue on TV.
No, you can't argue at all, not just on TV, because that's what happened. Fumble.
Specifics that I can't argue on TV.
We kept asking them for a search warrant. What do you want? Please get out of our home.
One of the TBI agents finally put Lake County Sheriff Brian Avery on the phone, and the sheriff rushed to the Wortman's home with a number of deputies.
I said, I want those people out of my house, and they're not to come back without a search warrant. So he did carry them, walked them out to the porch, and then they left.
The sheriff's deputies planted themselves in the Wortman's living room until the TBI agents got back 5 hours later with a search warrant. Wortman later took out an arrest warrant for the 2 TBI agents for breaking into his home, but the DA, Phil Bibbins, immediately dismissed it.
He said, Fred?
Oh! So, how are you going to get any type of recourse for this when TBI and District Attorney's Office are hand in hand?
Later took out an arrest warrant for the 2 TBI agents for breaking into his home, but the DA, Phil Bibbins, immediately dismissed it.
He said, Fred, I can't do anything to the TBI.
Bivens, who had to work with those agents, tells News Channel 5 Investigates he dismissed that warrant because he did not think what they had done was a crime. Finally, in his quest for justice, Mr. Wortman took his story here to the Lake County Courthouse. In a nearly unprecedented move, the grand jury indicted the 2 TBI agents, charging them with aggravated burglary, aggravated assault, and aggravated kidnapping.
By statute, it is appropriate for us to go.
DA Kim Helper from Franklin was brought in after the local DA recused himself. You'll remember Helper from our Policing for Profit investigation for her lenient attitude toward officers pressuring drivers to consent to searches.
If I have not committed a crime, is it proper for a police officer to make me think that I have?
I believe that officers can use a variety of techniques.
Helper went before a judge and dismissed the indictment against the 2 agents.
So did you have the sense that they were almost untouchable?
Yes, nobody can control them as far as I can see.
The charges against the TBI agents were expunged. As a result, Helper says it would be illegal and unethical for her to talk about why she did what she did.
The mental anguish and trauma, we still suffer from it today.
Marilyn Wortman says when she looks around, she's still haunted by memories of that day.
That my home was invaded.
Do you think, broadly speaking, there's an attorney, J.B. Nichols, who is fighting in New York State for access, public access, media access to law enforcement disciplinary proceedings. Now, NYPD, their own district in, I guess, the Manhattan courts, I'm not sure how far it extends, they have policy, very localized policy that allows public access to some of the proceedings. But when it comes to the rest of New York State, there isn't public access, media access to these disciplinary hearings. They're closed. So you can't go in and see what's going on. And here, that this is evoking that memory, like what I learned from J.B. Nichols and what he's fighting for press access in New York State, is we have some entity, the sheriff's office says, all right, let's take out warrants against these 2 TBI officers because what they did was unlawful. And then you have the DA say, I'm dropping those charges. And then, nope, we want a review. So I recuse myself. We have one of my other buddies come over as a special prosecutor from another district who the news is doing a great job interpolating in little snippets. So here's Kim Halper previously being very strongly on law enforcement's side, stretching to the limits of what would be justified as police tactics, pressuring for what would either be a lawful or unlawful search, and finding a way to try to color between the lines to get there. And that same person who's very on the lenient side is going to say, well, I reviewed it and I also expunged it, so you can't look at my decisions and the reasoning behind my conclusions in my review. That is so far from any type of transparency. And when there is no transparency at all, my only logical conclusion is that there is no accountability and that there would never be accountability. So this is a crazy side story. This is just a crazy... Again, it has nothing to do with Holly Bobo, but it has everything to do with the way these agencies interweave.
That I was held hostage in my home, that my home was degraded.
Now the Wortmans are suing the 2 agents who they say violated their constitutional rights.
And I can tell you, they followed what the Supreme Court says is allowable in these situations.
The TBI has called it retaliation for an investigation that ultimately sent their son to prison.
What they did had nothing to do with our son. What they did had something to do with us by breaking into our house without a search warrant and threatening to kill us. That's what happened to us, not anything to do with our son.
The TBI director tells me that because the agents had told Mr. Wortman what they were looking for, it created what the courts call an exigent circumstance, where they had to force their way into the house and secure the scene while they tried to get a search warrant. But I spoke to veteran defense attorney Jim Todd. He told me the courts have been very clear that officers cannot create those circumstances themselves and then use that as justification for barging into someone's home. Vicki?
This video is a...
All right, so we're going to be back over with Burton Staggs. And again, this is going to be before it seems like he may have been put on the witness list by the state for these post-conviction things. He's going to show a route, what the road would look like. And now this would be some of the roads where they're supposed to be, according to Brent Booth, you know, it's possible if you're driving like 100 miles per hour. So he does this route April 14th of 2019. I'm going to drop his link in the description again.
Recreation of the events based on testimony in the Holly Bobo murder trial. Jason Autry, the state's star witness in the murder trial, testified that Zach Adams told him that once Holly Bobo was kidnapped, she was taken to a barn on Yellow Springs Road where she was raped. This video began directly in front of where that barn once stood. In a recent interview, the new landowner told me he tore that barn down because it was in ill repair.
Wait, so didn't we hear at trial that there was like some nefarious, the barn was torn down to hide evidence?
The new property owner did confirm that he acquired the property after the murder, rape, and kidnapping of Holly Bobo, and that his wife was, in fact, related to 2 of the co-conspirators, and the property was part of the estate of their family. Notice as we make our way down Yellow Springs Road that we pass Yellow Springs Church, which also plays a large role in this case. We'll visit that later. According to Jason Autry's testimony, Zach Adams asked him to come to Shayne Austin's mobile home that he needed help. Jason Autry told the jury when he arrived at Shayne Austin's mobile home that he saw Shayne Austin and Zach Adams, but he did not see Dylan Adams, but that a fire was burning in a burn barrel and they seemed to be in a hurry to burn things and to leave the area.
They didn't burn anything. They instead went on a joyride, or somebody, according to the state, went on a joyride to leave a Hansel and Gretel trail of Holly's belongings on the road, even though we heard about this burn barrel ad nauseum at the trial.
Autry testified that when he arrived at the trailer, he saw a body wrapped in a blanket in the back of a white pickup truck.
Okay, so this gate, I believe, is the gate that was not previously installed.
He saw a body wrapped in a blanket in the back of a white pickup truck.
But it's part of Jason Autry's story of what happened on the day of the abduction. That gate is part of the story.
He believed that to be the body of an associate of the A-team. He later found out that that was the body of Holly Bobo.
The TBI came down so hard on this not-for-profit group of private investigators.
All right, so now where are we in this news coverage? All right, we are July 19th, 2019, and we're going to hear about Without Warning and Cheryl Wasaki? There's a bit of a problem here because Karen Bobo's clearly able to turn this information over to somebody who's working in the capacity, a nonprofit. They're going to end up going to the media. But we have plenty of reason to believe, I would say, that there was this weird pipeline dynamic between somebody referring Karen Bobo to Dennis Benjamin, retired Memphis police officer who is now going to be working in the capacity of a private investigator for Karen Bobo, who TBI is denying it. Oh, we didn't have any. It was a one-way street. You know, we weren't giving anything to Dennis Benjamin, which is demonstrably false if you pay attention to how this investigation, or whatever we want to call it, proceeded, especially in that early 2014 timeframe. So I would imagine that Without Warning was able to have access to certain information that every other media outlet that was asking anytime there was a press conference by TBI or by anyone from the district attorney's office about what evidence do you guys have? Well, we can't talk about the ongoing investigation. Different answers for the media pool and the rest of the public. But now there's this weird pipeline where Karen Bobo is able to give information, funnel it to maybe Whitney Duncan, and then now Cheryl Wasaki. The ATM video of the truck going backwards through the bank might not have been available, but Terry Dykes had looked at cell phone information and seen that there was evidence to believe that the guys had been in Parsons, such as Shayne Austin going to the bank and pulling money out of the ATM. So while that video wasn't in play yet, there were details that supported an alibi. Maybe not in such a clear-cut manner, because the theory could then be, well, what if Zach's phone was on them, but Zach wasn't physically present with them, and it was only his device that was pinging in the, or that was located, hitting off the towers in that area. So, but here you have the media making the conclusion, based off the conclusion that the remaining members of TBI and the prosecution team have tried to espouse, that is incorrect, an incorrect characterization, that the purported alibi for the four co-defendants was debunked and was never verified. That's not a proper characterization. And in fact, they have a bigger egg on their face now that they have to deal with the awareness, Doug Bates, Katie Spirko, of that ATM video frame. Implication being that they're aware of your car and your license plate, and they're going to look for any reason whatsoever to put a target on your back. And while I do think that there's a problem that you have a family, where's the pipeline that Sheriff Chuck laid out? You have TBI to Karen Bobo to Dennis Benjamin to TBI. You've got your circle of information that can get out the way that they want to get out, with Karen Bobo going to Sheila and Without Warning. That's problematic. And please don't take what I'm about to say as me saying that that's not problematic. That's super problematic. But on the other hand, seeing TBI go through all of this work and effort to take out warrants, why didn't we do this much work to get the ATM video? Why didn't we do this much work to get the Joe's video? But we're going to expend all these resources and time going after somebody that, quite frankly, maybe she started and was steered towards the conclusion that it was these four guys. But if they were really being that analytical and going out and driving the paths, what if the real fear was someone realizing that this doesn't add up. TBI wasn't going out and driving these routes. TBI wasn't going out and firing the gun to see. We heard that they did this in May after being confronted by the research that Trial and Error podcast and Zach Adams' current team did. What if there was a little bit of concern that, hey, they're really looking at all of this stuff? And sure, they're accepting what Karen Bobo believes at first, but what if they start to realize it doesn't add up? I don't know. I thought it was very weird that they're doing all of this to threaten and intimidate her, and I believe that they were. Even though there's also the risk of what she was doing and what her organization was doing, tainting public opinion. Maybe? Where they go out, or maybe not that exact day, but like 2 days later when they start going around the scene. This would have been back in September of 2014.
Oh, you're a kid. You'd be out here looking for it, wouldn't you?
Another
I wonder if this is footage from the response.
New developments tonight in the high-profile Holly Bobo murder case. The third and final defendant accused of murdering her has served his time.
But
August
Jason Autry will not be getting out of prison. He remains in limbo, waiting to see if a plea deal will set him free.
So what does all this mean? News Channel 5's Nick Beres is in the 5 Alert Center with exclusive details.
People forget that before his arrest in the Bobo case, Jason Autry was already in prison on a federal gun charge. Well, I have learned that his 8-year sentence is up, but Autry still is not going anywhere, at least not yet. He's still charged in connection with the Holly Bobo case, but not convicted.
No, sir. By no means, I'm not a killer. By no means did I bother that girl.
Well, now we know that Autry appears to have lied to me during an exclusive interview after his arrest 4 years ago. He later testified at trial and helped convict Zach Adams of murdering Bobo. Adams' brother Dylan also went to prison. Autry admitted he helped Zach dispose of Bobo's body.
Grabbed the upper torso of Miss Bobo. Zach come around, let the tailgate down. I brought the upper torso to the end of the tailgate.
So Autry's served his federal time but remains locked up without bond, still awaiting his state trial. It won't happen. We know he brokered a plea deal for his testimony, but before any release, there's the matter of Zach Adams' appeal.
It would be malpractice to not appeal a case where somebody gets life in prison without the possibility of parole.
That's exactly what Adams' attorney will now do. What's been the delay? News Channel 5 has learned transcripts of the entire trial are only just now finally complete. That sets the stage for an appeal.
How the appellate court knows what occurred in the trial court is the fact that they get transcripts of everything that is said.
And this is old, but Trial and Error podcast has just published the transcripts. So if you missed that earlier in the stream, dropping the link again, that's innocentbrothers.com. And they have a ton of other stuff on there as well. And we'll be looking at some of those. I'm not going to reread the trial transcripts, but we're going to try to pinpoint like sidebars, things that might have had weird jumps during the trial, and of course, voir dire, things that we know are outside the presence of the jury and the press feed. So.
And legal analyst Nick Leonardo, who is part of our gavel-to-gavel coverage of the trial, says there are issues for Adams' attorney to argue. But it may not be until late next year that the 3 appellate court judges finally do hear that appeal. In the meantime, it looks like Autry will remain locked up. Prosecutors don't want to set him free until they know whether or not a new trial will be ordered. Nick Beres, News Channel 5.
Zach Adams was sentenced to life in prison for the murder of Holly Bobo. That was more than 2 years ago.
February
and now
3rd,
finally his
2020.
formal appeal is about to be filed.
Does he stand a chance? As News Channel 5's Nick Beres tells us in this exclusive report, there is a very real possibility Adams could get a new trial.
It was an emotional and a painful trial that took more than 2 weeks. A guilty verdict sent Zach Adams to prison, but now his appeal is finally about to be filed.
It would be malpractice to not appeal a case where somebody gets life in prison without the possibility of parole.
That was Adams attorney Jennifer Thompson on Morning Line more than 2 years ago. His appeal is now pending, and this convicted killer now argues for a new trial.
I think there's probably a greater than 50% chance that this case could come back on an appeal and have to come back and be retried for one or a series of potential errors that occurred.
Legal analyst Nick Leonardo co-anchored News Channel 5's gavel-to-gavel coverage of the Bobo trial. He recalls instances where improper testimony could have tainted the jury's verdict. For instance,
there was some discussions about seeing drugs in the Adams place, methamphetamine and the like, and I think that could be obviously very prejudicial.
Adams was convicted of first-degree murder. The case against him was almost entirely circumstantial and hinged heavily on the testimony of co-defendant Jason Autry. Many believe Autry cut a deal for his testimony, but today he still remains locked up. Why?
Autry is still in jail at this point in time in the Tennessee Department of Corrections because the prosecution doesn't have a whole lot of faith in the conviction that they acquired in the trial court.
In other words, Autry...
Man, Nick Leonardo has been calling these shots. It's been really interesting to watch the coverage and see Nick Leonardo pop up and be like, well, if this is really what they're saying it is, or there could be doubts raised about this, like he's really calling things out. And even just noticing like, hey, they're waiting to make a decision with Jason Autry because they want to see if this conviction is finalized after Jennifer Thompson makes this move at an appeal. And remember, these post-conviction relief hearings, that petition is filed through a quorum nobis. So that's a mechanism to ask the trial court to correct the errors that happened within the trial court. Not commonly used. So even though we think, well, what do you mean they were waiting for the appeal to finish? Isn't there an appeal going on right now? It's a petition for post-conviction relief at the trial court level. I don't think the state expected Doug Bates and Dana McClendon, Katie Spirko, the whole chain of events that brought us here to happen.
Remains locked up, at least in part, because he may be needed to testify again if the appellate court orders a new trial. It's not exactly clear why it has taken so long for the defense to file this appeal. Of course, there was a lengthy testimony transcript, but the court has now ordered that this happen soon so that the process can begin. Nick Beres, News Channel 5.
Tonight, 2 special agents from Tennessee.
All right, this is back to the side story-ish. It's barely a side story. With the couple winning the lawsuit for that TBI raid, search, whatever, on their home.
Tennessee's top law enforcement agency find themselves on the losing end of a lawsuit that accused them of an illegal home invasion. Now, a West Tennessee jury has ordered the 2 TBI agents to pay the couple more than $100,000. It follows an exclusive investigation led by Chief Investigative Reporter Phil Williams.
We first told you about this story back in 2018. The couple got the 2 TBI agents indicted for breaking into their home, but then a prosecutor dismissed the charges. Now a lawsuit they filed has resulted in a rare victory against the TBI.
Opened the door and I said, can I help you?
Fred Wortman walked us through the July 2015 incident when TBI agents Mark Reynolds and Jeff Jackson came to his Lake County home. They were wanting to confiscate some family valuables as part of an investigation into their adult son.
And I said, do you have a search warrant? And he said, no, we don't have a search warrant. And I said, well, in that case, I'm going to ask you to get off my porch and get out off of my property until you go and get a search warrant.
As Wortman headed inside, the agents rammed the door.
I was able to withstand their beating the door for about three pushes.
Fred was screaming numerous times, "Get out of our house, Maryland, call 911.
Eventually, one of the agents forced his way inside.
First words out of his mouth, I could have shot you. I thought you was going for a gun.
I think the TBI was on trial to a certain extent, Phil.
Dyersburg attorney Charles Agee says the 2 agents tried to convince the jury that Fred Wortman had threatened to destroy evidence, but he says their story fell apart on cross-examination.
And I think it created in the mind of the jury that their credibility was weak or that they were actually lying on the witness stand.
But I can tell you from my review of the case that the agents did exactly what they were trained to do.
TBI Director David Roush had defended the conduct of his two agents.
So you're okay with TBI agents going to a house and asking for consent to search? And if the homeowner says no, you're okay with them bursting into the house?
No, sir, that's not what I said.
That's what happened in this case.
Well, now so again, we're getting into specifics that I can't argue on TV.
He clearly said he supported their behavior and that he had investigated the incident. We found out during his discovery deposition under oath that his only investigation was talking to these two agents and getting their side of the story. He never talked to the Workmans who were the victims of this misbehavior by his agents.
Wow.
More than 4 years after the Wortmans decided to fight the system, their attorney hopes the jury's verdict sends a message.
Nobody is above the law, including these two agents or any other law enforcement officers in Lake County and Tennessee or this nation. And I think that was the message we sent.
The TBI issued a statement insisting, quote, "We continue to maintain that our agents' actions were both lawful and necessary." You can see the full statement plus watch our previous investigation right now at newschannel5.com.
Thanks, Bill. Now, one of the convicted killers of Holly Bobo has officially petitioned for a new trial. Zach Adams' attorney presented a judge with 56 reasons he should get a new trial. Holly Bobo went missing in Decatur County in 2011. Zach was tried and convicted in 2017 in West Tennessee. But his attorney says it wasn't far enough away from where the crime happened, or they should have brought in a jury from a different area to make sure it was fair.
Meanwhile, the Bobo family was actually in Nashville today pleading with lawmakers to change the state's Amber Alert policy. Holly was 20 when she went missing. Amber Alerts only apply to people under the age of 17, so Holly didn't get one early on in her disappearance. This year, lawmakers introduced the Holly Bobo Act, which would allow an alert to be issued for anyone under the
I thought she did get an Amber Alert, and they thought it was unusual because of the age.
age of 21.
We know now that the abductors traveled with Holly on rural back roads, and there were people who saw her, but they didn't realize what they were seeing. Instant action was needed during these crucial moments.
The committee passed the bill in a vote today in the House. Yesterday, the bill was sent to the full Senate floor.
Good evening. A biased judge and an unfair jury. Those claims are the basis of an appeal now filed by Holly Bobo's convicted killer.
It's been more than 2 years since the conviction of Zach Adams, but now, as News Channel 5's Nick Beres learned exclusively, he is asking for a new trial.
All right, so this was the same day. This is also February 27th, but I'm assuming they looked at the petition, the brief.
It's been a very long time coming, but this is the Adams appeal, and in it, his lawyer cites 56 instances where she says a serious mistake was made during the murder trial.
It would be malpractice to not appeal a case where somebody gets life in prison without the possibility of parole.
That's Adams' attorney Jennifer Thompson, just after her client was convicted in the murder of Holly Bobo. And now, finally, 2.5 years later, she's filed this appeal asking that Adams get a new trial.
There's quite a few good issues in this case because it was a very long case.
Legal analyst Nick Leonardo co-anchored News Channel 5's gavel-to-gavel coverage of the 2-week Bobo trial back in 2017. He cites the appeal highlights. Adams first challenges the judge's decision to only move the trial from Decatur to Hardin County, which is right next door, and that
And we just heard Judge McGinley say that, or I think it was news coverage about one of the hearings, that it was said at one of the hearings that after voir dire, 97% of the potential jury pool said they had heard about and or discussed this case, even though they had moved it over to Hardin County. 97%.
the jurors in that county were still biased against Adams.
The change of venue is very significant.
Leonardo also says the appeal alleges the judge allowed the prosecution to spring surprise evidence. For example, an incriminating photo lineup of Adams.
The defense was unaware that they even had that photo lineup, and they were not provided that in discovery. So what you have is a piece of evidence that comes in at the trial in front of the jury that the defense has never seen.
And thus, they couldn't prepare for it at trial. The appeal also claims the judge sided with the prosecution time and again unfairly. In one instance, denying the defense a break at the end of a long day.
It was a summer, It was very, very hot, and it was 6 o'clock. And so I believe there was a request by defense to pick up with their cross-examination.
That was for Jason Autry. So remember, Jason Autry was on the stand all day. And the day before, I think day 4 was Jason Autry. So on day 3, at the end of day 3, when they're asking about scheduling and what witnesses should we be prepared for the next day, the state said that they plan to call like TBI agents, random other witnesses. Well, they get there on the 4th and it's Jason Autry on the stand all day. So not only were they on notice that Jason Autry would be who they should be preparing for tomorrow, the star witness, the person that really points the finger, throws the book at Zachary Adams, they don't have the time to prepare. And then court is going until like 7 o'clock that night local time, and you can see the people in the court holding papers and fanning themselves. And they say, nope, get it done.
Following day, and the court said no and continued to push on through.
Again, those are just 3 of the 56 objections made in the appeal asking for a new trial. Now, the appellate court must decide if one or more of the alleged mistakes did enough to deny Adams a fair trial. Nick Beres, News Channel 5.
Thanks, Nick. The motion for appeal will first be heard by Judge Creed McGinley. After that, it's expected to be sent to the Tennessee Court of Appeals, where a decision will take at least 6 months.
And they are in.
Now, I know that we watched this already, but I think we need to watch real briefly here, because it reminded me of something we heard at, when did I put it on the timeline? February of 2017, I think. Let's see, February. Yeah, so February 2017, like the first day of February, we have Matt Scholl, Jason Autry's attorney, state in open court that, yeah, I told the judge that we don't expect to need a trial date. When the judge starts the proceedings today, he's like, I don't know what we're here for. This is 3 years to, well, what's the exact date? September 14th, 2020. So 3 years from the trial. Trial started on September 11th. Wait, so September 14th, would that have been... Did Jason Autry testify on September 14th, 2011? Literally 3 years to the day of his testimony. That wasn't an exaggeration. We're going to hear that. Anyway, he's out in the gallery at the beginning of these proceedings. We're not going to rewatch the whole lead-in, but I want you guys to see this interaction before they go on the record on this day, which is going to turn out to be the plea colloquy for Jason Autry. But the judge is going to act like he doesn't know that.
On the regular jury, there were 2 African-American males. I couldn't find my list of jurors, but I know Ken Bingham was on it. He was supposed to coach or something in high school. Yeah, there was a guy that used to work for Sandy.
They have me 2 alternate or 2 regular?
No, regular jury.
Well, I don't know. I assume they made 3 to the year.
I know Bingham was on the case.
I think they both. They were the deputies.
He goes, this is where he goes to talk to the family. And the court camera, the volume's like all the way down. This seems like a better moment to keep the mask on, considering you're like a foot away from someone's face, but okay. All right, so now he's going to finally go up to the bench, and we're going to hear him say he has no idea what to expect today. Though maybe he does. He's got the maximum security shirt.
All right. Martin County Circuit Court is now in session. With the Honorable C. Creek beginning to preside. Please remain standing. May God bless the United States, State of Tennessee, Burton County, and this honorable court. Be seated. Thank you, Sheriff. I'm far enough away. I'm going to uncover a little where y'all can hear me. First of all, we're a little bit over 2 hours late starting. That's what's known as a snafu. Y'all know what a snafu is? Situation normal, all F up. What actually acronym that stands for. We just had some disparity between the transportation. I told them I got all day and created absolutely no problems. You folks have been with us throughout the day. I was advised early on in this case, after Mr. Scholl and Brandon got involved, one of you said, Judge, we will not be needing a trial date. And that was fairly early in the process. We were still in Decatur County at the time I was told that. Prior to that,
early in the process.
I'd actually said, and this was in Decatur County.
So there you go. Fairly early in the process, we were still in Decatur County. So there we go. We're hearing it again. We heard it earlier while watching one of the hearings from, that actually might have been the beginning of 2017. Yeah, beginning of 2017.
We got Miss Nichols with us today.
There it is.
Who is the Commissioner of Children's Services, and she was lead prosecutor, which reminds me, I'm going to get Susan Jones FaceTime, because they've been through this case throughout. I'm going to let them follow it to the end. So I'll be.
He's checking a score quick while he's on his phone.
Hi there. Hey, we just started the hearing. I opened court, and we just now started the hearing. I briefly addressed just a few preliminary matters about, I was informed by defense counsel fairly early on, and they didn't tell me something had been worked out. They just said, we will not be needing a trial date. And I had said prior to that, we were still in Decatur County. That's why I looked back and saw Miss Nichols, and you guys were both there. You guys, as well as all the other attorneys, were there, and I think you probably remember me saying, if I was involved in this case from a defense standpoint, it would be a race to 201 Poplar. You remember me saying that? And apparently you folks won the race. Then sometime after that, the attorneys got together with the prosecutors. There was a proffer in this case. Actually, Mr. Autry met with attorneys and prosecutors and went through the route of what he testified to at the trial. Is that correct?
Yes, sir.
So we're ready to proceed now. You want to announce the basic terms of this plea agreement?
Yes, sir. Are we far enough away?
You are, I don't know about him.
I can talk through it. I can
I can hear you.
Yes,
Make sure the court reporter can hear you.
It's a little hard.
All right. I'll talk as loud as I can. Actually, 3 years ago to this day, Mr. Autry testified in this courtroom and told the jury and I guess the world, as it were, what happened April 13th of 2011. In this courtroom then and in this courtroom today, Karen Bobo, Dana Bobo, they're here. And they are in support and agreement with this guilty plea, which takes into account the realities of the prosecution before Mr. Autry cooperated, and then takes into account the importance of his cooperation and his credible, truthful testimony at trial.
I addressed earlier at the motion for new trial on the co-defendant. His testimony was some of the most credible, persuasive testimony I've ever heard given in a courtroom.
And it answered many questions that were left open factually in the investigation. It answered many questions that Karen and Dana had about what happened to their daughter, and it was a very important piece in getting justice for Holly. This guilty plea is to 17 CR 10, counts 3 and counts 8 of the indictment, On count 3, Mr. Autry pleaded guilty to the B felony, facilitation, especially aggravated kidnapping, an 8-year sentence as a range 1 offender. Count 8 of the same indictment, he'll plead guilty to solicitation to commit murder in the first degree, a class B felony, 8 years confinement as a range 1 standard offender. The two sentences to run concurrent with each other and also concurrent with a federal sentence, which is noted on the judgment sheets. The other counts by separate order are asked to be null pros without cause.
All right.
Mr. Autry will serve the sentence. There'll be no petition hearing or my approach.
Yes. Mr. Autry, can you hear me well?
Yes, sir.
I'm going to go through your rights at this time. You have the right to plead not guilty. If you enter a plea of not guilty, you're entitled to a speedy and public trial by jury or by judge sitting without a jury. At a trial, you'd have the right to the assistance of counsel, the right to confront and cross-examine witnesses testifying against you, and the right to compel witnesses to appear and testify on your behalf. At a trial, you cannot be compelled to take the witness stand and incriminate yourself. If your plea of guilty is accepted, there will not be a trial, and this case is at an end other than the imposing of the sentence upon you. In accepting this plea of guilty, the court can ask you questions, require that you answer those questions under oath on the record with the assistance of your attorney, and your answers could later be used against you in a prosecution for perjury. You need to understand that if you should ever be found guilty of another criminal offense at a later date, the judgment of conviction in today's case could be used to enhance the punishment for that later offense. You need to understand that by the entry of a guilty plea today, that you're waiving your right to appeal your case to a higher court. I want you to stand with your attorneys. I'm going to put you under oath. You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You are Jason Wayne Autry.
Yes, sir.
In case 17 CR 10, it's indicated you may wish to enter a plea of guilty. Are you doing this freely and voluntarily?
Yes, sir.
Nobody forcing you to enter a plea against your wishes?
No, sir.
Do you fully understand what you're doing today?
Yes, sir.
Have you consulted fully and thoroughly, discussed the case fully and thoroughly with your respective attorneys?
Yes, sir.
Talked with them about the nature of the offenses as well as any possible legal defenses.
Yes, sir.
Pleading guilty to count 3, especially aggravated kidnapping. The range 1 offender could get 15 to 25 years. And the charged offense on count 8 is first degree murder. That could be life without parole, or death. If the court accepts your plea, plead guilty to facilitating especially aggravated kidnapping. That's an amended charge, be an 8-year sentence as a range 1 standard offender, 30% classification. Count 2, you'd be pleading guilty to solicitation of murder 1, receive an 8-year sentence, range 1 standard offender, and 30% classification. They will run concurrent. Do you understand what that means?
Yes, sir.
They're also running concurrent with a federal sentence.
Yes, sir.
You want to give me a statement of facts, or does he want to stipulate a factual basis exists?
Your Honor, please, we stipulate that a factual basis exists for the plea. I ask that you accept the negotiated plea. I do want to say one thing for the record that we discussed, Your Honor. There was no formal agreement in this case between defense counsel and the prosecution until about 1 month ago, within the last month. So no offer was conveyed or given to Mr. Autry until just a few weeks ago, when I did so via Skype with the TDOC. So just, I wanted to get that clear for the record.
Not formal agreement, because they would have been, the other co-defendants would have been entitled to that. I think everybody suspected that an agreement would be forthcoming, but no formal agreement was reached until, you say, about 30 days ago.
We did not start having our conversations for the formal agreement until about 30 days ago.
Okay, let the record so reflect. Anything else?
That's all, Your Honor.
All right, yes.
You see what they're getting on the record here? No formal. No formal. So I feel like this is accomplishing two things here, right? We're making sure we don't say that there was a formal agreement in place at the time of trial, at the time that Jason Autry testified, and at the time that trial counsel Jennifer Thompson would have been cross-examining Jason Autry and asking questions about his perception of any benefits conferred or promises of leniency. We also have this weird, bolstering from the judge, where the judge is saying, most credible testimony I've ever seen. And again, keeping appeals in mind, the appeals court isn't going to watch the trial testimony. If you went and watched Jason Autry's 2017 trial testimony and saw the manner in which he delivered his testimony, the tone of voice he used, the facial expressions he was using, saying things like what was supposed to be a revolver and may have really been a pistol that ejected some 380 shell casing. Made the sound boom, 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 boom. You're going to question the credibility. Hearing the witness say, repeat. And I want to look and see if the court transcription has caught that. But they're going to defer to the trial judge to be the person that was in the room seeing it happen in real time. And they have the full, all five senses present in the room to assess the credibility of a witness on the stand. That's the scary part about what a court of appeals can and cannot consider, and the line that they won't cross. Yeah, that's how I feel. My personal opinion, I'm with Mel. Watching his testimony was sickening. Just up there lying, and his face was like stuck in this assertive, like downward, like he was always prepared to make sure what he was saying sounded serious. He was putting on this face, the serious face. It's just crazy. I'm with you, Blind Hog. The original trial is infuriating to watch. And here you've got on the record Judge McGinley clarifying, super credible, apparently acknowledging that without his testimony, and Doug Bates has done a great job at laying out the importance of Jason Autry's testimony, to the point where during this proceeding in 2020, Paul Hagerman is up there saying he answered questions that the investigation left open. Okay, well, if on one hand, Jason Autry's testimony is refuted, or on the other, his cross-examination, he wasn't efficiently challenged through cross-examination by trial counsel, ineffective assistance of counsel, right? He's approaching it from both types of enumerations of error. It's not just a harmless error, because you have the trial prosecutor stating at this proceeding that it was critical for closing gaps, that without him, there would be reasonable doubt about the theory of the case itself. So, my Grinch face, I gotta pull it down. I don't know if my face can naturally do that type of drag down without my hand helping me. But just a hot mess. We've got 4 minutes left in this, so we can play this out. And I know we've watched parts of it.
To in count 8?
Solicitation of first-degree murder.
Judge?
Yes.
Is that not a Class A offense?
Class B, or it's two levels down.
Solicitation's 2 levels down.
It goes down 1 just like facilitation does.
They said they thought solicitation went down 2, facilitation went down 1.
Are they going to change
They
the...
might want to double check that before they finish.
I think both sides said that they had finished. I'll stick around a few minutes after we recess this hearing, double check and make sure. Mr. Autry, I accept your plea, your sentence, as I earlier announced.
Judge, it's our intent in the plea for exactly what Your Honor stated. For on the first degree murder, for that to go 2 levels down, and on that kidnapping, especially aggravated kidnapping, for that to go 1 level. And Judge, we have talked to the TDOC. He has over 2,000 days of credit available. We wanted to make sure that was reflected on the record, which is enough time that will cover this offense.
So they will essentially enter that into, what is it, Tomas or whatever?
Correct,
And he's probably got his sentence built.
That's
but
correct.
They'll have to run that through the computer to make sure.
They have to process it, Your Honor, but we have been assured that he will get credit for this, the offense that was in Decaturville, and all the credit over 2,000 days.
Judge, the only question, the only reason I asked Mr. Shell to put that down there is because our case numbers changed. And I don't want any confusion about, where you get pretrial jail credit from which case number, because the case numbers changed. But it's actually only
pretrial credit from the time that the indictment was entered, the first indictment.
At the time of arrest. And I think we spelled it out in the judgment sheets, Your Honor.
Okay.
The scenario of how the case numbers changed.
Okay. Mr. Autry, do you feel like you've been treated fairly by the court?
Yes, sir.
All right. I try to treat everybody with dignity and respect.
Thank you.
All right, anything else? As I said, I'm going to recess. Y'all double check and make sure we're where we're supposed to be going on that. And if need be, before they take him away, let's make sure we got everything nailed down, okay?
That's fine, Your Honor.
All right, thank you.
Thank you. All right.
So this was September 2020. So, down here in Florida, I remember, COVID, the shutdown for COVID, I remember being March 17th. That was the day that Orlando announced that they were putting out a curfew. and everybody was freaking out because it's St. Patrick's Day, everybody wants to go to the bars, and that's when COVID set in. So this would have been September of 2020. So I think that's why we're seeing the masks. But it's still interesting. Green McGinley goes right up to the family and yanks his mask off when he's like this close to their faces.
I want to say this is over.
Melissa, I could be wrong here, but I believe if there was some type of like habeas petition, then that would be a better angle for Zachary Adams' team to fight for the admission of that recantation. But I think for the purpose of like a quorum nobis hearing, because they can't like lay the foundation and have the individual that's making the statement, in this case Jason Autry, doing the recanting on that interview with Katie Spirko, since they can't make him appear in person and testify to it and give the state the chance to argue against it, that's, I think, probably rightfully excluded from the record. And that sounds like it sucked, but fortunately in this situation, I think there's so much else screwed up beyond belief that I just have I'm really going to be upset if he doesn't get a new trial, because there's so much that I think was wrong here. But with that being said, I don't think it's like a fatal blow that Jason Autry wasn't able to testify and or that they couldn't play this recanting interview. And I think if those other errors weren't in play, it would be significant that couldn't come in. But I do think with something like a habeas, you go to the state Supreme Court and you say, look, we have new evidence. My client is currently serving a life sentence, and we think that he's being held without his will. You do a habeas petition, and then you fight again in a different way to get that information in. So I do think there is a way that if this petition that's going through the writ of quorum nobis fails, that they could try again with that recanting through a habeas petition, I think. So it's not, I don't think that's the be all end all of that recanting, but I don't think it's going to be necessary. I really think that there's enough here for a new trial. And again, I'm going to be upset. I'm going to be really upset if Judge Bradbury pulls a McGinley. So this ends here with him walking out. Next up, we have a quick, let's see how the news covers this. And I think this is important, right? So this hearing snippet was uploaded by WSM5. Let's see how News Channel 5 summarizes.
A new development today. The last defendant in the Holly Bobo murder case gets to walk away from prison.
Falsely accused, everybody. Innocent man, falsely accused.
Jason Autry was a key witness in the trial against one of the other suspects. This is the first time we heard from him back in 2014. We now know he was not an innocent man, but a plea deal is setting him free. News Channel 5's Matthew Torres is in Hardin County with the latest.
Holly Bobo's family was in the courtroom with the TBI when Jason Autry learned he could walk away from behind bars as early as tomorrow.
Jason, is there anything you want to say to the Holly Bobo family?
Autry appeared in the Hardin County Courthouse with a TDOC jumpsuit, wearing a face mask as he entered 2 guilty pleas to 2 lesser charges: facilitation to commit especially aggravated kidnapping and solicitation to commit first-degree murder. You might remember he was one of 3 suspects in the murder of Holly Bobo. The nursing student vanished from her Decatur County home in 2011. Her remains were found years later. Autry, Zach, and Dylan Adams were charged in the case. Dylan entered a plea of 35 years behind bars. Meanwhile, Zach was tried and convicted in 2017, but is now working to appeal his life sentence. Autry was a key witness in that trial, testifying how he helped Zach dispose of her body. The judge, defense, and prosecutors say without his testimony, there may never be a resolution to this case. The defense also pointed out that there was no formal plea agreement until a month ago.
Well, there's been some criticism that Mr. Autry was not being truthful when he said that he did not have a plea deal when he went and testified. We've had no formal plea agreement in this case.
Spell it out.
We have began discussions about a month ago with regards to the actual formal plea agreement, and this is the arrangement we came to.
But what was never officially answered was exactly why Holly Bobo was targeted. We may never get an answer to that question, but for now, Holly Bobo's family accepts the plea deal and is pleased knowing that this chapter of their lives can finally come to an end. Reporting in Savannah, Matthew Torres, News Channel 5.
This morning, we know more now about the terms of release for the final suspect in the Holly Bobo murder case.
All right, so this is now September 23rd. So remember, he took his plea on September 4th of 2020. Now we're on the 23rd.
And Nick has the exclusive details in this 5 Alert update for us this morning. And Nick, we're talking about Jason Autry.
That's exactly right, Amy. And you know what? Autry walked out of prison last week, and I, along with many others, were wondering about the terms of this felon's release. Neither Autry or his attorney would say. Now, his court release papers were made public, and the truth is, they really are more interesting for what they do not say. Autry is, we know, under a period of court-ordered supervision, but there does not appear to be any restrictions on where he can go. He could be in a halfway house right now or living with friends or family. And I found this kind of interesting. You know how if you or I get as much of a speeding ticket, we often are saddled with paying court costs and fees as part of the process? Well, Autry, who was charged with some very serious felonies, did not pay or owe a single fine or fee when he was released.
But he did plead guilty to something.
Well, that's for sure. Autry pleaded guilty to
That kind of tells you the weight, the importance, the weight that it carries that he pled guilty. We don't need anything else from you. We just need you to say this stuff. There was no punishment here for Jason Autry except that he was charged in the first place. And perhaps falsely charged. But once we get past that stage, and we're talking about the terms, to the point where the court, the Susan Jones is asking McGinley to double check, like, hey, are you sure that what you're agreeing to can actually be stepped down to classifications? And we can actually give him these minimums to give him the time served to get him out? No fees, no fines. He goes from being too dangerous to transport, but there isn't even an order for him to stay away from the victim's family. Reminds me a lot of the YSL trial and the plea deal palooza, where numerous attempts at bond hearings were denied for several co-defendants on the YSL indictment, with the rationale being from the state that, you know, they're too dangerous. They pose a risk to witnesses. Bonds denied. But yet not a single plea condition of anyone that took a plea before the trial started involved a stay-away order, stay-away condition. Yeah. Sheriff Chuck says Autry was forced to move in with Dennis Benjamin as part of this agreement, right? Yeah, like, can we at least get like some weird oddball term and condition? Nothing? Nothing? No fines? Like, what are we doing? Mr. Too Dangerous to Transport to time served. And then he ruins that. Like, he's got other charges he's dealing with. He's still in custody, unlike Terry Britt.
lesser charges of facilitation of especially aggravated kidnapping and solicitation to commit first-degree murder in the Bobo case. He already had served most of his 8-year sentence while awaiting trial, so with that time served, he walked away last week pretty much free and clear. Such is life when you cut a deal and become the ace witness for the prosecution in the high-profile trial of Zach Adams. Adams, of course, was convicted of murdering Bobo and is serving life. Autry, who was right there with him, is a free man living somewhere right now this morning.
The man accused of murdering Holly Bobo wants a new trial. Good evening, everyone. I'm Rory Johnston.
And I'm Vicki Yates. That request comes 5 years after...
All right, so this is now, we are forward. We are June 16th, 2022. So we're about to get upon the cusp, the first footage that I see of the post-conviction hearings. And it's really a powerful moment. I can't wait for you guys to see it.
Zach Adams began serving his life sentence.
News Channel 5's Nick Beres obtained an exclusive copy of a nearly 200-page appeal alleging errors and bias by the judge, lies from a key witness, and much more.
Appeals really are commonplace for convicts serving life sentences, but new trials, they are rarely granted. Still, this legal challenge comes 5 years after the fact and will be giving the appellate court much to consider.
Some of the claims are somewhat meritorious.
any long trial will have its share of mistakes, but the issue will be, were they bad enough to overturn a jury conviction of Adams?
And what the Court of Appeals is going to look at is to say, okay, is this harmless error or is this reversible error? That's the threshold.
News Channel 5 legal analyst Nick Leonardo covered the trial and says Adams was convicted on a circumstantial case in the murder of Holly Bobo. No DNA or physical evidence linked him to her death, but co-defendant Jason Autry did. He cooperated with prosecutors and testified he helped Adams dispose of Bobo's body after Adams shot her.
I grabbed the upper torso of Miss Bobo. Zach come around, let the tailgate down. I brought the upper torso to the end of the tailgate.
The appeal alleges contradictions in Autry's testimony and questions whether there was a bias by the judge. It also argues damaging statements from witnesses about Adams not related to the case were allowed during trial, wrongly influencing the jury. His attorney says there is a strong case for reversal.
It would be malpractice to not appeal a case where somebody gets life in prison without the possibility of parole.
Remember, Adams faced the death penalty before the prosecution agreed to life in prison. Leonardo says a new trial and another conviction may not bring the same result.
Be careful what you wish for, because he may end up with a death penalty if they had to retry this case again.
Hearings are expected to begin and conclude very soon, and it's possible a decision on whether or not a new trial will be granted will be made before the end of the year. In downtown Nashville, outside the appellate court, Nick Beres.
So we listened to those oral arguments delivered by Jennifer Thompson, or whatever we're going to call them, because I don't know if they were fully fledged arguments. It was rough. It was rough. I think it was like 6 or 7 streams ago. So, but it's in the playlist somewhere. Yeah. So, spoiler alert. Court of Appeals denied that. Court of Appeals denied that. Let's see. Next video.
Zach Adams is seeking a new trial. Now the man who helped put him away says he won't cooperate if that happens.
June 20th.
Here's News Channel 5's Nick Beres.
Jason Autry really was the key to the prosecution. Without his damaging testimony, it's very likely that Zach Adams never would have ended up behind bars. Now Adams is seeking a new trial, and Autry has sent me a letter.
Oh.
Adams was convicted in 2017 for the kidnapping, rape, and murder of Holly Bobo and is serving a life sentence. There was little physical evidence directly linking Adams to the crime, but Jason Autry cut a deal testifying he witnessed Adams shoot Bobo, and then he helped to dispose of the body.
I grabbed the upper torso of Miss Bobo. Zach come around, let the tailgate down.
So Bailey's is saying, and again, I'm not an attorney, guys, but my take on what Nick Leonardo was saying, hey, wait, so he could face the death penalty again. I think the reason that like a jeopardy situation wouldn't come into play, a double jeopardy, would be because it was a deal, rather than a finding, right? It wasn't like the jury went through the sentencing phase, deliberated, and said, yes, we find there to be enough aggravating factors to warrant a death penalty, which means that it never entered the stage where he was in jeopardy for that type of penalty. I'm not sure if that's the same way that double jeopardy and whether or not it would attach, if that analysis is how it works for penalty phases, but I'm thinking that might be the logic there. That might help explain if and why. And perhaps they would argue, perhaps there would be arguments from both sides for a retrial that the death penalty should or should not even be on the table. So, yeah, not sure. But yeah, let's do a new trial and let's ramp it up to make sure that the next trial counsel, if needed, if the state wants to retry the case at all, and if they want to attach the death penalty to it, let's make sure we have the most qualified team this time around, with no excuses about a conflict of interest.
I brought the upper torso to the end of the tailgate.
He was convicted solely or largely on the testimony of an accomplice, in this case, Mr. Autry.
Now Adams' lawyer has filed a 200-page brief with the appellate court arguing, among other things, that Autry lied. If Adams is granted a new trial, News Channel 5 legal analyst Nick Leonardo says Autry will again be the key.
I think that Autry was the case.
But in his letter to News Channel 5, Autry writes, "I wish I would never have took the stand. And if Adams' conviction is overturned,
Hold on, can we read more? Can we read more of this? Okay, I'm going to try. All right. So up here, verbally abused again. Can't read the first part of that line or the last part. So think I deserve, and it fades out. On down the road, don't you think? At this time, blah, something, something, testifying in the Bobo case. One quick look in the blank. I understand that Mr. Adam, oh, I skipped a line. And today I wish I would have never take the stand. I understand that Mr. Adams has the case appealed and something, something is overturned. I will not, and it's underlined, be back in, maybe it says in to testify. Something in closing, all that brings me to this. I am willing in something the best I can with any questions. Something for maybe this is pre-trial preppings. Trial, it's, I wish I could read it. I wish they would show it face forward.
I wish I would never have took the stand. And if Adams' conviction is overturned, I will not be back in court to testify. Autry did not say why.
I think it's a huge problem for the prosecution.
Maybe so, but Autry is a confirmed liar, having denied any involvement to me in an exclusive interview before the trial. Did you kidnap and kill Holly Bobo? Were you part of that? Autry either lied there or later at trial. Was his testimony truthful, and will he be called to tell his story again? If there is a new trial, the prosecution will need Autry, but there is no guarantee that the appellate court will grant Adams a new trial. A decision is expected before the end of the year. Nick Beres, News Channel 5.
I love that Nick Beres, and Channel 5 never misses an opportunity to bring up the interview they did with Jason Autry, still declaring his innocence when he had Fletcher and Long as his attorneys. Also, Adventure Erin says here that Jason Autry's deal, would have to be vacated and charges would have to be refiled if the state wanted to try him and seek capital punishment. Appellate courts very rarely vacate plea deals. So that's huge context.
All right, Nick, thank you. Jason Autry, by the way, is serving time in federal prison. It's on a gun charge, though, unrelated to the Bobo case.
The state of Tennessee has filed a response to the Holly Bobo murder case. Zach Adams, the man sentenced for Holly Bobo's death, is asking for a new trial, a request that the state wants dismissed. This comes after Jason Autry recanted his testimony, which played.
So there must have been some type of camera recording in court. And what did I say? I forgot it already. June 19th, 2024. There must have been cameras in the court. This is Judge Bradbury. This video is only 34 seconds long, but I want you guys to look at the image in this courtroom.
A large role in Adams' conviction. No DNA evidence ever linked him to the crime. Holly was kidnapped from her home in Decatur County in 2011. Her remains were found 3 years later. Autry took a plea deal for his role in the crime in exchange for testifying against Adams. There's a hearing set.
Look at this, guys. Look at this court gallery, and you cannot see the whole gallery, but you can see it's Doug Bates at the table by himself. And there is one man in the gallery behind where Doug Bates is sitting. And you have a full gallery on the other side. You have a full table of different members of TBI. I think Brent Booth is retired at this point. When did he retire? But he's there. You've got Kay Fergs, you've got Walker, you've got Jennifer Nichols, you've got Boyano. Tell me this isn't something. Tell me this isn't something. This is so stupid. I know it's stupid. But I asked for a little Renaissance painting. Because this just what I look at this scene, and this is what I envisioned. This is all the way back in 2024. The courtroom, it's like Doug Bates against the world. He does look like a boss. Doug Bates. Like, I don't know. And I know this is like a stupid little clip here. I don't know what made me see this, but I have been thinking about this frame, this still frame, for like 2 weeks since I saw it. And now there's people out there, especially since these later proceedings have been covered, we're able to see what's going on. I don't think that that gallery is going to be empty next time around. And it's been filling up. By the time we watch the November hearings, there's a crowd. There is a crowd behind the table that Zachary Adams' team sits in. And I think that's awesome to see. I think that is awesome to see. That's there's like a few more frames of this view
For Friday.
and then it ends.
There is no easy way for me to put this.
Doug did not come to play. Shout out to Doug Bates. Crazy. We've watched this before. I think this is really where I started doing my playlist curation. This interview with Zach Adams, where he's asked about his innocence on July 3rd, 2024.
There is no easy way for me to put this, Zach, so I'm just going to tell it like it is. You have a lengthy criminal history. You have a lengthy history of using drugs. Is there any proof that you were not involved with this murder?
For the first time, Zach Adams is answering questions from a Tennessee reporter about the murder of nursing student Holly Bobo.
It's also the first time Adams has spoken since the state's key witness in the case recanted his testimony, saying Adams didn't do it. Adams agreed to speak with our chief investigative reporter, Jeremy Finley.
Unsure how much time we'd have on the phone with Zach Adams. Well, we're going to jump right into it. WSMV4 Investigates wasted no time asking the questions so many in Tennessee now have for the convicted murderer. If you say you're innocent, who killed Holly Bobo?
I have no idea. I have absolutely no idea.
It's the first time he's answered questions since WSMV4 Investigates obtained the video of the state's key witness in the trial, now recanting his testimony that he saw Adams kill Bobo.
That's the worst that I've ever felt in my life, coming back, knowing that you just lied, put an innocent man in prison.
Jason Autry is an admitted liar. He has a lengthy criminal history. So why should anybody believe him now?
Why would he have a reason to lie now? He had everything to gain by lying the first time, but now he has nothing to gain by lying. Absolutely nothing.
But it's not only Autry who told police that Adams killed the nursing student. A fellow inmate testified that Adams asked him to relay a message to Adams' brother Dylan, who was also charged with Bobo's murder. And that message was stay quiet or you would put him in a hole beside her. So how do you explain that?
I was pretty angry that day. I was real angry that day. Anybody can get on the stand and say you said this or you said that. That's why you're supposed to be able to get up there and testify on your own behalf.
So why didn't you?
I would advise my lawyers not to.
Adams' own ex-girlfriend also testified. And she heard you say that law enforcement would never be able to find her. Rebecca also says that after you broke up, you threatened to tie her up just like you did to Holly.
There were comments that were made that were taken out of context, but never have I said I did this or I did that.
Why would Rebecca say that? This was your girlfriend. Why would she say that?
Just we was arguing, and just to get a point across, quit arguing.
There is no easy way for me to put this, Zach, so I'm just going to tell it like it is. You have a lengthy criminal history. You have a lengthy history of using drugs.
But there's really no violence in my criminal background. There might be a domestic assault or something.
But you were accused of even attacking a family member, shooting at your mother, I believe. That's violent.
It was my fault, and it was an accident.
Is there any proof that you were not involved with this murder?
I think before all this is over with, we'll have a little proof.
I know that you say that you're innocent, but Autry's recanting and then you asking for a new trial is clearly going to be devastating to the Bobo family. So what would you say to the Bobo family?
Tell them to think about my family. Think about an innocent person being in prison for something they didn't do, and the real person still being out there.
All right, that's Jeremy Finley.
So there you go. And that reporter, I think, like, was echoing a lot of the questions that when I first started looking at this case. And I'm not opposed to anybody coming in here and asking questions, right? These are things, it's like juror role play. What would the jury be questioning? But, well, didn't he say he told someone else he was gonna do the same thing that he did to her? Okay, well, what about what your girlfriend said about you? What about, like, I think that reporter is asking questions that kind of unravel piece by piece that the state's case was based on weak circumstantial evidence, hearsay that doesn't even make sense with the facts. Like, there was a rumor from a jailhouse witness that Holly Bobo was, like, buried on Zach Adams' land or put in a well on Zach Adams' land, and there has been zero physical evidence recovered from Zach Adams' home or the land surrounding it. Zero. But the initial media press coverage, we got to go watch it, kept showing these B-roll reels of them excavating at his property and saying that, oh, they found bones. And, you know, but it's important questions. It's important questions to ask. The question about shooting at mom. Well, the state dropped those charges. They arrested him, but I'm pretty sure there ended up being no conviction for something like that. So, really, not really supposed to be able to come in at trial. It seems on the exclusionable side of 404B evidence. But important questions nevertheless. And then that finishes with Zachary Adams saying, well, I think we're going to see proof of my innocence. Proof of an alibi. And this was back in the summer of 2024. When January 2025 would roll around, Zach Adams is sitting in court and he sees a still image of his truck, the Chevy Silverado, backwards through the ATM on Boyano's screen. And he says, yo, Doug, that's my truck. And from there, that same ATM surveillance footage at the state saying, hey, you have everything that we have. We don't know what you're talking about. Subpoena gate unravels from there. So I think at that point in time, Zach was thinking the cell phone records, Marshall John Walker's analysis, the photo of Dylan Adams making a purchase in Parsons at like a gas station convenience store at the same time, 11:10, 11:20, where it would be impossible for them to all be at this location had they been the ones that committed these crimes and Jason Autry let him tell the story. It would dispute entirely Jason Autry's version of events. And then on top of it, they end up, after this, they also end up finding that still image on the screen. So, and guys, the next thing I have in this playlist here, we have the amazing Trial and Error podcast. You can see I go into episode 1, or did I have this in here twice? Okay, no, there's part 2. But that's all in here, their podcast. I think I left out a good portion of some of their bonus content to keep the episodes in order in this playlist. But if you guys want to deep dive through everything I put together in this playlist, it should be in the description for you there. I highly recommend, if you haven't already watched Trial and Error's podcast, start from episode 1 and just keep watching all the way forward. We do have this. Let's look at the March 25th. It's a short clip, but
we have continuing coverage on the latest updates in connection to the Holly Bobo case. WBBJ 7 Eyewitness News reporter Ryan Brooks joins us live in studio with more. Ryan?
That's right, Terry. New details emerged from a man convicted of murdering the Tennessee nursing student over a decade ago. Court sessions begin again today at Hardin County Circuit Court in Savannah, preceding the case of Holly Bobo, the 20-year-old nursing student who disappeared from her home in 2011. Earlier last year, a petition was filed by convict Zachary Adams' lawyer, Doug Bates, after co-defendant Jason Autry recanted his testimony.
What is going on over here in the doorway?
Conviction was based primarily on the testimony of Autry. Zachary Adams is appealing his conviction with the hopes of being granted a new trial following his co-defendant Jason Autry after his confession in February of 2024 to lying on the stand at the time of the trial. Other orders of business question the validity of Katie Sapirko, the licensed neuropsychologist who video recorded the conversation in prison with Autry about his testimony. Both the state and Adams' lawyer Doug Bates agreed not to bring Sapirko as a witness if there is a retrial.
We're scratching our heads a little bit because she's the foundation of their petition, but the overriding tone of Jason Autry lied to that jury in 2017, and when Sapirko is here to set the record straight. We then find out, oh wait a minute, no, she's not a neuropsychologist. Today, she's an investigator.
Adams' lawyer tells us how Katie Sapirko is still connected to Zachary Adams.
Dr. Sapirko is still Mr. Adams' agent this morning. She is working on his behalf right now.
Honorable Judge Brent Bradbury argues Sapirko's stance in this case.
There are allegations and significant proof that she represented herself as a neuropsychologist after her representation of Mr. Bates, with Mr. Bates.
But couldn't she also be that as well? I mean, you can be an expert.
Yeah, I'm not arguing.
Okay.
Friday, the court granted a motion to appoint counsel for Jason Autry. Following the court hearing arguments on the motions, Judge Brent Bradbury ordered the rest of the hearing sealed. Now we wait for a decision to be released.
All right, and then we find out that the ultimate decision on the Jason Autry recanting is that the video will not be admissible in and of itself. Maybe if Jason Autry were to come testify, but that wasn't going to happen either. So it's not available for consideration for the purpose of these post-conviction hearings. So not on the record here for those proceedings. And there was an interlocutory appeal on that decision filed and denied. So I thought that was that not Amy?
But couldn't she also be that as well? I mean, you can be an expert.
Yeah, I'm not arguing.
Okay.
Friday, the court granted a motion to appoint counsel for Jason Autry. Following the court hearing argument.
And I just thought that was Amy that was speaking there. Maybe it wasn't. But yeah. So we didn't get to see much of the proceedings from March 2025 either, but there was a little clip there. And we saw a lot of the May ones. We saw some August. We saw a good amount of the August ones. And we were able to watch almost everything from November. I think we're missing Jack Van Hoosier. I'm pretty sure Jack Van Hoosier testified during the post-conviction relief hearings. I don't see his testimony out there. Did I see any other clips? Let me look at. Let's see. Yeah, we got the brother. Let's watch this one real quick to see if they show any snippets.
Welcome back. WSVU Investigates has an update for you here. A judge will decide if Holly Bobo's convicted killer should be granted post-conviction relief. Let's get right to investigator Courtney Allen. Courtney, this hearing is actually going to decide whether Zach Adams gets a new trial.
Lauren, Adams was convicted of raping, kidnapping, and killing nursing student Holly Bobo back in 2011. But his defense team says he is not responsible and says a prison video of a key witness taken years after the trial supports that. That video that our investigative team obtained last summer showed the key witness, Jason Autry, recanting his testimony, saying he made it all up when he said Adams murdered Bobo. The state and defense argued today about whether that video should be played during the hearing. The judge ultimately sided with the state, saying the video is hearsay and should be inadmissible.
The statement was simply an interview, not under oath, made by, granted it was an agent of Mr. Adams, but there's no support of reliability of that particular statement in these circumstances.
The defense
So you got some faces in the gallery here, guys. Look at the gallery.
Report of reliability of that particular statement in these circumstances.
The defense now wants to appeal that ruling, saying the video is too important to be thrown out. We are still waiting on opening statements to begin in this hearing. And again, all of this determines whether Adams will be granted a new trial. We have an exclusive interview between Adams and our chief investigative reporter, Jeremy Finley, available to watch right now on our WSMV4.
And that's what we watched, where we just saw it. It looked like it was like the phone, the audio wave with the recording of the voice over the phone. That's what they're referring to there. So that takes us up to speed, you guys, with, this was May. We got to watch the opening statements from May. And I think on the 28th of December, let's get together, whatever we're doing on the 28th anyway, before we wrap up that stream. I think we should rewatch the opening statements from these post-conviction proceedings. So expect that on the 28th. The 29th and 30th are the final scheduled hearings for this matter. So that will be Monday. That'll be a week from today, these hearings. I'm excited. Also, huge shout out again. Sheriff Chuck is throwing more gifts in the chat. Thank you so much, Sheriff Chuck. Another 5. Big thank you here. Thank you so much for your support, helping us keep this going. And yeah, I don't know, for the next 7 days, guys, we will be looking at the post-conviction relief, the documents that are available. It's incomplete, but we're going to continue off. We read the initial petition and some of the back and forth for like the first month of the post-conviction petition effort, but there was still more on the docket to get through. I also want to read the Terry Dykes affidavit with you guys. That was filed before the appeal, before the post-conviction relief petition. But it's going to be Terry Dykes saying, like, look, this is impossible. The state's theory is impossible, once again. And then the trial transcripts, right? So we have a ton of written material to go through over the next few days. I don't know entirely scheduling. I'm not opposed to like popping on Christmas. I know I'm going to randomly think about this case. But Christmas probably, there's a good chance that I won't be doing a stream for Christmas. But everything else, I'm open to popping live every day until the 29th. With that being said, you guys, tonight at 7 p.m. Eastern, I think it's 7 p.m. Eastern, because Miss Janet Demeter Central Time, I think she said it was 6 p.m. her time. She's going to be doing a watch through of this full Jason Autry recanting interview, 51 minutes. So if you haven't been able to watch this and or you want to watch it with the chat, I'll be over there. This video is actually going to redirect us over there when it ends. Even though she's not going to start right away, you can still hit the notification and subscribe button to make sure you get the reminder. But I think if you haven't seen it or want to watch it now, after seeing all the pre-trial stuff, the trial, and what we're seeing argued in these post-conviction relief petition hearings, what a better time than now to watch Jason Autry. In my opinion, he's way more credible, and naturally speaking, maybe there's some moments where he's like trying to impress the woman that's speaking to him. But other than that, he's not making strong facial expressions to bring life to what he's saying. It seems a bit more natural and candid. So I think that's what we've got tomorrow. Expect we'll be doing some document readings. Probably going through the post-conviction stuff first and then getting to the trial transcripts. But I don't know, the trial transcripts were pissing me off the little bit that I read. So I might change the order. You guys will see tomorrow when we fire up the stream, which we're going to end up doing. But we'll get through whatever we can either way. Other than that, we have Mavhawk here with the shout out for Janet. Me too. And let me just drop her channel link now as well. I think it's in the description of all of these recent streams. Okay, Miss Demeanor. And it's easier if you're going to search for her channel. I think it's easier to type Miss Janet Demeanor, or put like Holly Bobo or like Courtney Clenny. She's done some Courtney Clenny conversation as well to make sure her channel pulls up, because otherwise misdemeanor, YouTube's going to think you're trying to spell the word misdemeanor and send you everywhere else. So put the Janet in there and it'll come up faster. Yeah, Sheriff Chuck, I think that's right too. There's no time that Jason Autry is credible. He's a professional liar. I think so too. Self-serving. Even his, I'm an innocent man outside the courthouse, it's like, he comes off as sounding a little crazy, even though I fully believe that the other three are alibied. Part of me is like, I don't know. I don't know if I believe him saying he's an innocent man back in those old 2014 videos outside the courthouse steps. Just saying. Just saying. Oh, yeah. And then tomorrow, that's tomorrow already. So tomorrow, I think at, I'm going to have the time wrong. I think it's 6:30. It might be 6 o'clock Central Time. So around 7 or 7:30-ish, I'm also going to be over on Miss Janet Demeanor's channel. They're doing a Festivus celebration. We're going to air our grievances out. I'm going to have a little spiel, I think, about the Courtney Clenny case. I might not even get into it, but the rest of my 30 minutes is going to be all airing grievance about the Zachary Adams case. So probably going to be a lot of conversation about bad Jennifer. And a little bit of Amy Wyrick, just because Amy Wyrick is jumping on the scene post-conviction doesn't mean she's immune from my criticism and airing out of grievances. So that will also be on Miss Janet Demeanor's channel tomorrow, Christmas Eve. GV says, innocent man walking, beep, beep. That is kind of how it sounded. Yeah, I don't know, Sheriff Chuck. I've had these ideas. I'm not going to lie. Like, what if Jason Autry was with Terry Britt and just substituted Zach for Terry? Like, what if there's something more going on? I don't even know. I don't even know. But all I know is I fully think that the evidence alibis the three guys that are down in Parsons. I think even without that alibi evidence, there are major, major questions. So the alibi only helps, but I still think a new trial would be warranted, even if that ATM video was never, I don't want to say doesn't exist, but was never accessed by Zachary Adams' team. So Destined to Be says, I love a cat rant. Well, I love you guys. I love that you guys are here to listen to me rant. Since this is going to redirect over to Miss Demeanor's channel, I do imagine that, you know, Dolly Talk usually goes live around this time. Who do I see that's live real quick? It's not really giving me much live. It's giving me... So Andrea Burkhart was live earlier talking about Christy Martin. And it looks like she went over the direct testimony of Christy Martin. Hella's going to be live at 6:15 talking about the Lauren Matthias, all of those private text messages that are the subject of a lot of deserved scrutiny, if you ask me. So let me drop a link to that. She'll be going live in about an hour and a half. I think everyone's like wrapped up for their stuff for the day until Hella and Miss Demeanor. Oh, Take It to Trial is doing the Melody Ferris trial. So there's a live. So if you want to go watch something now, there is Melody Ferris dropped in the chat over at Take It to Trial's channel. Other than that, you guys, we've got, and thank you, Factual Lie. We had Antonio Brown update. If you guys are following that, judge said that she plans to hear oral arguments on motion to dismiss in April of 2026 and wants to try the case in 2026. So not much happened at that hearing, which wasn't expected. If you missed it, Courtney Clenny, the state dropped count 2 against Courtney Clenny, that interception of wire communications charge. We watched that hearing, I think like Friday night. We got together and did a stream. Anything else interesting happening? Tyrone Blackburn. I've wanted to do streams on the Fat Joe cases, but Tyrone Blackburn is such a hot mess that I don't think I can get through a coherent stream where I can explain what's going on and actually have you guys sensibly follow me. But Tyrone Blackburn is ignoring procedural things that need to happen, that an attorney should be communicating back and forth with opposing counsel on. And then the judge is even issuing orders like, since defendant never responded to this stuff, here's the order. But while Tyrone Blackburn is not and he's a party to the case. He's not just counsel. He's a named party and also counsel of record. And he's not responding to certain things. He's also filing a motion for sanctions against Joe Tacopina under Rule 11 of professional conduct. And it's just like wild motions, and he's citing citations, authorities that don't exist, or making up quotes for cases. The quotes don't exist in the case itself, in the holdings. It's just a lot. So I talk about that over on Twitter. Joe Tacopina, Jordan Sieve, Chad Siegel, counsel for Fat Joe, responded last week to Tyrone Blackburn's, what I would call a frivolous motion for sanctions. And I tried looking at it. I'm like, there's no way I could do a stream on this. It's just so off the wall. But I am filing that over on, talking about it over on X. Like, arguments are being raised that Tyrone Blackburn is saying Fat Joe's filing of an amended complaint is retaliation for Dixon filing a suit. Tyrone Blackburn and his client, Terrence Dixon, went and filed a separate case like 2 months after Fat Joe initiated this case, claiming RICO, naming Rock Nation as a party, just going off the wall. And they're claiming that Joe Tacopina, Fat Joe, that their lawsuit is retaliation for that, even though it was filed first. So Tacopina and his peers have to sit here and answer for that stuff. It's got to be to the point where it's not even fun anymore. Just wild. Defendants cite no authority for the proposition that courts have long recognized that coordinated filings in multiple forums designed to suppress litigation constitute an abuse of the judicial process warranting Rule 11 sanctions. So this is a quote from Tyrone Blackburn's motion for sanctions that's made up. This isn't real authority. It's not a real quote. But on top of that, there's only been one lawsuit filed by Cartagena. So there is no coordinated filings in multiple forums. So Fat Joe's attorneys have to take their time in representing their client to respond to this garbage. And it's really unbelievable. But if you guys want to see that, I've got that over on X. If you just want to read the full motion, I'll link that. I don't think I can do a video on it. It's just going to be me going like this for 2 hours. So let me get the link for you there if you guys want to go and really watch Tacopina, Chad Siegel, and Jordan Sieve lay this out. I'm going to call it the taco motion. Other than that, you can go check out my thoughts and shock and disbelief over on X. Other than that, guys, we're going to wrap this up. Thank you so much for hanging out. Sheriff Chuck says, thank you for another great stream, Kat. Thank you for all your support. Merry Christmas to Kat and all the chat. I'll see a lot of you before Christmas. Maybe on Christmas. I don't know. I feel like I'm going to ban myself from YouTube on Christmas Day. Or maybe we'll do something Christmassy. Maybe if Hal's not busy, that will be the day we watch vintage Brian Steele when he was still a brunette. Is brunette? That's not the right word for a guy with brown hair. He had brown hair. Doing opening statements. Maybe we can get Hal together if he's not busy all day on Christmas, but I won't hold him to that. Other than that, you guys, hope to see you guys tomorrow. Or over in Miss Janet Demeanor. We're going to watch that Jason Autry recanting. Hope everyone has a great day. See you soon. And no slime left behind. Thank you, O'Bailey's. Always a good reminder.
A as in Elisa, and B, Your Honor, as in Barry. C as in Colette. G as in Goldfetter. K as in kittens. M as in magic. P as in perfect. C as in Colette. U as in unbelievable. V as in victory. W as in wonderful.
O for objection. S for sustain. B for buffering. E for Pepto-Bane. S for slime, my friend, and you, as in what you mean. I as in adultery call. M as in may I sleep. All the ABCs of they keep on spinning round. Never gonna let me down. Got my slams down deep for telling anything. R for rights we stand, I for infinity. Life's a courtroom dance. Keep your stances strong with ABCs of steel. You can never go wrong. Oh, the ABCs of steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. Of steel makes me feel so real. Yeah, they keep on spinning round. Never gonna let me down. Oh, the ABCs of steel